Welcome back. Well, Findon High School has its very own courtroom. Used for mock trials, students are encouraged to work on their confidence and develop strong communication skills for adult life. As Maddie Dunn reports, the verdict is in. It works.
It's been really energising and positive and uplifting for our school community.
It just went for all my fears but totally blew them away.
It makes me feel proud to know that I've had an impact on those students and done something for them.
These aren't the faces we're used to seeing in our halls of justice.
We're in trial for Jetty Smith murdering a 7-year-old boy. Madam Prosecutor, you may start.
From the witness stand to the jury box, Findon High School's built its very own courtroom.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Legal studies teacher Mel Campbell has poured her heart and soul into the project, a groundbreaking first for the 60-year-old school and the state.
It's basically a fully functional courtroom to use for mock hearings for our students.
She's defied doubters to fundraise more than $14,000 for the custom-built classroom.
People are, oh, that's a lot of money. How are you going to, raise it? And I said, I'm going to do it.
After 6 months of campaigning, planning and putting hammer to nail, the striking setup's finally finished. Principal Sue Burtonshaw says it demonstrates the passion of the school community.
There was a sense of urgency with this one, and that's what I like about it. Idea, getting people on board and then some action, and then we're here today.
The idea stemmed from Mel's legal studies class, where she's been conducting mock trials for more than 5 years.
We were just doing them on and off, and I said, look, let's go, let's get our own. I'm sick of setting it up all the time, and from there, within a 10 to 12 week time frame, we had it.
It's the perfect way to put students' legal knowledge to the test, but the hearings aren't just about making the grade. The mock trials are all about developing crucial life skills and ensuring the kids aren't just another brick in the wall.
It threw me a bit into the deep end, but I'm very grateful for it because I used to be so insecure.
And they're not restricted to those undertaking legal studies. The hearings are for students of every discipline.
I want to get the PE kids in. We'll do a drugs case. The photography students are going to come in and take some photos. The IT class are going to come in and do some filming. Just a whole cross-curricular approach. Every subject will be integrated.
Although they certainly aren't for the faint-hearted.
We want to do a murder scene next year at school, so the art faculty will be in charge of creating the body.
Teaching is no longer about standing in front of the classroom and delivering a whole lot of knowledge and facts and information. It's about actually getting the students to ask the questions.
And the biggest question...
Do you think you might use the room to do some real life discipline if somebody's misbehaving?
We have had a few jokes about that, I think some students were wondering whether that was going to become the room where we had conversations.
We could possibly do a trial by students so that they could actually come up with punishments.
With more power than the states to limit the rights of US citizens?
Well, Your Honor, we must look at the Organic Act of 1936, which they were able to make their own constitution, and the states are able to make some of their own laws and policies, and so can the Virgin Islands. So it's just power that they both have. None of them actually have more power than another. So taking a look into the Virgin Islands Code, Title 16, Section 31 states that the nature of marriage is hereby declared to be a civil contract which may be entered into between a male and a female in accordance with law. And this is why Ms. Buchanan's and Ms. Arroyo's request to have an official marriage license was denied at the time, because this is a violation of the code Title 16, Section 31, which just states that that the nature of it is it's always been between a male and a female, therefore meaning that they would just violate this code of the Virgin Islands. Now, the Virgin Islands is able to make some of their own decisions based of the Organic Act of 1936, which they're able to have some sort of self-government and make their own policies and rules. So the Virgin, since it's not a state, Obergefell v. Hodges does not apply, such as the petitioner has attempted to argue, because in that case it says that it only applies to the states. And again, the Virgin Islands is a territory rather than a state. Therefore, that case does not apply, taking out the petitioner's argument. Now, cross-applying Balzac v. Puerto Rico.
Counsel?
Yes, Your Honor.
You were just about to mention Balzac v. Puerto Rico, which is what I'm going to get to right now. The Virgin Islands has been a territory of the United States for 99 years. Their centennial will be 2017. The fact that they are unincorporated territory shackles them with the insular cases, which include Balzac v. Puerto Rico. Looking at that amount of time and the closeness that the Virgin Islands now holds with the United States, would rulings like Obergefell and other Supreme Court decisions that do not directly state they apply to territory apply to the Virgin Islands if it was an incorporated territory rather than an unincorporated territory?
Well, Your Honor, in Balzac v. Puerto Rico, it says that it was a case in which the Supreme Court held that certain provisions of the U.S. Constitution does not apply to territories, therefore meaning that this argument that the petitioner is trying to make about the fundamental right does not apply to the Virgin Islands. Why? Because it is, may I answer the question, Your Honor?
Yes, you may, then you can conclude.
Yes, and my counsel will get further into detail, but we must realize that the Virgin Islands is a territory rather than a state, therefore meaning why it doesn't apply. And we pray for these reasons that you vote to uphold the lower court's decision. Thank you.
Hi, good afternoon. Opponents ready? Your Honor, ready? Mr. Chief Justice and Associates, may it please the court?
It does.
My partner, Cecilia Perez and Iris Rodriguez Muro, will represent the respondent, the government of the Virgin Islands, in the case before the court today. Your Honor, this case is about the law and the upholding of it following the Constitution that our founding fathers made in the beginning of our great nation. The question I will be addressing is whether the Virgin Islanders are entitled to the adoption of same-sex marriage as a fundamental right through the application of the Due Process Clause and Equal Protection Clauses of the 14th Amendment to the United States Constitution. Now, to answer this question, it simply is an unequivocal no. The Virgin Islands are unincorporated territories. An unincorporated territory in American law is an area controlled by the United States government where the fundamental rights apply as a matter of law, but other constitutional rights are not available. Now, selected constitutional provisions variously apply depending on congressional organic acts and judicial ruling according to the U.S. constitutional practice. Now, local tradition and law. All 5 modern inhabited territories are organized but unincorporated. So, answering the question, the Virgin Islands are unincorporated territory. And of course, following the Organic Act that was established in 1936, of course, cross-applying all of my co-counsel's arguments, then no, not all rights should apply. And in this case, this is nothing more but a privilege that will only apply to states. Now, yes, Your Honor.
You mentioned that the Organic Act is which was decided upon by Congress for a territory, is what provides for fundamental rights to the territory. The Organic Act of the Virgin Islands, and this is stated in the executive order, provides for the Due Process Clause, and as a matter of fact, the entirety of the 14th Amendment under Article 11. Article 11 granted the exact same language used for the 14th Amendment to the Virgin Islands when it was applied. If that is the case, do the appellants have a case with the fact that Congress has already provided an action that can allow them to make a claim?
No, Your Honor. Simply because the appellants actually cross-applied Obergefell v. Hodges. However, again, it was not a congressional hearing. It was actually done by the Supreme Court, and the Supreme Court held that it should apply to all 50 states. In that contention, it was referring to the 50 states of the United States of America. So since it wasn't a congressional hearing, it would not apply to a territory, as Congress is the one to make decisions where they feel necessary, because of course the Virgin Islands are unincorporated territory, so therefore Congress has the power to interfere. Now, cross-applying Baker v. Carr, it states the Supreme Court addresses the court's political question doctrine and how the federal courts have the right to intervene and decide on redistricting cases. Now, this case completely takes out any argument that the petitioner may attempt to make, because following the Organic Act, again, the lack of the Virgin Islands Constitution shows that the Virgin Islands attain to the U.S. Constitution and only follows federal law enacted by Congress. Now, also cross-applying Balzac v. Puerto Rico.
So hold on. Counsel, you just mentioned something very important, and I'm not sure if it benefits you. The Virgin Islands has to follow, well, congressionally decided federal law.
Right, Your Honor.
The Defense of Marriage Act provided a federal definition of marriage, which was later ruled unconstitutional. So the Virgin Islands has to follow federal law, and the Supreme Court overrules federal law. Are we not placed with a case where, because federal law provided the same definition as the Virgin Islands, that neither could stand?
Your Honor, we have to take into, Your Honor, we need to look at the fact that the law stands. And of course, since the Virgin Islands are unincorporated territory, the federal law is the law that will stand. Now, the Supreme Court applies to all states, and the Virgin Islands are not a state. They are an unincorporated territory, if I may add so. They are territory, but they are also unincorporated. So, of course, again, following the definition that was established regarding unincorporated territories under American law, it clearly states that fundamental rights apply as a matter of law, but other constitutional rights are not available. So therefore, the argument that the appellant has made regarding the 14th Amendment and the due process and equal protection clauses under the 14th Amendment, they would be unapplicable in this case. Does that answer your question, Your Honor?
Yes, counsel.
Now, in Balzac v. Puerto Rico, the Supreme Court held that certain provisions of the United States Constitution did not apply to territories not incorporated into the Union. Applying this binding case to our case demonstrates exactly why we are here today. We are all well aware that Puerto Rico is a Commonwealth. The Virgin Islands are a territory, unincorporated territory, therefore completely following the Supreme Court holding. So therefore, this case is fully binding and essential to take into consideration when making a decision. Now,
but hold on. Balzac also says, and this is right in the same section where it points out that though trial by jury may be fundamental to the United States, it didn't extend to Puerto Rico at the time. It says right after that the due process clause of the 14th Amendment attaches to all territories by its own force, because that is where most litigation for U.S. citizens comes from.
Your Honor, you said it yourself. It applies to all territories. However, the Virgin Islands are unincorporated territories. So following American law, those rights would not apply.
But counsel, so was Puerto Rico at the time. And in Balzac, it pointed out that Puerto Rico and the Philippines inherit that. Puerto Rico, though a Commonwealth by designation, is still an unincorporated territory. So would it not hurt your case if the due process clause did come, or is there a process that could still be afforded to these ladies if the due process clause does extend to them?
No, it still wouldn't, Your Honor. Again, following federal law and as it stands today, right? Because we're arguing how the law stands today. So of course, we cannot go back because Puerto Rico is a Commonwealth now. And of course, yes, this was a landmark case. So yes, this is a binding case. Why? Because again, the Virgin Islands are unincorporated territory. So it's clearly stated under American law that not all constitutional rights are to be applied because they are unincorporated territory. Does that answer your question, Your Honor?
Yes, counsel.
Now, even though the Virgin Islands are unincorporated territory, we understand that they still have such privileges. However, they must understand that they are to follow federal law, as Congress is the one to lead whenever it comes into a redistricting case in which they should be able to make their opinion. So for these reasons, and these reasons alone, we pray, cross-applying all of my co-counsel's arguments, that there is no way that the appellants can make a case regarding as to whether they are entitled to same-sex marriage under the 14th Amendment, because it is clearly stated under American law that unincorporated territories have the fundamental rights, but not all constitutional rights are to be applied. Thank you.
That's what you're telling yourself.
Oh, I see that I have 1 second left. I'll leave it to the court. Thank you.
That was excellent.
That was really great.
So now you see how many different ways you can approach the argument separate to what we do, right?
Yeah.
Feeling good about yourself now?
Yeah.
You sure?
I just have to
All right. So we have our respondent team also. Would you be prepared to operate under the side of the appellants while our respondent team preps to go ahead?
They want you to appellant, so.
That's my co-counsel. Yeah, well, if you guys are available, then yes, sure. Just she's first speaker, so I'll allow my co-counsel to trade spots.
All right, take your time. Let me get mine ready also. Don't rush. Take your time. Side two, go ahead. All right, Alice, you ready? All right, any question?
Opponents ready?
Give us a sec. All right, Alice, you're doing the process. Justiciability government committee. Excellent. So doing justiciability or due process? Oh, you're doing justiciability. Who was the process government?
No, I say I can't do that. I can't do that. Graciela is the process.
Ooh, Graciela together.
One nation.
Marialis, you can do both.
I did not fix it for me yet.
All right. So, Marialis, you're going to do justiciability.
I'll do the process. It's fine.
You have to do process on that side.
Me and Graciela.
All right. One of you going to do process. You have to just trust somebody's doing the process today.
No, I don't do it. He would do it. I do my argument. I practice last night. Do it. I want to do it. We're not going.
All right, people, let's go.
I am. Take the process. Where's the process? That's so not cool.
All right. The respondents may begin. Sorry. The respondents, are you ready? Respondents, ready? Respondents, are you ready? Yes. Appellants, are you ready?
Yes, Your Honor. Yes, Your Honor.
You may proceed.
Mr. Chief Justice and Associate Justices, may it please the court.
It does.
My partner, Brisa Rodriguez, and I, Cecilia Perez, will present Ms. Arroyo and Ms. Buchanan, the petitioner. At this time, I will speak for 5 minutes and address the first point of error, and my partner will speak for 5 minutes and address the second point of error. So, Your Honor, the question that I will be addressing is whether U.S. Virgin Islanders' complaint urging the application of the fundamental right to marry to citizens of the U.S. Virgin Islands is a non-justiciable political question. The answer is yes, because it is a fundamental right which was decided in Obergefell v. Hodges, and courts can decide over this, such as if we take a look at Obergefell and v. Hodges, which was decided in June 26 in 2015, in which the Supreme Court decided that the fundamental right is guaranteed to same-sex couples, which does apply to our case, because if we take a closer look at Section 3 of the Revised Organic Act of 1954 as amended, provides that no law shall be enacted into the Virgin Islands which shall deprive any person of life, liberty, or property without due process of law, or deny to any person therein equal protection of the laws. Therefore, meaning that actually in the United States Congress, by enacting the Revised Organic Act of 1954, made the due process of the 14th Amendment directly applicable to the territory of the Virgin Islands of the United States. Therefore, meaning that Obergefell v. Hodges does apply to our case, because in the Organic Act of 1954, it states that the 14th Amendment and due process is applicable to the Virgin Islands, therefore meaning that Obergefell v. Hodges does apply, because we are also under the United States, and we cannot, if we're going to consider them as United States citizens, we need to give them, the Virgin Islanders, Ms. Arroyo and Ms. Buchanan, and more people, their fundamental right to same-sex marriage, because we cannot give rights to people that live in the States and not people that live in the Virgin Islands, because the Organic Act of 1954 allows it to be applicable.
But counsel, aren't we faced with a situation where Congress has in effect already done that, not just to the Virgin Islands, but to all territories? Representation is given to them, yes, but they can't vote for their commander-in-chief. People in American Samoa, they aren't even citizens. They don't even get the full extent of the first portion of the citizenship clause of the 14th Amendment. So while they can provide soldiers, they can't vote for their own commander-in-chief until they move. Couldn't this be the same situation facing Mr. Arroyo and Ms. Buchanan? Their issue isn't that the Virgin Islands is denying them marriage. It can't be provided because of their locality. Just like voting, they don't get it until they actually are within the contiguous 50. Wouldn't that be the situation facing your clients?
Well, Your Honor, we must take into account that the governor of the Virgin Islands, Kendrick Matthew, did sign an executive order entered on July 27, 2015, requiring the territory's government to comply with the U.S. Supreme Court that ruled that marriage rights to same-sex couples throughout the country, which was in Obergefell v. Hodges, therefore meaning that it should apply. And if this executive order was signed and Mr. Arroyo and Ms. Buchanan were denied their same-sex license for marriage by the moot clerk, then they are being denied their rights, Your Honor, because it was decided in Obergefell v. Hodges, which my co-counsel will also address, that it was a fundamental right, and therefore they're depriving Mr. Arroyo and Ms. Buchanan of their rights. And actually, when this executive order was signed, Mr. Arroyo and Ms. Buchanan did attempt for a second time to try to get their license of marriage. However, they were denied, and they were denied quite a few times.
But counsel, I agree that they did attempt a second time, 4 days after the executive order was passed. Was 4 days enough time for them to act?
Well, Your Honor, yes, it was enough, because the executive order was signed and entered on July 27, 2015. So as soon as that executive order is signed, it is now it's now in place. It's taking action. Therefore, this is why Ms. Arroyo and Ms. Buchanan did take action and to make another attempt to get their license of marriage. However, they were denied by the moot clerk, and this is why I'm arguing that they're actually indeed being denied their rights, because on June 26th of 2015, the Supreme Court of the United States ruled that the 14th Amendment requires the state to license a marriage between two people of the same sex and recognize marriage between two people of the same sex when their marriage was lawfully licensed and performed out of state. Now, the respondent may try to argue that the Virgin Islands is not a state. However, we must realize that the Virgin Islands is still a part of the United States, and that the Organic Act of 1954 makes the due process of the 14th Amendment directly applicable to the Virgin Islands, therefore meaning that Obergefell v. Hodges does in fact apply to our case. And just...
So I have to go back to the executive order for a second. In looking at the executive order, it says that in 15 days, a status update would be provided on the status of these changes. Mr. Arroyo and Ms. Buchanan went back long before 15 days. They went back in 4. If nothing was changed yet, they went back on a Thursday, if I remember correctly. The executive order was issued on a Monday. If 15 days hadn't passed yet, can they still make the claim, or did their haste eliminate their challenge before the court today?
However, Your Honor, they kept constantly denying them the. Can I answer the question, Your Honor?
Actually, you can. I have one more, and then I'll allow you to conclude.
Yes, they kept denying them their fundamental rights, which was decided in Obergefell v. Hodges, and we must give Ms. Arroyo and Ms. Buchanan their fundamental rights. We pray for these reasons that you vote to overturn the lower court's decision. Thank you.
All right, my last question for you, counsel, is this. Is it your contention today that though there was a 15-day grace period, for lack of a better word, to check on the implementation, that even if that was the case, Carmen DeVille, the clerk of the Moot Superior Court, would still have denied them the ability to get their marriage license, even if those 15 days passed?
Well, Your Honor, we must realize that they were still denied their fundamental right to same-sex marriage, and for these reasons, we're asking that they're given their rights because the Organic Act of 1954 and even the executive order that was signed, it must apply, but they just kept constantly getting denied the request made. Thank you.
All right, counsel. Thank you.
Sorry. Good afternoon.
Good afternoon.
Mr. Chief Justice and Associates, may it please the court?
It does.
My partner, Cecilia Perez, and I, Risa Rodriguez, will represent the petitioner, Audrey and Brittany, in the case before the court today. Your Honor, this case is about justice and granting citizens the rights that were constitutionally granted by our founding fathers. The question I will be addressing today is whether Virgin Islanders are entitled to the adoption of same-sex marriage as a fundamental right through the application of the Due Process Clause and Equal Protection Clauses of the 14th Amendment to the United States Constitution. The answer to this question is a yes. Even though the Virgin Islands are U.S. territory, they will have privileges such as citizenship. In Tuawa v. U.S., the court held that persons born in the United States and subject to the jurisdiction thereof are citizens of the United States. Now, citizenship is defined in the Constitution as the attribute of persons who, as members of polity, have certain privileges and duties in addition to those they have as persons. Now, citizens include those born in the United States, state territory, or naturalized according to law. Now, cross-applying the Constitution and Tuawa v. U.S., the Virgin Islanders are citizens and the Virgin Islanders are incorporated, for they are territory and they are indeed under the jurisdiction of the United States of America. When it comes down to rights created through social contract, it clearly says that a citizen is to enjoy equally the rights, privileges, and protections of personhood as established by law. Without further ado, then that would clearly state that yes, the Virgin Islanders are entitled to indeed have an approbation of their marriage license. Now,
but hold on. You mentioned Tuawa. And Tuawa v. U.S. also brings up a very interesting point. That case says that though a right may be fundamental, for a right to be truly fundamental, it cannot be in merely a colloquial sense or considered necessary for the American form of order and liberty. What I draw from that is it's saying that though a right may be considered fundamental in the United States, meaning the 50 states, it isn't necessarily fundamental to territories. That's the reasoning they used while referencing the insular cases to speak about American Samoa in regard to citizenship. Is marriage so fundamental that the Virgin Islands gets it, even though until 2003, the United States didn't even recognize same-sex marriage as fundamental within its own borders?
yes, Your Honor, definitely. Times have changed. And as time goes by, we must apply our Constitution to the times as they change. Because, of course, we need to make sure that everyone is applied the same rights. Again, going back to the definition of citizenship, under the actual Constitution, citizenship applies to people of territory, people of state, and people naturalized into the United States. So therefore, not only that, but cross-applying Tuawa v. U.S., Tuawa also says that citizens are people under the jurisdiction of the United States of America. And Virgin Islands being a territory would imply that, yes, they are under the jurisdiction of the United States of America. Does that answer your question, Your Honor?
Yes, counsel.
Now, the court held going on to another argument that I will make is that they have access to the United States judicial system. the Superior Moot Court and the Supreme Court work together in unison to make sure that all citizens are granted the same rights. Why? Because they are citizens. And if they weren't to be granted the same rights, that would be unconstitutional. So therefore, they work together. So if that were the case, it is truly clear that we should apply Obergefell v. Hodges. Now, the court held that the Due Process Clause of the 14th Amendment guarantees the right to marry as one of the fundamental liberties it protects, and that analysis applies to the same-sex couples in the same manner as it does to opposite-sex couples. Now, the judicial precedent held that the right to marry is a fundamental liberty because it is inherent to the concept of individual autonomy. It protects the most intimate association between two people, and it has historically been recognized as the keystone of social order. So therefore, it clearly states that it is applicable under the Due Process Clause of the 14th Amendment, clearly answering the question I am here to answer today. Now, not only that, but if they were to truly work again together, both the Superior Moot Court and the Supreme Court, then this should apply, especially if we have an executive order that was signed by the governor. Executive Order 473-2015 clearly stated that no law should be enacted in the Virgin Islands which shall deprive any person of life, liberty, or the pursuit of happiness without due process of law, or deny any person therein equal protection of laws. Now, it also stated that the United States Congress said that by enacting the revised Organic Act of 1954 made by the Due Process Clause of the 14th Amendment directly applicable to the territory of the Virgin Islands of the United States, cross-applying the argument made by my co-counsel. So for these reasons, we pray that you uphold the law as it stands. Why? Because we're here, because the law is there to make sure that our society is under control. We are here and we plead the court to take into account the Constitution that was written by our founding fathers in the beginning of this great nation. We cannot simply just pick parts of the Constitution that we seem to interpret better than the other. Why? Because the founding fathers meant for the whole Constitution to be something for everyone, every single citizen. And Virgin Islanders are citizens of the United States of America under the definition of citizenship of the Constitution.
Counsel, I realize you're just about done. However, you mentioned 3 cases that build to something that I think we have an issue with before the court today. Baker v. Carr says that governments gain their power from the concern and the wills of the governed. Tuawa v. U.S. says that for the U.S. government to force rights onto a territory when they are not culturally, legally, or traditionally prepared to accept them would be an act of paternalism, if not outright overt imperialism.
Your Honor,
aren't we faced with a situation where to say that the Virgin Islands must know, when they haven't had the conversation present in Obergefell, where they haven't had the debates or the campaigns present in Obergefell, must now accept something they've never thought of? Would that not be a political question where the US government is changing status now as they see fit to allow a right that they themselves like?
Your Honor, I'm aware that Baker v. Carr was landmarked a long time ago, but there's also Boumediene v. Bush, in which the Supreme Court held that the Constitution grants Congress and the President the power to acquire, dispose of, and govern territory, but not the power to decide what. May I finish answering the question?
Yes, you may.
Again, it gives them the power to acquire, dispose of, and govern territory, not the power to decide when and where terms apply. So putting that out there, that clearly states that, yes, they have the power to acquire, dispose of, and govern the territory, but they do not have the right to judge when any order set by the government of the Virgin Islands is to apply. So following Executive Order 473-2015, it should be applicable to our case today. Thank you. Does that answer your question? I did do it great.
Yes, Counsel.
All right. Thank you, Your Honor.
All right. That's a black friend, because we did have it earlier. We had the case last year. That's a black friend. All right, respondents. Let me adjust so you can see our time. You see them, you flip the screen, and I just convert the light. That is fine. All right. You submit. Got you. Get frame. Yes, we frame. Take my mouse.
Miss, I am in the one. Mike is okay. You have it on the bottom.
No. I have the case. We had a case last year. So I'll come down to that. All right. Are the respondents ready to proceed?
Yes, ma'am.
Respondents may approach.
May it please the court?
It does.
Good day, Chief Justice and Associate Justices. My name is Christopher Jimmy, and I, alongside my co-counsels Mary Alice, will be representing the government of the Virgin Islands in the matter before the court today. Your Honors, this is not a case about morals, virtues, personal beliefs, or pious opinion. The Virgin Islands government did not, does not, and has not denied Ms. Arroyo and Ms. Buchanan the right to marry. Ms. Arroyo and Ms. Buchanan's complaint is a non-justiciable one, and no entitlement of the adoption of same-sex marriage as a fundamental right exists in the Virgin Islands via the due process or equal protection clauses of the 14th Amendment of the Constitution. I will speak to the matter of justiciability, while my counsel will address due process and equal protection questions. Today, we request that this court affirm the lower court's ruling. This matter is non-justiciable for the following reasons. 1, the relationship of the Virgin Islands to the United States does not mean all mandates will be automatically and immediately attached to the islands or its citizens. 2, a coordinated branch of the United States government, the legislative branch, and not the judiciary branch, must provide independent resolution of this matter. 3,
Counsel, hold up. Opposing counsel brings up a very interesting point. It's not the legislative branch that acted to adjust law. It's the executive, via the executive order. Doesn't the executive order provide for the congressional action, since it is a law, for Ms. Arroyo and Ms. Buchanan's complaint?
Unfortunately, Your Honor, the executive order passed by Governor Kendrick Matthews is actually a moot point because it acts outside of the Virgin Islands Constitution.
How so?
Your Honors, a law does not exist that grants gay marriage equality in the Virgin Islands. Therefore, we cannot provide a marriage license. To go outside of that and provide one on its own, when a clear state definition of what gay marriage is acting out, is overreaching in the executive power.
So then, counsel, what, in your opinion, what exactly did the executive order do? If it didn't provide for a change of law, what did it do?
Your Honors, the executive order granted a I'm sorry, Your Honor, a moment of deference.
All right, let me rephrase that question. The executive order was passed, right? And it was passed with the intent of extending the ruling of Oberfeld v. Adams. If we look at it in its writing, your argument is that it's a moot point. That, one, it's an overreach, it does nothing to benefit Ms. Arroyo and Ms. Buchanan. Why not? Then what does it actually do? If it didn't give them the ability to get their marriage license, what did it do? That was the running counsel.
Your Honor, the executive departments, its agencies, and instrumentalities had to comply with Oberfeld v. Adams. The executive department had 15 days to provide a status update. The legislature had no mandate, no set time, no sessions to change laws to allow the executive to execute a change of law. This would then provide for this court to rule upon.
Then, counsel, okay, I agree with you that the legislative department will have to change the law as written. However, what if we're now faced with the fact that the executive order does provide a law? And that law is the U.S. definition of marriage. Isn't it, since you're arguing for justiciability, isn't it this court's duty to provide the interpretation as to which of these two competing laws we should follow?
No, Your Honor.
Why not?
Your Honor, the Virgin Islands is not a state. As of now, it's not even on its way to becoming a state. The Virgin Islands' current political status is an unincorporated territory, to which all laws and rights do not extend ex proprio vigor. Laws Act of Puerto Rico held that the Sixth Amendment specifically and points out that in the fact the entirety of the Bill of Rights does not extend, minus congressional actions. 200 of the U.S. shows that the citizenship clause of the 14th Amendment cannot attach by its own force, even be forced to without the people seeking its own on their own. While the insular cases may be looked on as anachronistic, sometimes contentious, incourageous, or even without parallel in the judicial history, as stated in 204, they have not been overruled and must provide the analytical framework in the territorial matters.
Well, Councilor, if the insular cases must provide the analytical framework, and Balzac v. Puerto Rico is one of those insular cases, and in that case it says that the 14th Amendment's due process clause does extend to the territories. And Obergefell says that marriage is fundamental, and fundamental in regards to the liberty rights of a citizen of the United States. How can it not extend to Mr. Rory and Ms. Buchanan in the Virgin Islands? And why doesn't the executive want to provide that for?
That's changed today. Number 15 is 64. 15 is now 64. Students don't have
The power to extend rights to citizens of the territories has been wholly given to Congress through Articles 4, Section 3 of the U.S. Constitution that provides Congress with the ability to make all needful rules for the territories. VI Title 16, Section 31 defines marriage as a union between a man and a woman. To change our standing law to suit Obergefell v. Hodges is a job not within the court's power to do. Baker v. Carr states that where the Constitution assigns a particular function wholly and indivisibly to another department, the federal judiciary does not intervene. This matter belongs to the legislative branch of the Virgin Islands government. Your Honors, an analogy can suffice in this situation. Just because the national menu, SCOTUS, says it's available, the restaurant head chef, Governor Matthews, says the food is ready, and even if you're starving, it does not mean, Your Honor, may I please finish?
Yes, you may call.
It does not mean that you can take the food from the pot in the kitchen, as missed the bill. You must wait for the server to bring it. The territories are not a buffet of constitutional rights. Congress must provide the platter before you are able to enjoy this food at your leisure. This is the case with marriage. In short, same-sex marriage rights, rulings, and even mandates do not attach to territories, minus congressional action. Congress has taken no such actions, and Article 4, Section 3, paired with the insular framework, marks Congress as the sole branch of government in charge with such extension. This matter belongs in the legislative branch of the United States, and more immediately, the legislative branch of the Virgin Islands. The question is political, the matter is non-justiciable, and thus, this matter is the decision of the lower court should be affirmed. Thank you.
All right. Where did you go? What's your glasses? Where did you go? What's your glasses?
Your Honors, may it please the court?
Proceed.
I am Mary Alice Prosper, also representing the government of the Virgin Islands. Your Honors, I reiterate the words of my co-counsel. This is not a case about morals, virtues, personal beliefs, or pious opinion. We are not denying Ms. Arroyo and Ms. Buchanan equal protection, nor have we denied them due process. The procedure these women seek exists in the United States, but does not in the Virgin Islands, and cannot until congressional action extends such a procedure to the territory. Furthermore, the executive order and Obergefell v. Hodges do not provide the necessary force to extend same-sex marriage to the Virgin Islands. It is for these reasons that this court should affirm the lower court's decision. To my first point, we cannot deprive one of something that does not exist. The right was not denied because of Ms. Arroyo and Ms. Buchanan's sexuality. It does not exist because it has not been extended to our established locality. Article 4 of the Constitution, paired with the language in Balzac, grants Congress the ultimate say in matters of the territory. Where the Constitution assigns a particular function wholly and indivisibly to another department, the federal judiciary does not intervene.
Counsel, hold on. What do you mean? Fundamental rights, aren't we?
No, Your Honors.
So, okay, so if we're not, would you agree that, looking at Balzac, the due process clause of the Constitution extends the Virgin Islands, correct?
Yes, Your Honor.
And Obergefell states that marriage is a fundamental right inherent in a person's liberty under the due process clause of the 14th Amendment, correct?
Yes, sir.
If that is the case, is it your contention today that though the due process clause may be fundamental and attacked by its own force, that challenges to other rights under that clause do not attach to the territories by their own force?
Yes, Your Honor.
Would that be your same argument if you were looking at one of the enumerated rights of the Constitution? Let's say this was an argument for speech or assembly. Would you argue that that type of right doesn't attach by its own force?
Your Honors, the two rights that you mentioned do attach by their own force, but as you stated, marriage is not an enumerated right in the United States Constitution. To my next point, just as a Virgin Islander who wishes to vote for president can move to the United States in order to vote, Ms. Arroyo and Ms. Buchanan can equivalently get their marriage license with all rights and immunities provided by the U.S. Constitution, and then return to the Virgin Islands and enjoy the rights of a married couple. Same-sex marriage is not fundamental in regards to the territory. Your Honors, as stated in Duncan v. Louisiana in 1968, quoted by Wabo v. Villacrucis in 1990, and cited once more in Tuav v. West just last year in the same month that the Supreme Court ruled on Obergefell. It is not sufficient that a right be considered fundamentally important in a colloquial sense, or even that a right be necessary to the American regime afforded liberty. Though the United States may see same-sex marriage as fundamental for the Union, its reach stops at the borders of the 50 states. Trial by jury, though a fundamental right granted by the Bill of Rights, was not considered so fundamental that it was required in Puerto Rico until Congress extended such a right. Citizenship, though coveted by many, as stated once again in Tuar, is not considered fundamental enough to warrant immediate extension to American Samoa. And though we have same-sex couples undeniably, we can't.
Counselor, if you deny people certain fundamental rights, aren't you denying them their due process as well?
Well, Your Honors, marriage is not a fundamental right. Therefore, we are not denying them a fundamental right.
Okay, so the argument you were just about to make, or your argument about denying people citizenship, people of Virgin Islands are U.S. citizens, but they're denied certain things. Aren't they being denied their due process by being denied not being able to vote?
No, Your Honor.
Why not? Why would it be, if unlike American Samoa, where I agree, they are American nationals and not U.S. citizens. The Virgin Islands, as of 1925, everyone born in the Virgin Islands is a birthright citizen of the United States. So why is it that, if your argument is marriage isn't fundamental enough to attach by its own, and we're looking at voting, what due process, why can't Virgin Islands citizens vote for president?
Virgin Island citizens cannot vote for president because such a right has not been extended to the territories, which is equivalent to the right marriage. It is not extended, same-sex marriage is not extended to the territory. Your Honors, 204 also illustrates a possible limit on congressional power and a clear limit on the power of the courts. Until a United States territory is legally and culturally ready to accept the extension of a right, one cannot be forcibly extended. I quote, "To mandate an irregular intrusion into the economy of democratic decision-making would be an exercise of paternalism, if not overt cultural imperialism, to all the U.S. So sadly, Your Honors, though congressional action is the only possible way to extend this procedure to provide a right to these ladies, Congress and the courts have been once again shackled by the insular cases. To conclude, Your Honors, these ladies can take a flight to one of the 50 states, their previous residence in New York, or Ms. Buchanan's home state of Indiana, and purchase a marriage license, return to the Virgin Islands, and have a twilight wedding ceremony at Megan's Point with flowers ordered from All Occasions Flower Shop, cake from Breads and Cakes Bakery, aesthetic apparel from VI Bridal, and have a wedding of their dreams. However, what we cannot do is issue a fraudulent document that violates Virgin Islands law and current cultural norms by any means. No entitlement.
So you're saying that the Virgin Islands is more than willing to recognize a marriage license issued in one of the states?
Yes, Your Honor.
So it's your contention that the only thing that Mr. Roy and Ms. Buchanan cannot get is what? If they can get married, you're saying they still have their right to marry. The only thing they can't get, what is stopping them from just getting married? Yeah. Well, what is actually stopping them from getting married if you're saying you recognize it?
Your Honors, we're not stopping them from getting married. There is no procedure for them to be issued a marriage license, which is what they seek.
As you just pointed out, you said that they could have easily gone back to New York. They could have hopped on a Spirit flight, a Delta flight, a JetBlue American flight, gotten their license, come back, and any religious source, any judge, anyone who is able to sanctize a union would do it.
Yes, sir.
So you're just saying that they really just chose to spend money, spend time before the court for something that would have taken them 2 hours and then stay excited to get.
Yes, Your Honor. No entitlement to same-sex marriage exists, and no violation of the due process or equal protection guarantees of Ms. Arroyo and Ms. Buchanan exists. And as such, this court should affirm the lower court's decision. Thank you.
I have one final question. Is it right that you're basically saying right now that Ms. Arroyo and Ms. Buchanan just need to incur a financial cost to get their marriage license? Is that fair? Is that even right to make them do?
Your Honors, this is not a case about my morals, virtues, or personal opinion. Again, yes, Ms. Arroyo and Ms. Buchanan could have easily taken a flight to one of the 50 states and gotten their marriage license. We do not have a procedure. We do not have a procedure in the Virgin Islands for a license to be issued to them.
Counselor, if they get a license from another state, the Virgin Islands will recognize that license, correct?
Yes, Your Honor.
Okay, so then your whole argument would fail because you're just saying it's a due process issue then at that point, because you're not denying them the right to get married because you're saying that they can get married. You're just denying the process to get married, correct?
No, Your Honor.
Explain, counsel.
We're not denying them the process to get married. These young ladies, Your Honor, I see my time has elapsed. May I please answer?
You can answer the question, counsel.
Your Honors, we are not denying these young ladies the process of getting married. The Virgin Islands government does not have a procedure, and it is not culturally ready to accept same-sex marriage. And therefore, we cannot impose same-sex marriage on the territory. Thank you.
You're so good, man. No, you're good. You're good, man.
Hey, that was a really interesting argument.
Thank you.
That's probably of our four that we have, that is the most out there one, because it allows you to kind of get around the executive order, because the executive order does say you have to follow it, but they're arguing for something that you would get. You could get married, but the procedure doesn't exist, which is what you're missing, Mary Alice. We can't deny you something that doesn't exist.
I had no idea how bad it is to live in a territory legally. And I apologize from the United States that this is totally really bad. I mean, I can't say it with a straight face, but I mean, it's organized discrimination. And then I wish more people in the States actually knew this. Maybe we could help you guys out somehow, because this is really bad.
It actually gets a bit weirder. Our case last year was actually about voting rights, and it brought up another interesting point. Right now, Tuaua of the U.S. is actually supposed to be granted certiorari to go up to the Supreme Court. But what makes it unique is the insular cases point out that every territory should be addressed differently.
Right.
The Virgin Islands has this weird thing where no one has ever actually challenged anything specific to us. And if they did, there's this weird additional point. Every territory except the Virgin Islands was acquired by treaty of war or an acquisition at the end of a war.
Right.
Every other territory that was acquired by purchase is either a state or parts of multiple states. But no one has ever argued that in the Virgin Islands.
Yeah, that'd be very interesting, because I mean, yeah, I think you would have some more rights. I was coming back and reading the Bidwell case, and I mean, and when you take a look at the Bidwell case, Downs versus Bidwell, and then it's expressed very similar to Plessy versus Ferguson. We really are looking at like two levels of and saying that's okay, and this is like totally wrong.
And we're talking about cases that, the funny thing about the insular cases is this: the only one decided after the Virgin Islands became a territory is Balzac. Not one of them referenced the Virgin Islands directly.
Wow.
So we're really in this weird situation where the Virgin Islands may have the ability to get those cases overturned, but no one has actually challenged for it yet.
Yeah. I'm wondering why.
I'll be honest with you. My weird belief about the whole thing is it's that because of the way we're tied to the US, it hasn't gotten to the point where people really feel this need for it, especially with the fact that if this was the 1920s and it was much harder to get to the States, people would be arguing for it. But 2 hours to Florida, you can technically vote. So it gets to this point where no one is really arguing for them yet. They're starting to come up now, but the Virgin Islands might be the very chisel that the other territories need.
Wow. Now, correct me if I'm wrong, but I had this argument, especially on your voting rights case from last year. You could be from the Virgin Islands and be a U.S. citizen and run for president, but you couldn't vote for yourself.
Well, actually you could, but I'll explain how it gets weird. Yes, you could be, once you're a born citizen of the United States Virgin Islands, you can run for president, but you would have had to have resided in a state for a year before. You can actually reside in the Virgin Islands for your entire time and meet the requirement.
Okay.
But that year before you run, you have to reside in a state.
Wow. But then we could have somebody like Ted Cruz, who was born in another country and had dual citizenship, and he could run with a straight face. That doesn't seem to make sense.
It doesn't. And the funny thing is, maybe if he was the nominee, we would have been faced with a unique situation where that would have come up. But yeah, you could very well run for president from the Virgin Islands, because if it was a case like with the Northern Mariana Islands, theirs is a bit weird.
Right.
At one point, your time in the Northern Mariana Islands wouldn't count toward your time being in the U.S. The Virgin Islands always has. And our laws specifically, including the way we were acquired, get really bizarre because the documents of transfer from Denmark pretty much say, though the official transfer was the 31st of March, anyone born after the 1st of January 1970, the moment 1925, February 25th hit, they could have been in any place in the United States, unincorporated territory or not. They were instantly U.S. citizens.
Wow.
They could have been in the Philippines, they would have been U.S. citizens.
Right.
Nobody else in the Philippines would have gotten that on that day.
In when you were part of Denmark, were you a territory, or what were you considered part of Denmark?
It was weird because that entire point of history is one of those unique things for any Caribbean island. We were a territory of Denmark, but we weren't. It's weird because at that point in time, up to 1917, the Virgin Islands was actually used as a free port. So we had jumping back into our history a bit, in 1898, actually, the same time Puerto Rico was acquired, there was a tidal wave in the Virgin Islands, an earthquake and a tidal wave. And one of the earliest reports about that incident was from a naval ship docked in St. Croix, a U.S. naval ship docked in St. Croix. So the U.S. has been kind of trying to have with Germany since about 1868 to buy the Virgin Islands. It's just that the final sale didn't go through until 1970. So though we were Danish at that point in time, because of the position, U.S. money was the currency.
Oh, wow.
It's a lot of little weird things specific to us that the other territories haven't really had to deal with.
Right.
So there's even one of our senators actually proposed that the U.S. should. It's a weird thing because I don't necessarily agree with his views on it, and I kind of know him personally. His comment was the U.S. should apologize for purchasing the Virgin Islands, at least to the Virgin Islands people, because the people had no say in it. And it's weird because $25 million is a chunk of change to put down for the Virgin Islands when you just got in Puerto Rico in 1898.
Yeah.
So the U.S. bought the Virgin Islands for strategic reasons, but in a way provided for more rights than any other territory at that time. And the Organic Act, I'm glad that your students looked at the 36 and the 54 versions of it. 36 makes no mention of us being an unincorporated territory.
Right. And
only until 54.
Right. And I think they did that to gain more power over the situation. I mean, it's a deliberate point of change that they realized that they were trying to slip one over, I guess, is what you try to say. That's really that unfair. And you don't really see that, but we're having a little bit of the stuff coming from Puerto Rico with the recent bankruptcy and different things. You know, I had no idea. We've been working with the JAG Corps doing some law day stuff for them. And one of our partner lawyers from the JAG Corps was from Puerto Rico, Ms. Maldonado, and Captain Maldonado. And she was telling us that she is, I said Puerto Rico, and her parents were up here and they came by and visited us. And they were saying about the laws that you can't have to use American ships to go to from place to place. And you can't make treaties, you can't do this, you can't do that. So basically you're kind of tied on your commerce and your trade on what you can do. So it's very difficult to have free reign to gain any taxes or whatever you want to do.
And I actually think Puerto Rico is in a weirder situation than us, simply because the word Commonwealth, people tend to believe that it actually means that their status is different compared to theirs and ours. Commonwealth is just a phrase. The Northern Mariana Islands are a Commonwealth of the United States also. They're still unincorporated territories.
Yeah, and even though it's supposed to be just underneath a state, doesn't mean they're going to get statehood any quicker nor any more rights. It's, it's just like a supersized hamburger. it's not any bigger. It just costs more money or whatever.
And I am actually one of those people who in regards to the Virgin Islands, Puerto Rico is a little different. I do believe they could make a better argument for statehood because of their size. I actually think that there's an additional option because the whole UN Charter in regards to the removing of the colonial status in regards to overseas governmental territories says that sovereign nations must give territories the ability to self-determine. I don't think that the only choices we have are free association, status quo, or statehood. I'm actually not of the belief that Congress would go out of its way to allow us to say we're incorporated and they'll think about that. But I think there's a fourth option nobody's addressed. The District of the Virgin Islands.
Yeah.
The entire amendment provided for that. Why not just provide an amendment that creates a special district until, because we won't have the population size to become a state. But if you go in a special district, you inherit those, you can still inherit the same form of federal taxation if it comes down to it, without having to worry about population size, districting, appointed senators. You can very well just say, okay, the Virgin Islands gets one senator to do its size. And it adds an additional congressperson, just the way DC says that they get an apportionment of an electoral college voters equal to the least popular state in the union. We could very well get the same apportionment minus one. That would give us two.
Yeah. Well, this has been fascinating to me because I had no earthly idea, and actually, Northern Mariana Islands have a moot court too, and it would be kind of neat to get both you guys together and do stuff like this to have territory. And their cases hadn't been so territorial; they've been mostly like regular state cases. So I guess we didn't know the plight of the territories until we actually picked this up, and it's really been an eye-opener for the girls because they've been working really hard trying to prepare to at least give you some arguments about that. So we wish you the best of luck. When is your competition?
They pushed it back a week, so our first day is the 31st of May.
Okay.
And finals will be on the 2nd of June.
Wow. And you guys win quite a bit of times, don't you?
We actually have won the last 3, and we have about half of the wins for the competition. But this year, I'm honestly not sure how that's going to play out because we're not sure who the other schools locally are. So we have taken the last 3. We're kind of attempting for a 4-peat this year. We were the first school to ever win 3 back-to-back. We're trying to be the first school to win 4 back-to-back also.
Oh, that's good. Congratulations. You do a really good job. Your kids are very good.
And we're actually missing one of our arguers. She's actually aware of a close-up trip to DC.
Oh, wow.
So she's actually off island. And it's just a matter of figuring out who our 6 are, because we're pretty much down to 7, and we're hunting just to make sure that 6 we put forward are the strongest 6 we can find.
Good. I wish you guys the best of luck, and I'll be emailing you because I'd like to try to do some other stuff. When does your school year end and begin?
Our school year ends, the exact day this year is actually the 22nd of June. Okay. I still have access to my school email all across summer though, so I consistently use my school email. We start back this year, the first week in September, I believe. I think we start back that first week in September. I can actually give you the exact date. Give me a sec. Mm-hmm. We return, actually, yeah, our first day of school is the 6th of September.
Okay. Well, I'd like to try to see if we could see, we could get you involved. We could get you involved in doing some stuff in Australia where you could actually be in a courtroom in Australia and you can present a court case. We do the same with Ontario in Canada. You could be in a Canadian law case. And then we do, we'd like to do one like with you guys in your territory. And then we invite you to do one for, we have our Army, JCOR will work with you and they can actually work with you through the computers too. And they would help you out, which they would think would be kind of neat because we have quite a few there from the territories. So they would maybe even get a territory case, and they would really like it. I mean, I know Captain Maldonado was, she was wanting to come today to actually talk with you because she's, like I said, from Puerto Rico, but she's very interested in territorial law.
All right, well, I've never even used Zoom until today. I kind of like how it's set up. If you can get her for a day, anytime next week, I could even see if I could get the team. I tend to meet with them daily. It's just that we don't always get everybody. If it comes down to it and she starts the time to meet us and you could give me a date, I'd have no problem scheduling another go around. By then we should have the arguments a bit more polished, have those intros and outros hammered, and we'll be good.
Yeah, I'll try to get a hold of her this weekend, and I'll try to shoot you an email, and I'll shoot you an email and telling you when the links are, what the links are to this, so you can watch your kids. Okay?
That would be excellent. I'll touch base with our administrator so they could know how this went, and let's see if we can officially get it started. So next year I can just build my team from the start of the school year and work our way across the whole thing.
Well, what we would do is you really would get a international feel, and we would get a good territorial feel too. But you could actually, kids could experience, and they would be cross-examined by judges in Ontario and then in South Australia. And if we get really lucky, we're trying to get South Africa too. So that would be really kind of nice all the way around.
That would be excellent. It helps us. It helps us to broaden their horizons and their view of the world, because it always helps to learn about how places operate, especially legally, period. Especially from us, who people tend to believe we're on this nice little small island and we don't know more.
Yeah, I don't think there's any place anymore you can really hide and it's perfect. So, I think they could actually see that kids will be kids and adults will be adults and crooks will be crooks.
Pretty much.
And lawyers will be lawyers, and we'll see what happens. But I'll say goodbye today, and thank you so much, okay?
Thank you. You have a question?
Bye.
If it pleases the court, Your Honour, my name is Edwards. Can I appear for the prosecution along with my learned friend? We are here today because Jenny Smith, the defendant,
Just wait, let them introduce themselves.
Just say your name so people will know for the record here, Okay.
I'm here. Just shut my door.
Okay, good. Okay, now the people from Australia will tell you their names right now, if you don't mind, and we'll just tell you our names and then we'll start. Okay.
Jennifer Edwards, prosecutor. Shana Proden, prosecutor.
Joshua Stark.
Detective Amelia. Dr. Anna Miles.
Thank you. Okay.
Defense attorney Risa Rodriguez.
Dr. Alston.
Okay. I guess you got all that, so let's go ahead and Judge, you can ask them to start their first opening statement, please.
We are here today because Jenny Smith, the defendant, brutally murdered a 7-year-old boy, Benjamin Netlow. We will prove to you that not only did Miss Smith murder Benjamin Netlow, but it was premeditated and she clearly knew what she was doing at the time. Miss Smith was 17 at the time of the case, and due to the heinous nature of the crime, according to Texas Penal Code Section 807, age affecting criminal responsibility, she is being charged as an adult and needs to be punished for her actions. Benjamin Netlow was a young boy who was playing in the park with his friends. as he had done on many occasions until he was brutally murdered by Ms. Smith. Benjamin Netlow had 9 stab wounds and no doubt would have been in excruciating pain whilst trying to fight for his life. The defence may argue that Ms. Smith is legally not responsible for her actions as she was on Prozac at the time, and it is the Prozac that had given Ms. Smith violent tendencies. We will prove that this is not the case and that Ms. Smith knew exactly what she was doing prior to the murder, during the murder and after the murder, and was mentally competent at the time. We will call 3 witnesses, Detective Sergeant Amelia Hodges, Dr. Joshua Sapp, and Dr. Anna Miles, who will all attest to the killing of Jenny Smith. There is absolutely no doubt that Ms. Smith is the person who murdered Benjamin Netlow. The evidence is conclusive. Thank you, Your Honour.
Okay.
Your Honor, Iris Rodriguez will present Jenny Smith.
Need to turn y'all up. Hold on. Can you say that again?
Yes. Your Honor, Iris Rodriguez will present Jenny Smith in the case of court today. We have just, as they explained why Jenny Smith should be convicted of the crime of first-degree murder. 5 important aspects of this case. First, the police called for a juvenile officer to sit on the interrogation of her client only after the body was found, and Jenny Smith had been talking to the police without her Miranda rights being read. In Miranda being read, police officers are required to inform her of her rights. Fifth Amendment right to remain silent and right to counsel anytime a suspect is subject to an interrogation. A suspect is under interrogation when a police officer's words or actions reasonably likely to elicit an incriminating response, or the officer either intends to and knows that such a response is likely. Quantify Rhode Island v. Innis. Second, a large portion of the evidence that will be presented in case was obtained from the statements that were given by her client without having their rights read to them, without a benefit of an attorney present, and without a benefit of a juvenile officer present, all of which make this entire evidence inadmissible in court today. When determining whether a suspect was in custody, courts must take into account all of the surrounding circumstances, thus apply Rhode Island v. Innis. The suspect's age is one of the factors the courts consider. Now, third, the police must follow the laws of Texas and rule those laws. They cannot short circuit or go around the law simply because they are trying to uphold the law or solve a crime. They cannot break the law to uphold it. If this were the case, the police would become criminals themselves. Their job is to protect and serve, not to do anything in their power to take away the rights of our citizens. Fourth, the prosecution has taken into oath to uphold the laws of Texas, and their team must do so in the prosecution of this case. They must convict their client through credible, legally obtained evidence and through good police work. We will show Your Honor that that is clearly not the case today. You cannot use information from a custodial interrogation of a minor for evidence against them without reading their Miranda rights first. Cross-apply JVD v. North Carolina. Now, 5, Dr. O'Reilly will testify and that Dr. Merrick's diagnosis was done in 1 visit, and then Jenny was prescribed with Prozac. 4 months later, then doubling the dosage. Jenny Smith had horrible side effects and loss of control over herself. We will call Dr. O'Reilly, Jamie Manning, and Joanna Stabler, and they will testify to our client's state of mind, her family lifestyle and situation, and bring out great many mitigating facts of this case. You will see an entirely different side of this case. We know, Your Honor, that after you carefully listen to our case, weigh the testimony of our witnesses, and listen to our cross-examination of prosecuting witnesses, that you will return a not guilty verdict for Jenny Smith. Thank you.
Mike, can I just interrupt for a minute? Our connection obviously isn't as great today, so we'll obviously have to slow down when we're talking, and if you could do the same, because we did miss probably a quarter of that speech.
Okay, we'll try.
Thank you.
Go, Aaron, call for their first witness.
Okay. First witness, please.
We call Detective Emily Hodges. May the witness please be shown this. It is a copy of the Brookbend Police Report.
Yes.
Detective Hodges, is this a report that you approved and was written by Officer Donnie Murray?
Yes, it is.
Your Honour, I would like to move this into evidence.
You may.
Can you please explain what led you to believe Miss Smith was a suspect?
Officer Donnie Murray and myself had gone back to the park that Benjamin Nettler had been and discovered that there were two children, Johnny Pooh Bear Holmes and Todd Kookaburra Jackson, that had seen the same girl wandering around just watching them.
Did you interview either of those boys?
The next day, I did. Officer Donnie Murray and I went back to further question Todd Jackson, as Officer Murray had felt he had more information that he had not stated the day before.
And what information did you get from Todd Jackson?
That he had seen the same girl at a snack bar several days before and learned her name was Jenny Smith and also got her number.
So how did you find Jenny?
Using the number Todd had gave us, the Brookbend Police Department were able to locate the girl, Jenny Smith.
What happened then?
Jenny was brought into the station for questioning.
Was her guardian with her?
No. Officer Donnie Murray left Smith's guardian a note and several messages on her phone.
Did she admit to harming Benjamin in some way?
No, she admitted being at the park but denied seeing or talk to Benjamin Nettler.
From all of your experience on your previous cases, when a person denies seeing the victim, does this not mean that they are trying to hide the fact that they have done wrong, as they have a guilty conscience?
In my experience, this has been the case.
What did you...
Yes. Sorry, I need to turn you up. Yes, go ahead.
Objection, Your Honor. Speculation.
Can you repeat that?
Objection, Your Honor. Speculation. The witness was never entered as an expert witness.
It's hard to hear. I'm sorry.
The witness, objection, Your Honor. Speculation. The witness was never entered as an expert witness.
I'm an expert in my field.
Sustained.
What did you decide to do then?
We decided to take Jenny Smith back to the park to show us where she was the previous day.
What did you discover?
As we walked along, we noticed a rectangular hole in the ground. As we passed by, Jenny Smith kicked some dirt in there and cursed softly underneath her breath.
What happened then?
I asked Jenny Smith about the hole, and she admitted that she had dug it 5 days prior. She also stated the fact about there not being a law about digging holes in a park and that there was nothing in there anyway.
Normally when a person digs a couple of holes 5 days in advance to committing a crime, would you suggest that that person had planned to do something with them?
Objection, Your Honor. Speculation.
Can you, I need to hear the statement again. Not you. I'm sorry. I need to hear what you were objecting to again.
Normally when a person digs a couple of holes 5 days in advance to committing a crime, would you suggest that that person had planned to do something with them?
Sustained.
Yes, I would.
At this point, did you think Miss Smith was involved with the disappearance of Benjamin Nettler?
I did, so we called for officers to search the rest of the park.
What did they find?
They found a second hole in the same rectangular shape that Miss Smith had admitted to digging.
Did they find anything?
They found Benjamin Nettler's body covered in 5 inches of dirt and leaves.
What was the condition of the body?
Benjamin appeared to have been stabbed multiple times.
What was Jenny's behaviour like when she was being interviewed?
She seemed lucid, calm, and collected during the interview.
Did she admit to harming Benjamin Nettler in any way?
A statement was taken in which she indicated having lured Benjamin away from the park, stabbed him multiple times, and then buried him.
Who was present in the interview?
Officer Donnie Murray, myself, and Juvenile Officer Leah Cotte.
At this point, was she arrested?
Yes, she was, and we obtained a search warrant for Jenny Smith's home.
Your Honour, may the witness please be shown this. It is a copy of the journal entries and the knife and wall picture.
Yes. Yes. Yes.
Detective Hodges, are these the journal entries and the knife picture from the wall that were found in Jenny Smith's bedroom?
Yes, they are.
Your Honour, I would like to enter this into evidence.
Yes, you may.
Did you find anything of particular interest in the defendant's room?
There were several pictures of serial killers on her wall labelled as her heroes.
Anything else of interest?
Yeah, her journal entry from January 1st.
Are you referring to where it said, and I quote, "This is going to be my year. I'm finally going to do it. New Year's resolution. Introduce my friend to someone. Now I just need to find the right kid. It better be soon because I can't wait. I want to know how it feels."
Yes, I am.
When it says friend, what is it talking about?
Officer Donnie Morrow, Juvenile Officer Leah Cotte, and I also found a picture of a knife on her wall in which she had labelled as her friend. This is particularly disturbing to me, especially for a juvenile.
Did you find anything linking Miss Smith to the murder?
Circulation.
Yes. We found a bloody knife between Miss...
Hold on. I think they... Can you repeat that?
Your Honor, speculation when they were talking about what the opinion on what she thought. Again, the witness is not entered as an expert.
Again, not entered as an expert witness. Sorry, the sound's been cutting in and out.
We're having the same issue our end.
Try to say it one more time. I'm sorry about that. I turned it way up.
Is that me? Well, objection, Your Honor. There was a statement made referring to what they thought about the knife. Again, the witness is not entered as an expert witness, so therefore the opinions are not validated.
Sustained.
On page 3 of the police report, in the last paragraph, Officer Donnie Murray said Smith's actions were deliberate and pre-planned. Do you agree with this?
Without a doubt.
No further questions, Your Honour.
You may redirect. Sorry, I'm new at this.
Cross-examine.
Cross-examine.
Detective, you said you picked up Jenny from her house at about 10 a.m. on January 8th.
Sorry, could you repeat that?
You said that you picked up Jenny Smith from her house at around 10 a.m. on January 8th of 2012, correct?
Correct.
At this time, Jenny Smith was in your custody, correct?
Correct.
Now, you were in charge of this investigation, correct?
Correct.
So ultimately, the person in charge is responsible, correct?
Yeah.
Now, you took Jenny Smith into custody to bring her downtown to talk at the police station, correct?
Correct.
You asked Jenny Smith questions about the death of Ben, correct?
Correct.
In the course of these discussions with Jenny Smith, you asked questions which you obtained information about Ben's death, correct?
Correct.
Now, asking questions of a suspect in custody to solicit information is called interrogation, correct?
Correct.
When you interrogate a suspect you have in custody, it requires that you read those people their rights, correct?
Correct. Now,
Jenny Smith has an additional protection under the law because she's a minor, correct?
Correct.
It would require the police to read juveniles or Miranda rights before asking questions. You were out of compliance when you used information on the body, correct?
We did.
Your Honor, we move to dismiss this witness and to dismiss all evidence that the witness identified in the court today.
I was interrupted for just a moment. On what grounds?
That all of the evidence was obtained acting illegally under custodial interrogation that happened without reading their rights to my client before the interrogation took place.
Right.
We did read her rights.
I'm gonna allow it. Allow the witness.
The prosecution just admitted that yes, Jenny Smith was under their custody and they didn't read her rights until after they arrested her, which means that all the interrogation and all of the evidence found from that interrogation is inadmissible in court today, Your Honor.
Your Honor, you're
Okay.
just a witness. Can we move on?
Say that one more time.
Your Honor, we just allowed the witness. Can we move on?
We can move forward.
Thank you.
Your Honor, you cannot abrogate people's rights, and this is clearly what happened with Jenny Smith. Why? Because it took all of the information from the legal interrogation.
Sorry, Your Honor, why are we still discussing this? We allowed the witness. You allowed the witness.
I what?
I did say that I would allow the witness earlier.
Can we call our next witness?
Let's move on to the next witness.
Thank you, Your Honor.
Thank you.
We call Dr. Joshua Sapp. Dr. Sapp, can you please tell me what your job is?
I am the Brookbend Medical Examiner, Texas.
How long have you been in that position?
11 years.
Where were you working prior to that?
I was the Assistant Medical Examiner of Brookbend, Texas for 5 years.
So you have been in this field for many years and have lots of experience.
Yes,
Who is the current president of the National Association of Medical Examiners?
I am.
How many autopsies have you performed?
Over 2,000?
Did you conduct the autopsy of Benjamin Netlow?
Yes, I did.
When did you perform the autopsy?
I did it on the 10th of January 2012.
Who else was present at the autopsy?
Detective Sergeant Amelia M. Hodges.
What age was the victim, Benjamin Netlow?
He was only 7 years old.
What did you rule his death as?
Homicide?
And what was the cause?
Multiple stab wounds, 9 in total.
Your Honour, may I approach? I'd like to enter the report of autopsy.
You may. Yes.
May I show the witness?
You may. Did you ask? You may approach the witness. I didn't hear the question.
May I show the witness?
Yes, you may.
Dr. Sapp, for the record, could you please identify this?
It's the autopsy report of Benjamin Netlow that I wrote.
Your Honour, I'd like to move this into evidence.
You may. Yes.
Dr. Sapp, could you please read out the highlighted sections on page 6?
The descendant sustained multiple sharp forceps injuries, including multiple stab wounds involving the chest and abdomen, multiple incised stab wounds of the neck, and multiple incised cutting wounds. Fatal wounds were identified involving the neck, where the transaction of the jugular vein stab wounds. Chest and abdomen causing inthoracic and abdominal hemorrhage. Of note, the cutting wounds of the left and right hands compatible with defense wounds. In addition, there was a number of blunt force injuries to the upper extremities hands, likewise compatible with defense wounds. The remainder of the autopsy revealed a normal, healthy male child with no congenital anomalies. Routine toxicological studies were ordered.
Your Honour, I would like to enter this evidence.
Yes, you may. I'm sorry. Yes.
For the record, could you please identify this?
It's the diagram of the male body.
Your Honour, we would like to move this into evidence.
Yes, you may.
Now there are 6 stab wounds, 4 of which your report states as fatal, and 3 self-defense wounds. In your opinion, based on the numerous stab wounds you have seen in your extensive career, does this look like someone was intentionally trying to kill the victim?
Yes, it appears to me that there was a lot of aggression.
Thank you, Dr. Sapp. It is horrible to think of the trauma poor little Benjamin Netlow experienced in his dying moments whilst he was fighting for his life. No further questions, Your Honour.
Okay.
You found the fence wound on Ben Elgo's body, correct?
Would you be able to repeat that? I can't hear you.
You found the fence wounds on Ben Elgo's body, correct?
Yes.
You believe that he put up a struggle before he was killed, correct?
Yes.
You didn't find any fingerprints on the body, did you?
No.
How many autopsies have you performed exactly?
Over 2,000?
Have you speculated in all of your autopsies?
No.
You cannot tell by looking at the wounds what motivated a person to murder someone, correct?
Yes.
Oh.
Yes, you.
Repeat that last part.
Yes, you cannot tell.
Yes. I'm highly professional, down, and good at my job.
But you cannot, by looking at a body, you cannot tell what the person had in its mind, correct?
Based on previous experiences, yes.
So you're saying that you do speculate, correct?
Your Honour, we've answered the question. Can we please move on?
I think, sorry, what's the word? I'm allowing the question. Can you re-ask the question? I don't believe he's answered the question if he speculates or not.
So you are saying that you are speculating. Correct.
No.
Speculation, correct?
Sorry, I couldn't hear you.
In fact, you cannot ascertain through an autopsy if a death has been premeditated or not, correct?
No.
So you cannot tell if a death has been premeditated or not, correct?
Your Honour, he just answered that exact question.
He did. Let's go ahead and move forward.
I just want to make sure that you answered, that I heard your answer right. No further questions.
You may step down. Forward, yeah.
Your Honour, we call Dr. Anna Miles.
Okay.
Dr. Miles, how long have you been in the field of psychiatry? I've spent more than 15 years treating patients with psychotic depression. Is treating psychotic depression your area of expertise? Yes, I am qualified as an expert in both Texas and federal courts and have written 3 books published directly to this case. What was the dosage of Prozac Jenny Smith was prescribed in July 2011? She was prescribed 20 milligrams by her physician. Why was the dosage up to further 20 milligrams? To my knowledge, it was because Jenny Smith's behaviour had not improved. Is this a higher dosage for a 15-year-old girl? No, it is not. What exactly was Miss Smith diagnosed with by her physician? She suffers from bipolar disorder and manic depression. Can you explain that? It is a mood disorder which causes episodes of depression. Prozac has been found to be effective treatment for depression in both children and adolescents. Is this correct? Yes, scientific studies show that drugs such as Prozac are effective treatments. Do you have any evidence of this? According to Dr. John M. Archol, the director of the Depression Center at the University of Michigan, Prozac is designed to increase serotonin, a feel-good brain chemical. Has Prozac been linked to acts of violence such as suicide and murder? No study has shown a connection between Prozac and increased incidents of violence, including suicide and murder. The FDA also has no evidence to say it does either. Is that it? The American Journal of Psychiatry analysed data from over 207 drug trials, which included 50,000 patients. What was the outcome? The study concluded that antidepressants were not associated with an increased risk of suicide or violence with major depressive disorder. Are you familiar with the journal Drug Safety? Yes. There was an article in there that analysed and reviewed over 2,000 studies of antidepressants, and suicidal events concluded that there appears to be little evidence that drugs increase the risk of suicide and related behaviour. Do you agree with these findings? Absolutely. What can you tell me about Prozac in regards to aggression? Prozac has been found to decrease hostility and aggression in people like Jenny Smith who suffer from manic depression. Dr. Miles, can you explain the connection between the rise of suicide and violence rates and the decrease in antidepressant use? The FDA requires black box warning on all antidepressants, which has resulted in the decrease of number of children and teenagers being put on Prozac. What has happened because of this? A recent study has found that the rates of suicide and violence has risen as the use of antidepressants fell. So basically taking teenagers off Prozac puts them for dangerous behaviour to themselves and others. What does this show? It demonstrates that children and teenagers that are in need of antidepressants but do not receive them because of fear of the warnings on the box, but they have actually been shown to become more violent and suicidal without adequate treatment. In your opinion, is Jenny's suicide attempts and violence linked to her taking Prozac? No. This means there is no evidence to suggest that Prozac impaired Jenny's judgment and was the cause of her actions in carrying out the murder of Benjamin Netlow, correct? Yes, there is no evidence to prove this. So Jenny Smith, even whilst on Prozac, still had the mental capacity to know what she was doing and was well aware of her actions. Yes, Jenny Smith's judgment was not affected by Prozac as she engaged in some planning prior to the murder, showing that this was something she deeply thought through and that it was premeditated. You say it was premeditated. What prior planning are you talking about? I'm referring to the journal entry dated January 1st, 2012, where it mentions she wanted to introduce her friend, which was a knife, to someone. She needed to find the right kid soon to see how it felt. This was literally 6 days before she killed Benjamin Netlow. Was there anything else concerning in those journal entries? In the January 7, 2012 diary entry, she further alluded to the fact that she would kill someone else. Just to make this clear, in your opinion, did Jenny Smith know right from wrong at the time she committed the murder of Benjamin Netlow? Yes. No further questions, Your Honour.
Thank you.
You found
You may go ahead. Are you ready?
Yes.
It's cutting out again.
You are being paid for this testimony, correct?
Yes.
Yeah.
As all expert witnesses are.
You have worked for drug companies in the past, correct?
We cannot hear you. Could you please speak up?
Speak.
All right. You've worked for drug companies in the past, correct?
Pardon?
Dr. Austin, you have worked for drug companies in the past, correct?
I've spent most of my time as a psychiatrist.
Dr. Austin, you have been an expert witness for drug companies in the past, correct?
No. I worked in the clinical research.
Wait, so are you contradicting yourself now? Is that it? You clearly
Clinical research is not a drug company.
Dr. Austin, let me see if I understand you clearly. You have no experience about representing and being a testimony for drug companies then, correct? No experience at all.
I have not testified for drug companies, no.
All right. Dr. Austin, you never personally examined my client, correct?
Yes.
Yes. I don't recall. Let me remind you that you are under oath, Dr. Austin.
Yes. That is correct. I did not personally examine Jenny Smith.
When she went to the hospital on November 11th, correct?
Pardon?
You never examined her when she went to the hospital, correct?
No.
Now, all of your decisions are based on theoretical opinions, correct?
Well, you cannot hear you. You're cutting out.
You can't really assume, all of your assumptions on this case are based on theoretical opinions, correct?
I have a bachelor's degree from Yale, a medical degree from Harvard Medical School, and I've spent more than 15 years in my area of work. I think I'm like qualified.
According to my last question, you testified that this is the first time that you experienced being a witness in the courtroom, correct?
No. For a drug company, I testified.
No,
I didn't testify.
So,
let me get something straight. It seems a bit confusing. It seems that you just caught yourself while you were under oath. So have you testified or not?
I have not testified. I have testified before, but I have not testified for a drug company.
That's not what you said.
That is what I said.
No, it's not.
Yes. Yes.
It's still muted, I think.
So that would mean that you have no drug expertise, correct?
I have clinical research.
Clinical research, but no drug expertise, correct? Yes or no?
Clinical research is legal.
Yes or no?
Yes. I've testified in over 100 trials.
The experience, as you just said, and you never examined my client, this would all come down to simple theoretical opinions, correct?
And the evidence.
What evidence?
I was given reliable sources of information from the psychiatric report, medical reports, and police reports, as well as a statement from Jenny Smith to the police and other witnesses. I believe these are reliable sources of information to give a full diagnosis.
So that would mean that you are testifying on hearsay evidence, correct?
It's not hearsay, it's affidavits.
No, it's affidavits.
You don't personally, you were not personally there, correct? So therefore that's all hearsay, correct?
I was not personally there.
Now, you cannot really assume what is going on in another person's head without professionally examining them, correct?
No, but the police and the other psychiatrists did examine them, didn't they?
But you didn't examine my client.
No, but I looked over their information.
Again, once again, over other people, correct?
Pardon?
You're testifying over other people, once again, correct?
Yes, highly qualified professionals.
Reviewing all of your answers, this would mean that all of these are theoretical opinions based on other people's opinions, correct?
Yes, and my expert opinion as well.
I'll pass the witness.
Honor, can we redirect?
Okay.
You may redirect.
Dr. Miles, do you have over 15 years of experience in your psychiatric career? Yes, that is correct. No further questions, Your Honour. That concludes the prosecution's witnesses.
Our first witness is called Dr. Catherine.
Sorry, can you repeat that?
We will be calling our witness, Dr. Catherine O'Reilly. Now, for the record, please state your name. Dr. Catherine O'Reilly. Could you please tell us your occupation for the record? I'm a psychiatrist with a private practice in the fields of psychopharmacology and psychotherapy. For the record, could you please tell us about your medical education? Yes, I have my undergraduate from Rice, my medical degree from the University of Texas, and I did one residency in psychiatry at Harvard Medical School and a 2-year residency at UT Southwestern Medical Center. What medical schools have you taught at? Harvard Medical, Johns Hopkins Medical, and the University of Texas Medical School. What other experiences in this area have you had? I've given lectures at various medical schools all over the country and presented for the past 20 years at medical seminars and published over 100 journal articles and medical journals. Your Honor, we would like to move that Dr. Catherine O'Reilly be considered an expert witness in areas of psychopharmacology and psychotherapy.
You may.
For the record, what, if anything, do you know about this particular case? Well, I interviewed Jenny Smith, her guardian, Kara Smith, her childhood friend, Jamie Manning, and school counselor, Joanna Steebling, her father, Drew Smith. I also reviewed Jenny Smith's medical, psychiatric, and school records since childhood. From this study, what have you conducted about this case? What, if anything, are your conclusions? Well, she appears to have been a pleasant, active child. She had bouts of minor depressive periods when her parents divorced. Their family pet also died, and when her father was arrested and sent to prison. She was extremely close to her mother, and when she died, Jenny became withdrawn with first depressive behavior. What, if anything, happened to Jenny Smith after her mother died? Well, Jenny began seeing a psychiatrist in July 2011, at which the time she was diagnosed with being bipolar and manic depressed. Your Honor, may we approach the bench?
Yes.
We would like to enter evidence, the clinic notes made by Dr. Merrick about her patient. Your Honor, may I approach the witness?
Yes.
Who is Ashley Merrick? The psychiatrist who treated Jenny Smith from 2011 to 2012. And what are those? These are the clinical notes of Dr. Merrick about Jenny Smith. When did Dr. Merrick first see Jenny Smith as a patient? July 25th, 2011. What was Dr. Merrick's diagnosis after this visit? She was diagnosed with both bipolar and manic depression. What, if anything, was unusual about this diagnosis? Well, both actually require a very complete exam that would take more than one visit to see the doctor. What, if anything, did the psychiatrist prescribe for Jenny at that time?
Well, it was originally 20 milligrams a day of Prozac, and about 4 months later, on November of 2011, they upped the dosage to 40 milligrams a day.
Dr. O'Reilly, what is your opinion on the Prozac?
Well, Prozac has a terrible impact on the brains of teenagers, and a person's brain is not fully developed until the age of 25. The use of Prozac can lead to greater incidence of violence. The adverse side effects of Prozac are anxiety, aggression, psychosis, hostility, and rage.
What, if anything, did the U.S. FDA require the makers of Prozac to put on the label?
There are suicidal thoughts or abnormal behaviors in teenagers.
What, if anything, did the Canadian government conclude about the use of Prozac?
That Prozac is not authorized for use in children because it can cause self-harm or harm to others.
What, if any, changes did Dr. Merrick do to Jenny Smith's Prozac on October 26, 2012?
Double the dosage to 40 milligrams per day.
Excuse me, as an expert, I have to ask you, why would you double something that wasn't working?
Well, that's actually a good question. It doesn't sound like medical reasoning. After she doubled her medicine dosage, Jenny Smith attempted suicide and then now has been accused of murder. All of this happened within 2 months.
Dr. O'Reilly, what is your expert opinion concerning Jenny Smith's state of mind at the time of the death of Benjamin Nelko?
That she was not responsible for the death. Her downward trajectory began when she started taking Prozac in July 2011. Then when the prescription was doubled, her problems only became worse. Had she been hospitalized in November 2011 when she began to self-mutilate herself and would not have had a suicide attempt in December of 2011 or a murder on January 2012.
Dr. O'Reilly, what did the government say Prozac would do again?
That there could be a possible cause of a teenager to harm themselves or others.
No further questions. I'll pass the witness.
Your Honor, may I approach the bench?
Yes, you may.
I'd like to enter this evidence.
Yes,
It is the affidavit of Catherine O'Reilly.
I'll allow it.
Ms. O'Reilly, you say in paragraph 2, page 3 of your affidavit that the use of Prozac can lead to greater incidence of violence in teenagers, and studies have found that there is a direct correlation between Prozac and violent side effects in juvenile females. Do you have any specific studies that you are referring to? Sorry, I couldn't hear that.
Yes, I go by the statement which was actually made by the government of Canada.
You referred to Canadian research in your testimony just now. Is that because you don't have any Texas data?
Well, it was actually the FDA of the US.
So is it Canada or US?
Understand how it would be different if, I mean, it's just talking about teenagers and the effects that Prozac would have.
The reason I ask this is because Dr. Amal states in the affidavit in paragraph 2 on page 2, and I quote, Prozac is commonly prescribed 20-year-old antidepressant. No scientific study has shown a connection between the antidepressant drug Prozac and increased incidence of suicidal violence, including murder.
She's been working with drug. Okay. She's been.
Mike, we can hear you. Continue, Jen.
Neither the medical field of the FDA has found any link between Prozac and acts of violence. There is no reliable scientific evidence that Prozac causes people to commit murder, and in fact, it has been proven to decrease in hostility, aggression, and anger in people who, like Smith, suffer from major depression and a borderline personality disorder. Do you have anything to say to this?
Objection, Your Honor. She's not. You're asking her questions about her testimony. Clearly, she has already given her testimony. It is what it is.
That's questions about Dr. Miles' testimony.
That's questions about Dr. Miles' testimony.
What my client, what the doctor is clearly doing is offering her testimony, not talking about somebody else. Because if she were to talk about somebody else's words, then that would be hearsay.
She just heard that evidence. You claim she is an expert witness. She should be able to answer the question.
Please just ask the counselor of the opposing team to please just ask the question.
I need the objection. Can you repeat the objection?
They just ask the question.
Do you have anything to say that there is no FDA conclusive evidence?
I cannot testify for the FDA.
You have also said that you disagree with the bipolar and the manic depression diagnosis from Dr. Myrick, Miss Smith's physician. Dr. Anna Miles testified that she did agree with the diagnosis. What is the reasoning for saying that Miss Smith does not have bipolar?
Well, in order to be diagnosed with these conditions, it needs to be more than one visit to the doctor. And in this case, I mean, there was only one.
There were several visits to her psychiatrist.
It was the first time. And in order to actually be diagnosed, there's supposed to be several tests.
Can you repeat that?
You also noted.
Sorry, I didn't hear. Didn't hear the first part that you said. I'm sorry. Can the witness repeat that statement?
I said that in order to actually, for these conditions to be diagnosed, there's supposed to be several tests, not just one.
You also noted that you were concerned Miss Smith was released from hospital too early. However, her psychiatrist, Dr. Ashley Ellen Myrick, was treating her on an outpatient basis. Have physicians not done this in the past?
Doesn't mean it's correct.
Do you believe that Joanna Stebley, the school counsellor, did her job properly with following up Jenny Smith? Yes or no?
I can't really talk for her.
You're an expert in your field.
Well, in my field, I'm just talking about the Prozac, and that it should have been more than one visit in order to actually be diagnosed, and that's what I'm saying.
50% of your practice involves dealing with team. Only 35 is with the pharmacology.
So why would you double something that's not working? Clearly the 20 milligrams wasn't working, and it was doubled to 40 milligrams a day.
Obviously it was having no effect on her, correct?
That's why she went to the hospital.
Do you believe that Jenny's behaviour was so bad, according to Joanna Stebley, she should have seen her more than 3 times in approximately 3 months? If she was your patient, would you have not seen her more?
Objection, Your Honor, out of scope of kids.
Sustained.
Your affidavit states on page 4, the second paragraph, that Jenny has nightmares. You also say that Jenny said she felt as if she were in a trance. The nightmares and remorse tells me that Jenny was fully aware of her actions prior and at the time of the murder. How can you say with the remorse that Jenny feels that she's not guilty and doesn't know what she was doing?
When the Prozac label clearly states that it has a warning for teenagers, and such as I mentioned, the brain is not fully developed until the age of 25, and the effects are such as the ones I mentioned of depression and either having suicidal thoughts or harm to themselves or others.
And Dr. Anna Miles has testified the exact opposite of you. It is highly possible that there have been any teens in Texas who have displayed.
Objection, Your Honor. It seems to me that the opposing counsel is testifying instead of asking questions.
Please stick to questions, counsel.
Is it highly possible that there have been any teens in Texas who have displayed aggressive and suicidal behavior that are not on Prozac?
Yes.
Yes, answer the question.
Objection, Your Honor. That's a hypothetical question. That's please go to please. The doctor cannot answer hypothetical questions.
Anyone could answer that question.
It's not correct to answer a hypothetical question in a case.
Is it a possibility that
That would
someone
be, once again, that your counsel, the opposing team, is testifying instead of asking questions.
Could you rephrase the question?
Is it possible someone not on Prozac can be suicidal?
I mean, it could be possible that the doctor was wrong. Your doctor.
Yes or no, is it possible?
Can you hear? Can you?
We can hear you. We're just waiting.
It's possible that your doctor was wrong.
Is it possible, yes or no? Answer the question.
Objection. Actually, question asked and answered. Can you go on to?
I didn't hear an official answer, maybe because of the sound.
It's possible that the expert witness was wrong. You're wrong.
You are not answering my question.
Try to answer again. I couldn't hear you. B, it sounded like a question.
Go.
Well, yes, but that's a hypothetical question.
Thank you. In your affidavit, you said that a person's brain is not fully formed until around age 25. Until that time, poor decision-making and issues with self-control are prevalent. Is it possible that Jenny's actions and behaviour can be simply attributed to her poor decision-making, which is common in teens?
Hypothetical questions, and I'm answering based on what I feel.
You're an expert. 50% of your clients are teens.
Yes.
Is it all possible that Jenny Smith was not taking the medication prescribed to her, and that's in fact the reason why she became more aggressive?
Did you hear the question?
Can you repeat it?
Is it all possible that Jenny Smith was not taking the medication prescribed to her, and that's in fact the reason why she became more aggressive?
It's not the question whether she took Prozac. It is that whether it worked or not.
No, I'm asking the question. Is it all possible that Jenny Smith was not taking the medication prescribed to her, and that's in fact the reason why she became more aggressive?
I was in the process of answering the question and I was interrupted. May I restate my answer?
Well, if you're going to answer the question, yes.
Well, if you're going to answer the question, yes.
I was answering. Okay. Anyways, it's not whether she took Prozac or not. It is whether it actually worked or not. And in this case, it didn't work. It just made the problems worse.
How do we know she was taking it for it to work? Did you see her take it?
Objection, out of the scope. Please.
Objection. Say your objection one more time.
Objection, out of scope of the testimony. Please stick to the facts.
Sustained.
Is it possible that her actions were caused by coming off the Prozac as the side effects of coming off that are depression, anger, aggression, confusion, suicidal thoughts, mood swings, memory problems, and inability to concentrate, which could account for her not completing her schoolwork? So is it possible, given that in Jamie Manning's affidavit, she said her aunt was forcing her to go to the psychiatrist?
Objection, Your Honor. These are all hypothetical questions, and my witness is simply answering the facts of her affidavit, not what might have happened, but what did happen.
Sustained.
Well, ask. No further questions, Your Honor.
We'll be calling Jamie Manning.
Oh.
Please state your name.
Jamie Manning.
For the record, please tell the court your age.
I'm 15 years old.
How long have you known Jenny Smith?
Since kindergarten.
What type of relationship have you had with Jenny Smith?
Well, she's my best friend. We've done everything together.
What, if anything, happened to Jenny after her mother died?
She became very sad and she cried quite a bit.
What do you mean by change?
She began wearing darker clothes and becoming and crying a lot more.
Now, what concerns, if any, did your friends express to you about your friendship with Jenny?
I know that she talked to her aunt about taking her to a psychiatrist, and she told me that if Jenny's actions didn't change, then
what, if anything, did you tell Jenny about what your friends told you?
She hit me and then told me that she didn't need me anymore.
What did you tell your parents about this incident?
I didn't tell them anything about it because I knew it wasn't Jenny's fault.
What do you mean by was it her fault?
It wasn't Jenny anymore. I saw in her eyes it wasn't the same Jenny that I knew.
Your Honor, no further questions. I will pass the witness.
Okay.
Ms. Manning,
May I redirect?
how well did you know?
Sorry. Go ahead.
Ms. Manning, Ms. Manning, how well did you know Jenny's mom, Linda Smith?
Can you repeat the question?
How well did you know Jenny's mom, Linda Smith?
I knew her very well.
When did Jenny's mom, Linda, pass away?
In September of 2011. Well, May 31st, 2011.
Did Jenny's behavior change after her mum passed away?
Yes.
What about her father? Have you ever met him?
No, he's in jail.
How long was he there for?
Objection, Your Honor, relevance.
I'll allow the question. I want to hear the answer. Go ahead. Can you explain the relevance of the question?
We're trying to work out whether he had much of a role in her upbringing.
Okay.
He wasn't ever there. He was in jail.
What do you think about Jenny's guardian, Kara Smith?
All I know is that she's never really home. She's working all the time, and she doesn't.
So do you think she was a suitable guardian to Jenny at this point in her life?
Probably not.
Was Kara sympathetic towards Jenny regarding her situation?
Can you repeat the question?
Was Kara sympathetic towards Jenny regarding her situation?
Well, everyone was sympathetic towards Jenny. Her mom had just passed away.
Did you know Benjamin Netlow? Did you know Benjamin Netlow?
No.
So you
Sorry
didn't
to
know
interrupt. Can the witness lean towards the mic maybe a little bit more? Thanks.
So you didn't babysit Benjamin Netlow?
I did a few times.
Was he a well-behaved child?
Your Honor, objection, relevance.
Again, can you explain the relevance of the questioning?
We're just trying to understand the relationship between her and Benjamin Netlow and why he was killed.
Well, Your Honor, Jamie Manning is testifying over the mood changes and actions of Jenny Smith, not of her brother.
Okay, let's move on past the brother.
Why did Jenny's aunt send her to see a psychiatrist?
Because of the mood changes in Jenny, she was crying all the time and was just seemed very upset and sad.
Do you happen to know what medication was prescribed to Jenny in July of 2011 by her psychiatrist?
I believe it was Prozac.
What was that?
I believe it was Prozac.
How did this seem to affect Jenny's behavior?
She became a lot more sad and a lot more aggressive.
Sorry, what was that?
She became a lot more sad and much more aggressive.
How many times do you recall Jenny being sent to the principal's office?
Too many to count.
What was she sent there for?
Usually for fights or
Would you happen to know what his fights were caused over?
I believe they were just fights over nothing. It was just fights.
In November 2011, why did your parents tell you to stay away from Jenny? Could it be that her father was in jail for assault with a deadly weapon and your parents were afraid she might hurt you?
No, it was just
Could you please repeat that?
it was because of how aggressive she had become after she had began taking her medication.
What was Jenny's reaction when you told her your parents didn't want you to be around her anymore?
She pushed me, she hit me and told me that she was
Do you think that if you had told your parents or someone at school that Jenny hit you, then she could have got the help she desperately needed before it was too late?
No, she had already gotten in enough trouble for abuse towards other students. I wouldn't understand.
Yeah, but that was not her friend that she'd hit before.
But Jenny anymore either.
No further questions, Your Honour.
For our next and final witness, we will call Joanna Stabley, the counselor. For the record, please state your name.
My name is Joanna Stabley.
For the record, please tell us your occupation.
I'm a school counselor at Brookbend High School.
What is your educational background?
I have a bachelor's in psychology and a master's degree in counseling from the University of Texas.
When did you first become aware of Jenny Smith?
In the spring of 2011, Jenny Smith's mother, Linda Smith, called me up to tell me that she was in the end stages of breast cancer. She wanted to get some help for Jenny.
What, if anything, did you do at that time?
I investigated and talked to Jenny Smith. She seemed to be doing fine. Then her grades were excellent. She was very involved in clubs and school activities.
What, if anything, did you conclude from this investigation?
She was doing well, so I thought I would monitor what was going on. Her father was in jail, so when she lost her mother, I knew that her life completely changed.
Was not an investigator.
I'm sorry?
Objection, Your Honor. She is not an investigator.
Your Honor, she's a school counselor. She personally met up with Jenny and was personally asked by Jenny's mother to help Jenny.
I'll allow it.
All right. What, if anything, how did she do with her grades in the spring of 2011?
Her mother died on May 31st, 2011. She missed the last couple of days of school, but she had completed her finals and she received all the credits that you need for your freshman year.
When Jenny came back to school in the fall of 2011, when did you see her again?
I heard from Kara Smith that Jenny was seeing a psychiatrist and had been prescribed the drug Prozac for depression. Then I began to receive reports from Jenny's teachers that she was not completing her homework, barely passing her quizzes and tests, and had quit all of her clubs and activities. On September 22nd, 2011, I met with her, and she had turned in her homework for 2 weeks.
What, if anything, did you observe about Jenny Smith's behavior at that time?
She was very different from the first time we met. She now wore all black, and she was very quiet. Her demeanor was sullen and spoken very little. I put a note in her school file and mailed a note of concern to her guardian.
When was the next time you saw her?
That was on October 19, 2011.
What, if anything, did you observe about her during that meeting?
She had came into my office because she had shoved a student in the hallway and her hand was bleeding. Even though there are no witnesses, I was concerned in the apparent increase of violence. The guardian.
When did you see her next?
On November 15, 2011, Jenny came into my office because she was fighting with 2 other girls. They all had to go to the nurse's office. I attended the examination and saw that Jenny had around 300 self-inflicted scars on her body. She had also had multiple burn marks. It was the worst case of self-mutilation that I have ever seen as a licensed professional counselor. I told the principal that because of Jenny's obvious psychological issues stemming from her mother's death, Jenny shouldn't be expelled for fighting, but she should receive in-school suspension.
What, if anything, did Kara Smith say about Jenny Smith's behavior on November 15, 2011?
I called her by the phone and found out that she has never gotten my other 2 notes. I told her happening with and to Jenny.
What, if anything, came about this new visit of Jenny Smith to her psychiatrist?
On November 2008, 2011, I received a note from Jenny's doctor that Jenny's Prozac prescription had been changed to 40 milligrams per day. During the next 3 weeks before Christmas, she became more withdrawn and sullen and verbally aggressive. The rumors at school were all about her terrorizing several freshman girls when there were no faculty members around.
What, if anything, happened to Jenny during the Christmas holidays of 2011?
I learned later that Jenny Smith had been in the hospital for 2 days because she had taken a bottle of pills and tried to kill herself. I tried to visit her, but she refused to see me.
When did Jenny Smith first begin having trouble in school?
I've looked through all of her records, and she had never had any trouble until the fall of 2011.
No further questions. I'll pass the witness.
Ms. Debley, you had stated that you had noticed major changes in Jenny Smith's attitude. If her behaviour was so bad as you claimed in your affidavit, then why did you only see her 3 times, approximately a month apart each time?
Because I felt that it was only necessary to see her I didn't feel that it was necessary to see her until these things had happened. Of course, I was monitoring her behavior, And whenever it spiked up like it did in these 3 incidents, that's whenever I felt that I needed to go and talk to her.
But isn't it your job to be proactive where you can and act when required?
I'm sorry, can you repeat the question?
Isn't it your job to be proactive where you can and act when required?
Can you repeat the question? I'm sorry, it keeps breaking up at the beginning.
It's breaking up really bad. Just if you could repeat the question, she'll be glad to answer.
Isn't it your job to be proactive where you can and act when required?
And that's exactly what I did.
Did you genuinely care about the safety and well-being of Jenny Smith, or were you just ticking the boxes and saying you'd met her 3 times so you were doing your job?
Of course I cared about Jenny Smith. That's why I sent notes to her parents. That's why I met with Jenny every time I felt that it was necessary.
Her parents? What was that?
I said, I'm sorry, it was her guardian, Kara, not her parents.
Jenny Smith's psychiatrist did the right thing by informing you about her medication and records. When you noticed a change in behaviour, why did you not contact Jenny Smith's psychiatrist?
Well, that's why I had contacted her guardian, because I didn't feel that it was my place to contact the psychiatrist, but rather the guardian to inform the psychiatrist based on the guardian, what the guardian wanted.
But do you think if you had done this could have prevented the terrible tragedy?
Well, if I would have done this, I would have been going against Kara Smith and what her wishes may have been. It's also up to the guardian. I'm not the only one who has a say in what happens later.
The well-being is at risk, it is your duty.
If you thought that her well-being was at risk, then it's your duty. Correct?
You're implying that Prozac is the problem.
No.
No, I'm not. When you had no response from Jenny Smith's guardian, why didn't you take further action?
Because Jenny had never gotten in any trouble, and I didn't feel that it was serious whenever it was just a one-time event.
What do you mean any trouble? She was getting into fights all the time.
She had only gotten into 3 recorded fights. 3 fights that were on the record that someone could.
3 recorded fights? There were many more.
Proven, I'm sorry, which is what I said, proven, which is I saw her on every single occasion.
And yet not made physical contact.
And yet not made physical contact with the guardian.
I did the 3rd time, whenever I felt that it was necessary.
Maybe it was a bit too late. You noted that you realised Jenny was self-mutilating. Do you not think the information would have been vital to her therapist?
Can I answer your other question, please? Maybe it was a bit too late because of the Prozac. If the Prozac hadn't been doubled, then there wouldn't have been a too late.
Well, if you had communicated with her psychiatrist, then it may not have been.
If your psychiatrist wouldn't have overdosed her, then maybe this wouldn't have happened also.
According to Dr. Miles, it is not a high dosage for a person of her age.
It might not be. Well, every person is different, and you have to take it different on that person. And obviously, in this case, it wasn't working with the lower doses, so there's no point that it was.
And her psychiatrist saw her more times than you did.
Her psychiatrist also thought it would be a good idea to double the Prozac, which is obviously a bad idea.
She is more qualified than you. It is not in any of her medical records that a therapist was aware of her self-harm, despite it being something that was highly relevant. When Jenny Smith was first brought to you for shoving a girl in the locker, why didn't you take further action?
I did take further actions. I sent a note home to the guardian because this was the first time on record anything had happened. So this is when
Why was the phone call not made when the incident happened?
The phone call was not made because I didn't feel that it was necessary. Jenny Smith had never gotten into any trouble before until recently.
What, physical violence isn't necessary?
I'm sorry?
Physical violence isn't bad?
Well, again, this was her first time. I sent a note home and I felt that it was sufficient enough because I didn't think it was going to happen again since it hadn't happened in the past.
Physical violence is never acceptable. It is against the law.
Well, I mean, the double of Prozac wasn't acceptable either. It wasn't helping her. It was just making her worse.
That's your opinion.
Actually, it's facts, as you can see from Jenny's actions.
Well, to the psychiatrist, who is more qualified than you, it is not a high dosage for a person of her age.
Well, can you repeat your question? I'm sorry.
Never mind. Jenny clearly manipulates the truth and is well aware of her actions. You said in your affidavit that she was terrorizing certain freshman girls when no staff or faculty members were around. Does this not clearly show that she knows exactly what she is doing and when to do it in order to not receive any consequences?
Not at all. You can't see inside of Jenny's brain to show that she knew what she was doing. It said that she had terrorized freshman girls, but not that she did it knowing what she was doing.
But she did it at a certain time when no people are around to witness it.
This doesn't mean that she knows what she's doing.
But it happened multiple occasions.
It does not mean that she knows what she's doing. She's not in the right state of mind because your expert psychiatrist that is supposedly more qualified than me dosed her wrong.
Again, 2 expert psychiatrists outrank you.
But only one of the psychiatrists saw her, and the psychiatrist that saw her barely saw her. So I would beg to differ that both of the psychiatrists outrank me, rather that we are both experts, or all 3 of us are experts, so we're all equal.
The psychiatrist saw her more than you did.
I'm sorry?
The psychiatrist saw her more than you did.
But I definitely monitored her behavior more than the psychiatrist did. As
I only saw her 3 times a month. 3 times, approximately a month apart.
I did not monitor her behavior.
You did not monitor her behavior.
You cannot prove that I did not. I indeed monitored her behavior.
But it's in your affidavit that you saw her 3 times, approximately a month apart. Once in September, once in October, and once in November. Is that correct?
Objection, Your Honor. Question after. We've been going around in circles for a while now. Can they please ask another question?
Ms. Debley, how many years have you been in your type of role?
10.
In your years of experience, have you seen many children undergo many different changes through their puberty and teenage years?
I'm rather not testifying on whether this was Jenny's puberty or not, but it was rather the Prozac.
I'm not asking you that. Just answer the question. Yes or no?
I'm sorry, but that is out of the scope of my testimony, so I cannot answer it.
10 years experience.
You just said that she had 10 years experience.
Yes.
Anyone could answer this question.
My testimony is over Jenny Smith's behavior, not over my experience with every other case.
Or you testified as an expert witness.
Well, you testified as an expert witness.
I'm testifying as an expert witness to show that my expertise can see that the way that I examined Jenny Smith was correct in my expertise.
Isn't it normal for teenagers to suddenly change the way they dress, the way they act, for instance, wearing all black, especially when they're going through hormonal changes during adolescence?
Well, this one is, again, specific. I can't answer for all of my other cases, but for Jenny Smith, this was caused by the Prozac.
Again, your opinion.
No, it's my expertise. Like you said, I'm testifying as an expert witness, and that is my expertise over this examination.
Is it possible that Jenny wasn't actually taking the Prozac in the first place, and that could be the reason there was no positive change in her behaviour?
It's not what I'm testifying. I'm testifying that the Prozac...
But this is a question I'm asking you. And you said you were monitoring her.
Of course I was monitoring her. And I can't answer a hypothetical. Again, I'm an expert witness that should be answering...
It's not a hypothetical question. Is it possible that she wasn't actually taking the Prozac in the first place?
Is it possible means that anything is a hypothetical. Is it possible?
Did you actually see her take the medication in the first place?
That's not a hypothetical.
That's not a hypothetical question.
That's not what my testimony is about.
I'm asking you.
So once
Well, I'm
again-
asking you now.
Well, once again, it is out of my testimony and I cannot answer it.
This is being argumentative.
Your Honor, the witness has been argumentative. Can you get her to answer my question, please?
Your Honor, the opposing counsel is clearly not stopping to ask hypothetical questions. To be asking characters.
Your Honor, your microphone is muted.
Sorry about that. I thought I heard the other counsel speaking. I do feel like we're going a bit in circles, so I would like to see if we maybe can rephrase and close up the question.
Did you see Jenny take a Prozac?
Again.
Yes or no?
Again, that is not in my testimony and I cannot answer that question.
Is it possible that instead of Prozac being the cause of aggression that you say Jenny Smith had, that she was actually going through the 5 stages of grief?
My testimony is simply over facts, not hypotheticals.
You monitored her. You should know this about her. This is not hypothetical.
Asking questions. And in this case, she keeps asking hypothetical questions. I thought we could do this.
I need the other counsel to speak up.
Your Honor,
Or
the opposing counsel keeps asking hypothetical questions and forcing my witness to try and answer a hypothetical question that is out of the scope of character.
sustained.
No further questions, Your Honor.
Your Honor, is it our closing now?
I believe so.
Your Honor, throughout the trial, we have presented you the evidence and information that shows Jenny Smith pre-planned the murder of Benjamin Netlow and displayed clear intentions to commit this crime again. We have proved to you that Prozac couldn't have been the cause, and even whilst taking the drug, Jenny retained full mental capacity and control of her actions and willingly killed Benjamin Netlow. If Jenny isn't made to feel the full weight of her actions, then she will not understand the severity of what she has done and will be likely to do it again. It is clear that she had the intentions to commit this crime again, as she had already commenced the planning of a second murder after she killed Benjamin Netlow, as seen in her diary. Jenny Smith must not be seen as mentally incapable of committing such a crime when there is no evidence to prove Prozac is linked between acts of violence, including murder. The death of Benjamin Netlow was thought out, premeditated and deliberate, as Jenny had engaged in pre-planning 6 days prior to the murder and had dug 2 graves, not just one. Jenny, at any time, could have reconsidered her actions and instead could have decided not to commit this crime on an unsuspecting child of 7 years. What you need to ask yourself is, are you willing to let Jenny Smith out into the community only for her to turn around and kill another innocent victim, like she's expressed the desire to do so? Jenny must be dealt with as any other offender with clear criminal intent, and Prozac must not be used as an excuse for her actions. Thank you, Your Honor.
Your Honor, I stand here to explain that there are instances to both Jenny Smith not guilty. First, I'd like to address that their expert on police procedures clearly said that the information obtained from the custodial interrogation was illegal, as they admitted that they had not read my client their rights until after the interrogation was over. Now, consider Dr. O'Reilly's testimony. Note that Prozac was outlawed in Canada and carries a warning in the United States for aggressive and self-mutating behaviors in teenagers. These warning signs alone make it first-degree murder impossible to prove. A case is clearly made that she was not in her right frame of mind. You cannot have a premeditated crime under these conditions. Second, consider Dr. O'Reilly's testimony that Jenny Smith was diagnosed both with bipolar disorder and she was manic depressed.
Both of these conditions result in wild mood swings, and then add something like Prozac on top of that, and the results will only be magnified, not diminished. These were diagnosed on one visit, even though they should take several visits to actually be diagnosed. Doubling the dose and then the side effects of going without the double medicine can cause this behavior change. Now, third, consider Joanna Stapley's testimony. She noticed and documented Jenny Smith's behavior before and after November 15th visit, when she saw the 300 scars of self-mutilation along with the burn marks. These are signs of suicide and fit into the warning of Prozac. Now, fourth, consider Jamie Hack's testimony, when she stated that Jenny Smith physically attacked her in November 2011. Compare the relationship pre and post-Prozac. You can see the documented changes in Jenny's behavior. All of these behaviors fully support the concept that Jenny Smith was not physically or mentally stable, and her condition was magnified by doubling Prozac. Fifth, consider that the police report and note that the Berkman police called for juvenile officers to sit on the interrogation of her client only after the body was found, and Jenny Smith had been talking to the police without her Miranda rights being explained, which the prosecution's expert witness has also added on to that, indeed all of the information was illegal, making all evidence inadmissible in court today. Now, Your Honor, we stand here because the police must follow the laws of Texas, and they should rule the laws as they were based on. They cannot short circuit or go around the law simply because they are trying to solve a crime. You cannot break the law to uphold it. If this were the case, the police would become criminals themselves. Their job is to protect and serve, not to do anything in their power to abuse the rights of our citizens. 8, the prosecution has taken an oath to uphold the laws of Texas, and their team must do so in the prosecution of this case. They must convict their client through credible, legally obtained evidence and through good police work, and clearly even the expert agrees that this is not the case. We've shown you time after time today that this is simply not the case. Your Honor, we stand here today because Jenny Smith is a victim. We have proved throughout the course of this trial that Jenny Smith is not only a threat to others but to herself. 300 marks of self-incised mutilation and burn marks along with attempted suicide throughout the course of a year. All of these took place after the first visit with Dr. Merrick on July 25th of 2011, when she was introduced to the drug Prozac. Jenny Smith is a victim. Jenny Smith had to encounter many traumas that children shouldn't go through in her young life. Her father's in jail, her mother is dead, and her aunt is hardly ever there for her. It is the government's job to ensure the well-being of all of its citizens. All Jenny needs is proper help. If convicted of murder, the government will fail Jenny Smith. What type of society do we want? What type of society do we aspire to be? We pray that you consider the circumstances and facts involved in this case. Clearly, Jenny Smith was not given her rights. This was used against her, and just as clear is the fact that Jenny Smith was not in her right state of mind. Both not guilty. Thank you, Your Honor.
All right, it's a tough one, so I have to think for a little bit, and I'll be back with a verdict. Okay. Do I have to choose? No. Well, I hope it's okay to break a little bit of character. I'm obviously volunteering today, and you guys all did a great job. It's tough to go either way because I think on one hand, it does sound like the Miranda rights weren't read in a timely manner, so that there's that. But I also don't think there's full proof that Prozac was the cause per se. So this is tough. I don't know. If it was me, if I was like, this was like real life, right? I think I would lean towards some sort of a I would want her to get help in like a, mental institution versus going to jail.
Okay.
I guess I'm saying not guilty. I'm really sorry. I don't know what to say. I think that like I said, there wasn't full proof that Prozac was the reason at all, because obviously lots of things are going on with her. But I also think I might have wanted a little bit more evidence in the like premeditation and that kind of thing. So I think everybody did a great job. And honestly, if it could be a tie, that'd be my perfect world.
Okay.
Is that okay?
Fine. Okay, we thank you so much, Aaron, and we thank you, Findon. You guys did a marvelous job once again, and we surely appreciate it. And from our end, because most all the kids have to go home, we do truly appreciate. One of the things we do is we do Australian cases and we do United States cases too. So this is a little bit. And it's always been weird that we do better in Australia than we do with our own cases, and they do better in American cases than we do. So,
Australia, y'all brought it. Like, that was like awesome. Seriously. And both teams totally got it. I think the sound was obviously a barrier for everybody. So that was really tough. I think some questions got like more heated when it was just like, but I can't hear you, you know? So, everybody did really, really great. And can it be a hung jury? Is that okay?
Okay. To go back, Aaron, to prove premeditated murder, I think you were succinct in the first place. They have to show premeditation. And the only way they could show premeditation is to use the evidence that they could not legally use under Miranda and under J.D.B. Miller and some other cases that they could cite. It's the problem. I think you could end up doing something for less, but you couldn't hardly get first-degree murder. It's going to be a problem the way it's going today. But we're going to have to go because everybody has to leave on our end. And I know they have to go to class sometime in the morning in Australia. So we really do appreciate this. This was a lot of fun. I do have one other thing we might want, if you could do later. The people from the Virgin Islands have sent us this really cool case on the 14th Amendment. And it has to do with marriage of same-sex partners in a territory. And they're saying that the territory laws aren't necessarily the same as federal laws, and federal laws don't partake. So it hits a lot of boxes. So we're going to try to do something with that later on. But we appreciate this so much, and I'll be talking with you guys in Findon, okay? Thank you.
Thanks,
Thank you all.
Bye. Thank you.
Thank you.
Great job.
Let's start now. So before we start, I will introduce my vice principal. So
Hello, good morning.
Hello, how are you doing?
It's okay. I'm very sorry. So right now, we have a faculty meeting, and then I'm just go down here.
Oh, we appreciate that you came. This is so wonderful. We're having a parent meeting here, and we're talking to parents and students all at the same time. So this is a fun part for us too. I was telling your teachers how excited we are having your school involved. It's really a nice privilege.
Okay, I'm also happy to meet you and your school and our schools to be connected through the internet. Yeah, even though this is the internet, but the students and behind me, there are a lot of students prepared for this class.
Oh yeah, it's wonderful. Tell us a little bit about your school and how long you've been there.
Excuse me, I'm very sorry.
Sorry. Excuse me. I'm sorry. How long have you been at your school as a position, assistant principal, and tell us a little bit about your school?
Actually, I have been teaching since 1994. So I have been teaching almost for 20 years. Yes, and then for vice principal, yes, 5 years. Sorry, so we have a connection problem, so
No,
we
no,
can
you-
find.
Okay, yeah, that's really good. I just had to unmute a second because we had some parents talking in the background.
Hello?
Okay, yeah, we're here. We're still hearing you. Why is it not showing up there? Oh, okay, keep on talking.
Hello?
Hi.
Yeah, maybe this is our school's problem, not yours problem. Yes, now I can hear you clearly.
That's good. So I was wondering, is your school like an all girls school?
Yeah, that's right. Our school is all girls high school. And yes, that's right. And then our school, okay, so it started from 1961. Hello?
Yeah, we can
Yeah, let me
still,
introduce our,
keep on going.
yeah, let me introduce our school very briefly.
Marcos, here's some parents are coming for you.
Okay. Oh, yes. Our school started from 1961.
Mm-hmm.
And our school is a whole girls high school. Actually, this school is a vocational high school, but students have to graduate from this school. Half of students go to college, half of students go to work.
Oh, wow.
Yes, that's right.
So I was, what was it? Emperor of Go. Okay, tell us a little bit about the tracking system. What's the difference between the vocational school and the traditional high school in Korea? Get that? No.
Yes, we usually say there are two different types of high school in Korea right now. Yeah, we usually say common high school and specialized high school. In our school case, it's specialized high school. The big difference between two school systems is the curriculum.
Okay, the curriculum.
Yeah, curriculums. Our students study half of their curriculum follow just the common high school, like Korean language, math, science, and the sociology. And half of their curriculum, like a computer science, the English language, accounting.
Wow.
And yes, international meetings. Yeah, that's right.
Wow,
So,
and
yeah.
what is your school noted for? What are you what do you emphasize? What type of study?
Yeah, that's right. Our school emphasized on educating the student, the ability for presentation based on language, especially Korean and English.
Wow, that's very impressive. So you have the best English teachers in the country then, right?
Actually, not. I'm not. So 4 years ago, yeah, yes, I don't teach anymore. So I just the vice principal and I manage the school. Former, I was an English teacher, but still.
Oh, I can tell. I can tell.
But still, I'm missing my class.
Oh,
Yes.
yeah. I can tell that too. You have a real love for education.
Yeah, I like my student. I liked my classes. Still, yes, I really wanted to back to be a teacher, not a manager.
Yeah, yeah, I know what you mean. I was a principal for 9 years and then got back into teaching about 15 years ago. I'd much rather teach than I would be a principal. But more power to people like yourself that are leading schools. That's very good.
Yes, but I think this is. I'd like to say one more time. It's very nice talking to you and nice meeting you. And so I have to go up to the faculty meeting right now.
Okay, I understand. I know you can't be with us all day. I appreciate that, though.
Okay, next time if I can find a chance again, I'm gonna talk with you and your school teachers.
Yeah. Okay. Yeah. We'll do it next month again. We'll talk more to you. Okay.
Okay, thank you very much. Behind you, so I can find the 4 Korean flags. Oh, yeah. We say Korean flag name is 태극기. 태극기.
Oh, say that.
What is it? Say it again.
태극기 in Koreans. Our Korean flag's name in Korean 태극기. Sorry, sir. Yeah, maybe our English teacher explain you more about that.
Okay. Thank you so much.
Okay, see you. Thank you.
예, 다 보입니다. 네.
안 보이네.
Oh no, that is so cute. I always wonder why people do that. Jasmine and I were talking about, we see a lot on Korean dramas, and I didn't know people actually really did that, but that's really good.
Okay. Okay, so let's start the conversation today. Before we start, please speak slowly. Okay? Yes. Thank you. Thank you.
You're welcome. Thank you. We'll speak slowly.
Yeah. Okay. Let's talk about Korean dramas first. So please give us your question.
Okay. The first question would be, how can you learn about customs and manners through TV?
Okay. 화면에 보고 너네가 서 있게 그냥 말하면 돼.
I'm second grade. Hi. I'm second grade Cho Moon-young. Hello, I'm second grade Cho Hae-yun.
Are you hearing?
Can you speak a little bit louder, please?
Okay, sure.
Once you get there, you're stuck for the whole time.
And we will start the answer. Again. We'll start again. Hi. I'm second grade Cho Moon-young and
Hello, I'm second grade Cho Hae-yun.
And we'll start the first question. What can you learn from 2 dramas, You Are Surrounded and City Hunter, is 권선징악 and 인과보호 in Korean?
To define 권선징악 is to encourage a good deed and punish a bad deed. For a representative example, Yoo Moon-bae, who commits the crime in the drama You're Surrounded, has been disciplined for his bad deed so that he could be punished by the law. The drama also shows 권선징악 at the end, in which main characters who worked hard on disclosing Yoo Moon-bae's guilty to punish him solved the events and they had a happy ending.
And I will explain 인과응보. 인과응보 means that good behavior brings good result and bad behavior brings bad result. Moreover, it showed 인과응보 as a main character with a good behavior received a good result. After all, through the dramas, we can learn 권선징악 and 인과보호, which are written often in Korean lectures from all times. And this finish. Next question, please.
Okay. The second question would be, how important is revenge in Korea?
Come over here and take this picture.
Hello, I'm Heejin. I'm him. Nice to meet you. We are freshmen. Okay, let's start. Revenge is a very important factor in Korean dramas. Korean dramas, most of them have revenge because the dramatic source of revenge arouses Korean viewers' interest. Also today it becomes Korean drama's characteristics. Thank you.
People commonly get vicarious satisfaction through revenge in dramas, which they cannot feel in real life. I think it builds positive suspense because they look forward to watching the next content.
Thank you.
And please give us next question.
Okay, the third question would be how popular the Korean dramas are here in the US.
앉아서 할까요? 앉아서 화면에 잘 보이게. 앉아서 저거 이게 더 낫다. 앉아서 마이크를 잡고 마이크요? 여기 마이크.
아.
여기 화면 보시.
이제 너 좀만 저로 가봐.
알겠어.
해.
너무 어렵게 나와.
네. 하나, 둘, 셋.
Hello. Hi, my name is Lee Sujin.
Hi, my name is Kim Sayan. We are third
third
grade
grade.
and we are same
Same
class.
class.
Oh. I will answer it. That's recently movie streaming website has increased highly. Story is very fun. An American may feel
discharged with the use of a motor vehicle without the consent. We, the prosecution, will probe beyond reasonable doubt that the defendant took the vehicle without the owner's consent. The vehicle is the meaning of conveyance. The defendant took the vehicle and drove it for the purpose of driving. The defendant not only took the utility, but intended to do so, and has admissions as to taking the ute. We will call two witnesses, a police officer who will confirm the admission by the defendant, probationary constable Michaels, and the victim, Abby Blackett, who will confirm that the defendant attempted to take the vehicle. Section 86A of the Criminal Law Consolidation Act established that it is an offense to drive, use, or interfere with the motor vehicle without first obtaining the consent of the owner. Further, that driving includes any activity that can exert control over the vehicle or conveyance. Your Honor, can I refer to Reg versus Roberts per Lord CJ at page 88 in that the state of authorities, I think the only sensible course for the court is to consider the matter afresh. The defendant could operate the brakes, indicators, warning signs, steering, and lights. In my opinion, he also had something to do with the movement and propulsion, in that he was managing a vehicle. I think the defendant was driving in the ordinary sense of the word. I think, moreover, that an examination of the relevant legislation supports the view, and he was driving the vehicle with the meaning of the Road Traffic Act 1961 as amended. The defendant had a considerable measure of control over the vehicle, and careless or unskilled exercise of that control could constitute a danger to other road users. It seemed likely to me that the legislature intended that a person in that position should be required to avoid infringement of statutory rules of the road so far as it is in his power to do so, and in particular should be sober, give appropriate signals, and ensure that the vehicle is properly lighted. I think the Road Traffic Act and the Motor Vehicles Act are so linked that the word drive in the Motor Vehicles Act 1959 as amended must have the same meaning as in the Road Traffic Act. The person at the wheel of the towed vehicle would surely be expected to have passed the necessary test to qualify for a driver's license pursuant to Part 3 of the Motor Vehicles Act. Thank you, Your Honor.
Thank you. Are you ready to call your first witness?
Yes.
Okay.
We call probationary constable Michaels. Could you please state your name and occupation?
Probationary Constable George Michaels.
How long have you been a police officer?
For 15 months.
Is there anything that happens at 15 months?
I would no longer be called probationary, but then I'd become a normal constable,
What duties do you perform?
the same as a normal constable.
Where were you on 26 November 2015?
During the day, I was home, then started my shift at 7,
At which police station was this?
the Norwood Police Station.
Do you recall any incidents or phone calls?
Yes, I recall 2. There was a man regarding an accident and another regarding attempted theft of Mrs. Blackett's ute.
What happened as a result of the phone call?
I told Mrs. Blackett that I couldn't leave the police station. I would tell Sergeant Cox when he returned.
Did Miss Blackett see the person?
Yes, it was Angela Crossier.
How did she know it was Angelo?
She said Angela used to work from her from time to time, and he shouted at her, and she could recognize her from his voice.
Did you wait until Sergeant Cox came in to fill him on the incident?
No, as we had no one in the cells at the time, and it was very quiet, so I stepped out on the street and saw 2 youths walking towards me. That matched the description given by Mrs. Blackett.
What did you do then?
I would have walked less than 200 meters from the police station to ask the boy his name.
What did he say?
He said his name was Angelo Crossier.
What happened next?
I asked him if he could come to the police station with me.
Did he agree?
He said okay.
Did you notice anything particular about him?
He was sweating heavily and a bit red in the face.
Earlier you said you noticed 2 youths in the street. Who was the other youth with Angelo Crossio?
Terry Green.
Did she appear to be ready and sweaty in face?
No.
What happened when you went inside the police station?
Someone had walked in to report an accident. I asked the man to take a seat and I'd be with him in a second.
Can you tell what happened next?
I asked Angelo if he had taken Abby Blackett's ute, and Abby Blackett had seen him running away and that identified him by his voice.
What was Angelo's response?
He denied it and said he was only 18.
Had you informed Angelo of his rights?
Yes.
What happened next?
I told him if he admitted to taking the ute, he would be let out on bail. But if he didn't, he'd have to stay in the cells until tomorrow.
What did he say to that?
He said, all you can do, he said all he wanted to do was go to a party and then he would confess to writing a statement and stuff.
Did he write the statement?
Yes, he did, and signed it.
Did you notice anything else peculiar?
Terry Green had said not to worry about the party as I couldn't get a car there anyway.
And why do you think that was peculiar?
It made me wonder whether Angelo tried taking the car to get them to the party.
No further questions, Your Honor.
Thank you. All right, does the defence have any questions of this witness?
Constable Michaels, you received a phone call from Abby Blackett not at 7 as he said, but at 8:15, correct?
Yes.
Your superior officer had told you earlier on November 26, 2015 to not leave the station, correct?
Sorry, we can't actually hear your questioning. There's a little bit of a delay. So if you could speak a little bit louder and a little bit slower. Sorry, we didn't hear that.
Very quiet area too.
You never went to investigate the crime scene on November 26th, did you?
No.
You took all of complaint that Mr. Blackett told you to be true, correct?
Yes.
You never investigated, correct?
Correct.
You got a confession before actually, and you never did an investigation, correct?
Can you please repeat the question?
You got a confession before.
You just speak in the microphone. You just speak directly into the microphone. Just move across a little bit and speak directly into the microphone.
You got a statement before ever commencing an investigation, correct?
Sorry, Miss Defence Counsel, if you just move yourself to your right and speak directly into the microphone.
Okay.
Go ahead. You obtained a statement before ever investigating, correct?
I talked to both people involved.
However, you did not investigate the crime scene, correct?
Correct.
Is this proper police procedure, yes or no?
I did it the next morning.
According to the law, an investigation must commence when an incident is reported, correct?
That's why I spoke to the accused.
You took Albie Blackett's statement and never investigated, correct?
The next day we did.
No further questions.
All right. Excuse me a moment. Yes. Do you want to ask any questions about or the fact that he confessed because he said he had to go to a party and didn't want to stay in custody? Mr. Betts, do you want to ask any questions about that?
No, did you ever investigate if there was a party out of town?
Yes, Terry said there was.
But Constable, you never went and did any further investigation other than what Terry said?
No, Your Honour.
All right. Okay.
In other words, you never investigated, correct?
Correct.
All right, thank you, Mr. Defence. Okay, is there any re-examination by the prosecution?
Yes, Your Honor.
Okay, thank you.
One moment, Your Honor. Probationary Constable Michaels, did you have any reason to doubt that there was a party?
No.
No further questions, Your Honor.
All right, thank you. You may stand down, Constable.
Thank you, Your Honour.
And now the next witness. Are you ready to call the next witness?
Next we call Abby Blackett. Next we call Abby Blackett.
Thank you.
Yes. Could you please state your name and occupation? Could you please state your name and occupation?
My name is Abby Blackett and I am a self-employed plumber.
Where were you on the night of 26 November 2015?
At home.
Where was your utility parked?
Just in the entrance to the drive.
Where were you before that?
At a job fixing a burst sewer.
What time did you get home?
My written statement said about 6:30 p.m, but I have since realised that all the times in my statement are an hour too early than the actual time.
Why is this?
My husband and I had just returned from an overseas trip the day before, Friday the 25th, and I hadn't realised that daylight savings had finished whilst we were away.
Why were you working so late at night given it was a Saturday?
We had been away for over a month and I had put off a few jobs until we returned and because they were urgent jobs for the clients at the time.
Did you have another job to go to?
Yes, my husband had rang and told me someone else had an urgent job.
Why did you go home first then?
I had broken my glasses at the previous job and wanted to get my spare pair.
Why do you need glasses?
Some of the work I do has attention to fine detail and I need them for up close stuff as I have pretty good long distance eyesight.
Did you do anything else at home?
I took a shower and had a quick meal.
Why did you take a shower if it was an urgent job?
The previous job required me to work on a burst sewer. I don't know about you, but if you have ever been near one, they smell absolutely disgusting and so did I.
What happened after your shower?
I had just finished my meal when my husband said he heard a noise in the driveway. I then heard a noise that sounded like my car was starting.
What time was this?
Again, my statement said about 7 p.m, which was actually 8 p.m.
And what did you do?
I ran outside and saw my ute backing across the footpath into the roadway. I shouted, "Hey, hey, stop," as I ran down the driveway.
And what happened then?
It stalled and the driver's door opened and I saw a man get out and run away.
What were they wearing?
He was wearing black jeans and a yellow top.
Where were you when he ran off?
Halfway down the driveway.
Did you recognize the person?
It was Angelo Crossio.
How do you know this?
As I shouted out for him to stop, he shouted back, "Give up, old woman, give up."
How do you know it was his voice?
He is unemployed and does work for me from time to time.
What happened then?
I drove the ute back up the driveway and I went inside and rang the Nord police station.
Who did you speak to?
Probationary Constable Michaels, and told him what happened.
When did Probationary Constable Michaels take your statement?
The next morning.
Why did he wait until the next morning?
I was tired and emotional and I still had to go to another job, an urgent job.
Did Probationary Constable Michaels tell you that someone had been charged with taking and using your utility?
Yes, he did. He said it was Angelo Crossio.
No further questions, Your Honour.
Thank you.
Now, Ms. Blackett,
Now, defense.
Ms. Blackett, it was your testimony that you had 2 drinks with your mates, correct?
Sorry, can you repeat the question?
It was your testimony that you had 2 drinks with your mates, correct?
Earlier in the day, yes.
It was your testimony that you broke your glasses, correct?
Yes.
It was your testimony that you drove home to pick up a spare pair of glasses because your wife called saying you had another job to do that evening, correct?
Correct.
Now, it was your testimony that you showered, got something to eat, plus drank 2 more beers before you called the police, correct?
Yes.
You called the police shortly after the event happened around 7, according to your testimony, correct?
No, as I said before, it was actually 8 o'clock because of daylight savings.
Really? That's not on your testimony. So, are you lying according to your testimony?
No, I just spoke about that and cleared it up.
So
The prosecutor just asked me about that question.
So you're admitting that you misspoke, correct?
No, in my statement I had explained that I hadn't realised daylight savings had finished whilst I was away. And in my statement and in the questions that I was just asked, I cleared that up.
So this is a bit confusing. So you're trying to say that your statement is wrong? So your testimony is wrong, correct?
Yes. It's an hour out.
It's, I know. Now, when you called the police station, you talked to Probationary Constable Michaels, correct?
Correct.
And you told them, you informed him about the theft, correct?
Correct. I was very emotional.
Yeah, Ms. Blackett, did anyone come to your house and investigate this incident that evening of November 26, 2015?
The next morning.
Now, did anyone come to your house and investigate this incident in the evening of November 26th before 9:30? Yes or no?
No.
Now, Ms. Blackett, it occurred in your testimony in this courtroom today that Angelo Crocio was arrested for the use of a ute before the police even investigate the crime scene at your house, correct?
Sorry, we couldn't hear that one.
So it is your testimony before this courtroom today that Mr. Angelo Crocio was arrested for the use of a ute before the police even investigated the crime scene, correct?
He committed to it. He signed a statement.
A statement to a crime scene that was never investigated, correct?
Well, when they admit to it, yes.
No, yes. So a crime scene that was never investigated, correct?
The next morning it was.
However, before 9:30, he was arrested for committing.
No.
No. So you lied before?
No, I said it was the next day.
However, you do understand that under police procedures, an investigation must have happened after the incident, correct? Especially if you call.
Yes.
It did not happen.
Angelo said he did it and signed a statement.
Full investigation, correct?
I'm sorry, but I'm not the police officer.
However, you are the person that's supposed to be so affected by this, correct?
Yes, but I don't know the police rules.
Investigating the crime scene, correct?
Sorry, could you repeat the question?
So they took your word without investigating the crime scene, correct?
The next morning.
However, again, I'm going to repeat myself, and going back to your previous answer, you clearly understand that under police procedures, an investigation must happen right after the incident, especially if you make that call, correct?
I'm not aware of all the procedures. I do not know the police laws. I wouldn't know this.
Okay, thank you. Now, according to your testimony, you had 4 beers before the event, correct?
Some ciders, but yes, my first drink was at 12 p.m. and it would have worn off.
No. I don't know if you're aware, however, the alcohol runs in the blood.
Sorry, I can't hear you.
Okay, according to your testimony, you parked your ute under the light at the end of your driveway, correct?
Yes.
Now, according to the events of November 26, 2015, your ute was parked in your driveway after 7 p.m., correct?
Just outside the driveway.
Ms. Walker, what side of which side of the gate is your light on? It's on the outside, correct?
The driver's side, it's on.
I'm asking about the light. Where is it on? Which side of the gate is it on? It's on the outside, correct?
The driver's side.
All right. Now, Mr. Blackett, would it surprise you if we told you that we sent an investigator to your house and we noticed that the lighting question was outside of your gate?
There's a light outside the front door.
And the gate.
As all houses.
Correct?
Yes. Yes.
Your ute is 17.54 feet long, correct?
Can't hear what you're saying, sorry.
So, according to your specifications, your ute is 17.54 feet long, correct?
I have no idea, sorry.
So you don't know your car?
No, not many people do.
All right. Now,
All I know is that it's a ute and I drive it to work and it's very handy.
underneath the driver's light, correct? Meaning that you would have gotten off at the light, correct?
I'm not quite sure what your question is and I can't hear too well.
All right. So if you parked your car.
We're just having trouble at this end.
Excuse me for a minute.
We're having trouble this end. Although it might be unnatural, if you just speak a little bit slower, the connection might be better.
And you have to probably speak really close to that microphone.
So parked your car in front of the light. So that would have mean that you got off the car at the light, correct?
I don't understand your question. Could you reword it, please?
Very Let me reword. So therefore, meaning that the utility vehicle had the back behind the light, correct?
What do you mean that there's a light at the back?
There's a light on your gate, and it's been established. You've been answering that there's a light outside your gate. Therefore, meaning that if you parked.
No, there's a street light and there's a light at my front door.
That's not what you answered. Would you like to restate?
Sorry, we were confused by your questions.
According to your testimony, you parked by a light by your gate. So you lied in your testimony?
Sorry, could you repeat that?
Okay. Well, according to your testimony, you parked by a light by the gate. So are you saying that you lied in your testimony?
I said that there's a street light.
No, that's not what it was stated in your testimony. Your testimony clearly states that you parked outside near a light of your gate. Are you saying you lied in your testimony?
No, which is a street light.
However, you specifically established in your testimony that there was a light on your gate. And you agreed to it various times. Look, if there was a record.
Sorry, I couldn't hear that last part.
Oh, for goodness.
The light at the front gate, that which I was referring to, was the street light.
Okay, I think that's time. Thank you. All right, so they're the only two witnesses for the prosecution.
Yes, Your Honor.
Okay, thank you. So is that your case for the prosecution?
Yes, Your Honor.
All right, I'll now hear from the defence and see if they want to do an opening statement or opening address.
Yes, we'll do an opening. Your Honor, this is a case of mere conjecture, magic, and basically bad mistaken identification. We would at this time like to review these statements of the Crown. On or about November 26, 2015, at Norwood, in the state of South Australia, defendant Mr. Crocio did use a motor vehicle, namely a folding utility, HR 083, without consent of the owner, Albie Black. This use is not a violation of Section 44A of the Road Traffic Act, as Mr. Crocio did. 1. Operate without the consent of the owner, only to benefit the owner. 2. He parked the ute in the driveway. 3. And did so for the purpose of Blackett, not for the purpose of driving it. Your Honor, here is the mistaken identification. My client on an automobile that was parked half in the street, half in the driveway, in the pathway. He started the car to move it up into the driveway for Mr. Blackett. He was not taking Mr. Blackett. He was helping Mr. Blackett. Mr. Blackett had been drinking at least 4 beers by his count and was not wearing his glasses. He cannot visually identify my client, and the police never investigated the crime scene. This means all of the evidence in this trial are the words of an impaired person, Mr. Blackett. We will provide a witness, Angelo Crocio, who will testify he was walking home to make sure his mother's seatbelt was off. On the way to his mother's, he passed by Albie's house. He noticed that Blackett had parked his ute outside his front gate and was pushing on the street. He looked inside the ute and noticed that the keys were still in the ignition. So he jumped into the car and moved the ute up on his driveway for him. He was moving you forward when Blackett came out of the house. Curcio will testify he stopped the car, got out, and told Mr. Blackett to be quiet. Mr. Blackett approached him, yelling, apparently drunk but and without his glasses, not wanting a confrontation in the front lawn. Angelo Curcio left the U parked in the driveway and went on. You may hear from the crowd that it is an open and shut case, and we couldn't agree more. An open and shut case of police overreach, overcharge, and breakdown of individual rights because of mistaken identity, that the client is innocent and that they're being voted simply because they were in the location. We ask you to ground claims against that. Curcio signed a confession that the police provided to him. He did so because he was told he could have it. This was done by a probationary constable that never investigated the crime scene first. That told the testimony of an impaired person over the phone and detained the first person she saw with a yellow shirt on him as the criminal. Mr. Curcio drove the car, but he drove the car into the driveway, not to help Blackett. There are no facts submitted in evidence to the contrary, and the witness statement of a gentleman who had been drinking and did not have his on is not a reliable witness. Cross-apply the Cheesing case. On April 12, 1985, the South Australian Court of Criminal Appeal unanimously upheld an appeal by Raymond John Cheesing. The South Australian Chief Justice ruled that the Cheesing's 1983 trial had miscarried and the verdict for the murder and abduction of Louis Bell must be set aside. Chief Justice King said the prisoner informants were unreliable and untrustworthy witnesses. This also applies to our case considering the amount Mr. Blackett had earned, as well as the fact he did not have his glasses on. 1. Mr. Curcio is an honest man, much more honest than the police. He admitted to driving the car to the driveway. The police wouldn't listen to his side of the story. They have twisted it all around to the story on the man without his glasses on who had been drinking. Who do you believe for? He had been drinking on the job, came home to get his glasses, was allegedly in a hurry to find his glasses, parked quickly, and then when he got home, began to drink some more, or my client. Keep following facts. Curcio identified at the scene by a man drinking and did not have to. 2. Taking control of the vehicle with the purpose of taking people into the driveway to get the car off the street. By doing this, the person did not meet all the Section 44A Motor Vehicle Act, as well as meeting the definition of breaking Criminal Law Consolidated Act 1935, 86A, using motor vehicle without who, on a road or elsewhere, drives, uses, or interferes with the motor vehicle without first obtaining the consent of the owner of the vehicle, guilty of an offense. By driving the vehicle into the driveway, now, are we going to have a law punishment? I would suggest not. Please classify Criminal Law Consolidation Act 1935's consent of owner. 1. The reference of the consent of the owner of property extends to A, the implied consent of the owner or owners. 2. The person is to have the implied consent of another if the person honestly, from the words or conduct of the other, that he or she has the other consent. The consent of the owner takes place here because 1. The keys were left in the ignition. 2. The U was parked radically in the street and the driveway. And 3. Angelo Curcio had done part-time work for Mr. Blackett. Wanted to simply lost. Curcio signed a confession that he drove the car because he drove the car into the driveway. He signed a statement that George Michaels wrote up for him. Why would Curcio write up for him? He was a fair cop. Remember in R versus Phillips, it was established that he is presumed to be innocent until proven guilty, and he provides the benefit of every legal doubt that is raised in this case. With the evidence that we present and the questions that we bring up about the Crown's case, you will see that the only thing left here is the vote. To vote my client, Mr. Curcio, not guilty of the motor vehicle without the consent of the owner. Thank you. We call our first witness.
Thank you.
Terry.
Thank you.
state your name? Mary Green. What is your occupation? A student of what if anything you know that I was with Angela Prost and other friends at the conference. Who told you that there was going to be a party out of town? Who is the person who told Crucio that Do Re Mi was playing at the pub that evening? Bill. Good afternoon, Bill. When, if anything, did you see that took place between Mr. and Crucio? What color of shirt did Mr. Crucio have on when you saw him around 6 p.m.?
Nutrition is going to be.
What color of shirt did Mr. Crucio have on?
Yeah, just a second. We're having
Yes.
about a 30-second delay here. We're having a few just last announcements.
Mike,
All right,
just in the meantime, we're still having trouble hearing your students speak.
Okay, we'll speak a little louder, but we're having some announcement difficulties right now.
Yeah, that's fine.
Okay, just give me about another minute because our bell's fixing to ring.
Yes.
Going to be, the one that's Terry Green, Teresa Green.
What color of shirt did Mr. Crucio have on when you saw him at the pub around 8:30? Yellow. Blue. Now, do you know what type of statement?
Sorry, I missed the answer. What was he wearing? Sorry, witness. What was Mr. Crucio wearing?
Good as.
Shirt did Mr. Crucio have on when you saw him at the pub around 6? Blue. What color of shirt did Mr. Crucio have on when you saw him at the pub around 8:30? Yellow. Do you know what type of statement Crucio signed when in the custody of the constable? I didn't see him type anything up, but I didn't know. I passed the witness.
Your Honor, can we cross-examine now?
Yes, thank you.
Miss Green, can you tell me how old you were on 26 November 2015?
17.
On the night in question, did you go to the pub with Angelo?
Yes.
Were you reluctant to go to the pub because you were underage?
No.
But your statement said that you were not very happy about it, but you still went to the pub. Is that correct?
Yes.
Did Angelo tell you not to worry because you looked over 18 years old? Well, I'm quoting from your statement here. He told me not to worry because we both looked over 18. I wasn't very happy, but when we got there, we met some friends and had a few drinks. Does Angelo make a habit of dragging you into a situation where you break laws? And in this case, underage drinking?
Objection, speculation.
Oh no, I'll allow it because the witness has admitted that she's underage. And I think I'll just restrict it to, did he often make you go to the pub when you didn't want to because you're underage?
Underage to drink, but not to go to the pub, correct?
Did he often makes you go to the pub to drink with you?
I don't drink. No, it doesn't make me.
Well, you do. You were worried about your mom finding out about it.
Because I'm always worried about what my mom thinks, like care for her.
Did Angelo try and get you both a lift to the party?
No.
Well, according to your statement, it says that he tried to get you a lift to the party and was asking your friends. In your statement, you said Angelo asked if your dad would lend him his car, and you said that Angelo does funny things sometimes. Did you think he was going to try and take a car? Yes or no?
No.
Was Angelo disappointed when there was no room in other cars to get a lift to the party?
No.
Well, according to your statement, it says he was disappointed.
Hearsay.
In your statement, you said...
Objection.
It's in your statement. Was Angelo disappointed when there was no room in other cars to get a lift to the party? In your statement, you said Angelo was sweating and shaking, and when he returned to the pub from home, why was he shaking?
I don't know.
Angelo's statement said that he had a white top and changed to yellow. You just testified that he had a blue top. Can you explain that?
Yes, I can testify that he's wearing.
How?
Because I saw him. I was with him whenever he came back.
So he changed his top twice. According to your statement, he was wearing a white top, and after when he returned home, he was wearing a yellow one. Where did the blue top come in between?
He was wearing a blue, then a yellow.
Where's the white top from then?
The what?
Angelo said he was wearing a white top, and when he returned to the pub, then yellow. Where did the blue top come from?
I can't talk for Angelo.
He was wearing blue jeans, not a blue top. How many alcoholic beverages had you consumed?
0. I didn't drink.
But according to your statement, you had a few drinks before your meal and another one Angelo returned.
Not alcohol, though. I never said alcohol.
So why were you worried about when your mom was going to find out? And the police officer?
Because
And that's in your statement.
Because, as I said before, I care what my mom thinks about me because I care about her, and I want to make a good impression.
So you were drinking, that's why you were so cared about your mom.
I was drinking, but not alcohol.
So then why were you worried about your mom?
I just told you because I always care about what my mom thinks.
If you weren't drinking alcohol, then there was no need to worry about it.
If you weren't drinking alcohol, then there would be no worry to be worried about. You just went out with your friends.
Is that a question or a statement?
Objection. Ask an answer.
Prosecutor.
Come on, Your Honor, this is going nowhere. Please ask another question. This question has been answered several times.
Well,
on your walk.
Okay. Can I ask you this, witness? Were you worried about being in the pub and that your mum would be cross about that?
There's a band that was never going to play.
I'm sorry, we didn't hear that.
Could you please repeat the question for her?
Doesn't matter whether she was drinking or not. the fact that you're at the pub something that you thought your mum might get cross about if she found out?
Because I'm never because my mom trusts me and I'm not worried about her knowing that I was in the pub because I'm a young lady. She knows I'm responsible, and we were just there to go see a band that Angela wanted to see.
All right. Thank you. I think the time is finished for you,
On your walk, were you
Ms. Green. We'll just have one more question for you, Ms. Green.
Can we have him?
One more question, Ms. Prosecutor. All right. I think we'll finish you. Thank you very much, Ms. Green. Now, does the defence have a second witness?
Yes, Your Honor. We call Angela Crocio to the stand.
Thank you.
What is your name?
My name is Angelo Crocio.
Where do you live?
I live with my mother, Rosetta, at 45 George.
What is your occupation?
Sorry, we can't hear you. Could you be close
Yes.
to the mic?
Mr. Crocio, you're going to have to get your mouth close to the microphone and speak loudly and slowly. Thank you.
What is your name?
My name is Angelo Crocio.
Where do you live?
I live with my mother, Rosetta.
What is your occupation?
I met in high school in 2015. For the casual work I do for Abu Blackett, the plumber. Around the corner.
Now, what were you doing on November 26, 2015?
I took a shower, dressed in blue jeans, blue pants, and a white shirt, and went to meet Eric Green.
Where did you go?
To a pub.
How long were you at the pub?
A couple hours. Around 8 from my mother's oven, so I told her I'd be.
And what happened?
On my way to my house, I went to Blackett's house. I saw that his ute was parked halfway to the street.
What, if anything, did you do?
These were still inside the car, going into his driveway.
Well, did you say to Mr. Blackett when he came out of the house?
I said, "Give up, old man, give up."
What did you mean by that?
I meant that he should give up his yelling. He was obviously drunk, and I was trying to calm him down. I was just trying to help him out. Driveway, so he wouldn't be a vehicle.
Who's this person?
My boss, Abby Blackett.
What exactly do you mean by it?
He hired me to be over. He had I walked back to my house, turned off the stove, turned the power, changed my shirt, fed my dog, and walked back to the pub.
When you got back,
Terry told me that Doremi wasn't playing for that. So we decided to leave the pub and go for a walk.
no further questions, Your Honor.
Thank you.
Your Honor, I just want to start off by saying we had no idea what happened. We couldn't hear a thing.
All right. Well, you just cross-examine how you intended to.
Yes.
Based on the sheet.
Yes, Your Honor. Have you done some casual work for plumber Abby Blackett?
Yes.
More than once?
Yes.
So you would know Abby Blackett well, and she would know you well.
Last part of your question, please.
So you would know Abby Blackett well, and she would know you well?
Yes.
How old was Terry Green on the night of 26 November 2015?
17.
You have stated that you went to the pub that night. Did you and Terry both drink alcoholic drinks?
No.
but in both of your statements, it said that you had more than a few drinks. And Terry stated that she thought the police wanted to speak to you as Probationary Constable Michaels knew you had been drinking. What do you say to that?
It's unspecified that they were alcoholic, just as drinks, which could have been almost anything. Water, sodas, not technically alcoholic beverages.
Yes, but Terry said in her statement that she was worried that Probationary Constable Michaels would ask questions. How do you explain this?
He never investigated anything.
Are you aware that as probationary driver on your P plates, you are not allowed to have any alcohol and drive?
Didn't drink any alcohol.
Well, you should, as it is a condition of holding your license. Sorry, Anna, if you were trying to move it into the driveway, if you're trying to move the ute into the driveway, does that constitute driving?
Yes, I was just trying to help him move his ute into the driveway so he wouldn't get hit.
Okay. Did you turn the keys in the ignition and attempt to start the car, meaning you were in control of it at the time?
Yes, I repeat, because I wanted to make sure it didn't get hit by a car if it was parked after.
Yes or no, please?
Yes.
Well, this does constitute driving. You have in fact broken the law. Do you usually break laws?
Well, that's a matter for me to decide whether he broke the law. But do you admit that you were attempting to move the car into the driveway, but you say only because it was parked on the curb in a bad spot?
That is correct.
All right. So I think, Ms. Prosecutor, I think you have established that he's driving, and the question of whether that's legal or not is what I have to decide. All right. So please go ahead, Ms. Prosecutor.
Okay. Were you worried or nervous when Police Constable Michaels asked you to go to the police station?
There's no reason why I would be nervous.
Could you repeat that, please?
There's no reason why I would be nervous.
Is it true that Probationary Constable Michaels said if you admitted to taking the ute, you could get bail?
He said that if I signed his statement that he'd let me get bail.
Just yes or no, please.
Yes. No, I mean no.
Did you sign a What was that?
No.
So Probationary Constable Michaels didn't say that you could get bail if you signed the statement?
Yes, he said I could get bail for signing if I signed the statement. But
So he did say, so he said yes.
No.
I'll repeat the question one more time, Mr. Corosio. Is it true that Probationary Constable Michaels said if you admitted to taking the ute, you could get bail, yes or no?
I didn't take the ute. I signed the statement because he told me if I signed the statement, he'd let me go.
Did you sign a statement saying that you tried to take Mrs. Blackett's ute?
He didn't listen to me any more than you are.
Just yes or no, please. Did you sign the statement?
Exactly the problem. He never investigated and you're not listening.
That isn't the question, Mr. Crosshair. Did you sign a statement saying that you tried to take Mrs. Blackett's ute?
No.
So your statement is a lie then?
It's not a statement.
Your written statement is?
It was never written. It was never my statement.
So you told Terry that your mum had taken the car and that's why you were trying to find a lift for both of you to the party. Is this correct?
I was never trying to find a lift to the party or anything.
Your statement says you did.
Acknowledging the evidence.
Sorry?
There was no party for me to, need to take a car to.
Your statement said there was.
Never says so in the evidence.
If your mum's car was home, does this mean you would have taken it as your means to get to the party, even after having consumed a few drinks, again breaking the law?
There was no need for me to take a car because I was never going to a party.
Okay, in both your statements you've admitted that. No further questions, Your Honour.
Thank you. Any re-examination by defence?
Yes.
Yes, Your Honor.
Okay, thank you.
Would the police
Go ahead.
Anything about a party?
Mr. Crosu, did the police ever ask anything about a party?
No, not at all.
Did they ever investigate?
No.
When you were at the station, they typed up a written statement and you handed it.
Yes, that is correct.
So it was never your written statement?
No, it was never my statement.
No further questions. I pass the witness.
Thank you. Thank you, Mr. Crossio. Okay, so now we're up to closings. So first I'll hear from the prosecution.
Yes, Your Honour. So do I just do it? Your Honour, the real issue here is that Mr. Crossio had attempted to take Mrs. Blackett's ute, which we believe was to attend the party he was so desperate to get to. The only reason he didn't actually take the ute was because Mrs. Blackett came out and caught him in the act. Well, we have established that, 1, the defendant took the vehicle without the owner's consent, 2, the vehicle was a means of conveyance, and 3, the defendant took the vehicle and drove it for the purpose of driving. The defendant not only took the utility, but intended to do so and made admissions as to taking the ute. As stated in our opening, that Section 86A of the Criminal Law Consolidation Act establishes that it is an offence to drive, use or interfere with a motor vehicle without first obtaining the consent of the owner. Further, that driving includes any activity that can exert control over the vehicle. The credibility of both witnesses, Angelo Crossio and Terry Green, is seriously questionable. Both have admitted to Terry underage drinking and Angelo getting behind the wheel of Mrs. Blackett's ute after having consumed alcohol, which is a breach of his probationary licence conditions. Terry Green is not reliable at all, as she had said in her statement that she had felt sick at the time and things were hazy, and thus so in her recollection of the events in that night. Terry had stated that Angelo does silly things sometimes and had encouraged her to go to the pub, even though she was underage, and consume alcohol. Angelo has proven that he shows a blatant disregard for laws and that are put in place for the safety of all community members, specifically getting behind the wheel with alcohol in his system. The answers to some of the questions from both witnesses were cagey and questionable. The defence suggested the fact that Miss Blackett couldn't see as she didn't have her glasses on. Miss Blackett clearly testified that she only needs them for close work and has excellent long-distance vision. Therefore, her vision was not impaired and she is a reliable witness. Furthermore, Miss Blackett was not impaired as a result of alcohol, as she had 4 drinks between 12 p.m. and 8 p.m. The keys were also not left in the ignition, but a spare set was under the driver's floor mat, which Angelo knew from having been in the car. It's in Terry's statement about, and it's also in Terry's statement about the party. I suggest to you, Your Honour, that you must find the accused, Mr. Crossio, guilty, taking into the previously mentioned Section 86A of the Criminal Law Consolidation Act 1935, referring to using a motor vehicle without consent. Can I also refer you to R. v. Roberts per Lord Parker CJ at page 88, where it was stated that the defendant could operate the brakes, indicators, warning device, steering, and lights, then he had something to do with the movement and propulsion. Your Honour, based on all the evidence we have presented, I suggest to you that you find the accused, Mr. Crozier, guilty of the charges against him. Nothing further.
Thank you, Mr. Prosecutor.
Allow me to proceed, Your Honor, for my closing statement.
Yes, thank you.
Ladies and gentlemen, Your Honor, you've listened to the testimony, you saw the exhibits, and you should be able to make up your mind strictly on the facts of this case. The facts are very simple. On November 26, 2015, the defendant, Mr. Crozier, did start to operate and move forward Mr. Albie Blackett's youth from the road to the inside of his driveway. Even though he didn't have permission to do this, he doesn't qualify as breaking law section 44A of the Road Traffic Act 1 because not all of the elements of the offense took place and were proved in court today. He was doing this simply to help Mr. Blackett. He had a prior working relationship with Mr. Blackett and knew about his drinking. Now, when he came across the youth in the driveway and footpath, he was concerned about Mr. Blackett. He knew that the police could ticket Mr. Blackett. It was this simple concern that motivated him to move up the car when he saw the keys in the car. Now, cross-apply the fact that our parents were drinking while inside his home. He came outside without her glasses. Now, as a confused and unreliable witness, at this point, of course, she's going to blame Mr. Crozier for drinking the car. If he didn't, she would have to admit to the police that she drove home after having several beers and couldn't park her car. Evidence of operation of a motor vehicle under the influence. On April 12, 1985, the South Australian Court of Criminal Appeal unanimously upheld an appeal by Raymond John Giesing, and South Australian Chief Justice Mr. Lang King ruled that Giesing's 1983 trial had miscarried in his guilty for the murder and abduction of that it must have been set aside. Chief Justice King said that the prisoner informants were unreliable and untrustworthy witnesses. This applies to during the fact that he did not have the glasses on. The Crown tried to argue that Crozier tried to take Mr. Blackett's youth without consent of the owner. Your Honor, this is not the case. In fact, cross-apply the fact that the timeline brought forth by Mr. Blackett put the event taking place at 7 p.m. At 7 p.m., Mr. Crozier was at the pub with his friends. Cross-apply the fact that the police never came to investigate Mr. Blackett's home at 9 p.m. Right after the incident. The Crown tried to argue that our witnesses weren't reliable. How is someone reliable when they do their job properly and investigate the crime? How can they arrest someone without handling the investigation in the first place? Now, at 7 p.m., we need to rely that at 7 p.m., Mr. Crozier had a blue shirt, white shirt, and was at the pub with his friends. So clearly, Mr. Crozier did not have a yellow shirt on until the phone call with the constable making this piece of evidence without police location of the driveway. The only thing that makes it is Mr. Crozier's story of moving the youth up the driveway. Without reading the person's rights or even investigating the crime scene is deplorable and should not be tolerated in court by any public servant. The purpose of Crozier occupying the youth was not driving it, but moving it for the purpose of public safety. Moving it far out of the way with the driver of the car in a dangerous situation to the public is not a crime. The car did not punish. The car didn't stop. Crozier stopped blocking the path for purpose to curb. Starting the car moving up out of the driveway, get it off the road, shows that intention that the defendant has not broken this law and should not be convicted today. I cross-applied criminal law consolidation Act 1935. A reference to the consent of the owner property extends to implied consent. A person does not have implied consent of another. The person honestly believes from the words or conduct of the other that he or others consent. This implied consent of the owner takes place here, Your Honor. 1. Two, the youth was parked erratically in the street. And 3, Angelo Crozier had done part-time work for Mr. Blackett and wanted to help out his boss. The Crown tried to maximize the impact of the possession slide by. Now, according to Black's Law Dictionary, coercion is the practice of forcing another party to behave in an involuntary manner, whether through actions or inaction by use of threats, rewards, or intimidation by some form of pressure. All the police did was tell him that this all he would have to do was admit what he did and he could make bail. He said he wanted to go to the party and he could sign anything. Anything, Your Honor, including the typed up statement that probationary counsel might sign up for him. Now, the entire case, the crime is totally subjective, unproved, and speculative. In R.B. Phillips' 1960 it was established that the accused is assumed to be innocent and proven guilty, and he is entitled to the benefit of every reasonable doubt that is raised in this case. It was up to the Crown to prove that Proccio was guilty. Did he meet that barrier? I'd say not. When you have a witness as someone that arresting someone without conducting a proper investigation in the scene, I wouldn't say that's quite reasonable. Now, they never or reason for taking the youth. I would ask the court why did they do so. The answer is simple. They never investigated the crime properly. Again, they took the word of Albie Blackett to be true without investigating if a crime had indeed taken place. He got a confession on the basis of it without any corroboration of his testimony. Why was the crime scene never visited before the suspect was picked up? If they had, who would not be in court here today? You know things, wouldn't it make more sense that my client was telling the truth? He didn't run away from the police once he never had a reason to take the youth. In fact, according to the testimony of Mr. Blackett, the youth ended up in his driveway. The events that lone witness at the Crown produced testified to say that it took place at 7 p.m. At 7 p.m., Your Honor, Mr. Blackett was at the pub. The group he wanted to see was playing at that. He did not need a youth. Conjecture's motive does not work in the 21st century. The Crown must provide the fact to convict, not the ideas to convict. We simply ask you to follow the facts. Look at what happened look at the exhibit. They all point to not guilty verdict and on the accountable legal prosecution where it was established that the accused is presumed to be innocent and proven guilty. I will set every account and reasonable doubt that the case. Without proof, without witnesses to back up Mr. Blackett's account, or without the police having done a proper police investigation of the scene, we are left with no reason but to convict a man who did nothing more than help Mr. Blackett. Thank you, and we respectfully ask to vote no.
Thank you. All right, thank you very much. A lot of preparation and effort's been put in by everybody. Are there any questions you want to ask me, or do you want me to just give feedback about the trial and issues that were done and not done?
Just give feedback.
Okay. All right. Well, I think the way trials work is that everyone prepares very hard for them, and sometimes the issue you've prepared very hard for has in fact found a way to not be an issue anymore. Like the issue of driving, I think, which looked like at the start to be a very big issue, didn't turn out to be one because Angela admitted getting in the car, the ute, and driving. The issues for the prosecution are, as many Americans would put it, give me a break. These coincidences are so ridiculous, as the defence say, that there's only one reason he wanted the ute, and that was to get to the party. And he knew the ute, and he probably knew where the keys are. The defence case is you've got a witness who's been drinking. Also, the witness gave the defence a bit of a free kick by saying that they'd just got back from overseas, so they were probably tired and jet lagged as well. And they'd been drinking during the day and drinking before reporting it to police. So the unreliability of the witness was a key issue which defence brought out. The poor investigation by police was brought out, and also the fact that this young man, although I think he denied it in evidence, but he, on the police case, signed a confession that was in dodgy circumstances because of the fact that bail was offered, and who wouldn't take bail rather than a night in custody for a young man. The prosecution, so there was a funny piece of evidence which neither side commented on, and that's the the comment by the person, give it up, old woman. Give up, old woman. That to me was a strange comment that didn't really have a logical reason for it to be made. So that she may have been confusing it with another person. The other issue was there was no evidence of where the witness left the keys at that time. Although someone mentioned the keys were under the driver's seat in the closing statement, I don't think there was any evidence of where it was. But I must say that the prosecution were up against it because of the poor investigation, the confession, and the fact that the car seemed to be driving consistently, to put it in the driveway. So the prosecution, though, were good because they attacked the witness with some vigour, and he was giving contradictory answers on the same questions. So it was a very good even contest, and the prosecution case was really that the circumstances are so coincidental that really the only explanation is that he took an opportunity and to try and drive this ute to the party because he'd been drinking, and he got caught red-handed. So I think in terms of a key way to prepare for trials is an old tip, is that the first thing you should do, having read all the prosecution papers, is write it, and all the defence papers, if you're defence, your private instructions, is to write out a draft closing address, because that's your end point you want to get to. Because if you think about what you want to say at the end, then you know what you have to ask to get there. So that's, if you do this again, the first thing you should do after reading everything and noting everything is then write your final address, because then that'll give you a clear picture of how you want to progress the trial. And that works from both sides. So, but I must say, but how old are you guys? 16?
Yeah.
Yes.
Yeah.
Yes.
It's a very good start that you all made. If you want to keep going. It's very difficult discipline asking questions, because sometimes you want to throw your own comments in there and your own disbelief of the answers. But just remember, you're there to ask questions all the time, and you shouldn't really throw any comments in. You can during objections, but not during questions. But I must say, ladies, that I was very impressed with you all. So, and I think the key to trial work also is preparation out of court time, which you've done very well. So, and well done to the witnesses as well. So, anything you want to say back to me or ask me about? I would think, because the circumstances were so strange on both sides, you got a drunk witness, poor investigation, that I think it was pretty hard for a prosecution to overcome in the end. If it was a balance of probabilities, I would have found him guilty, but beyond reasonable doubt, I think he just wins. The defendant just wins. But you often find, if you pursue the law, you can do the best job you've ever done and still lose your case. You're often bound by what your case gives you. And a final word is, when you do prepare for a trial, you also should identify what's your weapon at the trial. What is my weapon that's going to make me convince the court that my case is right? And when you find that weapon, which you'll do if you write your final address, keep that always in mind. This is my weapon and this is why he's guilty or not guilty. Yeah.
Thank you, Your Honor.
Okay, in terms of the advocacy, I don't like comparing people with people, because the one thing I do say to you is don't try and be someone else when you're arguing your own case. You can pick up good points from other people, but don't try and become another person. You are there, and juries and judges will soon work out what your personality is, and they will adapt to your personality. So don't try and be someone else, but always learn from good points that you see other people do, and just make that part of your own way of presentation in court. For instance, I'm not a particularly exciting person, but sometimes sometimes when I get animated, the jury might think, well, that's for a reason. He must think this is really important. And that will come out naturally without you even knowing it. So be yourselves, be confident in yourselves, and if you keep working hard like you did on this trial, I think it'll come to you. And you'll make mistakes along the way, but you'll get there. So well done
Thank
to
you.
everyone.
Thank you, Your Honour.
Thank you. All right, we'll disconnect now. And thank you to the organisers at Findon and Del Valley as well. It's the first time I've done something like this, and I really enjoyed it.
Thank you, Your Honour.
Thank you so much, Your Honour.
Thank you. Thank you.
Thanks, Peter.
Thank you, Peter.
Signing off.
Okay, bye.
America won.
Campbell.
Yes.
Both these girls are really excited about doing this, and they're both 14, so, you know, we got a lot to look forward to.
You're joking.
Are you kidding?
No.
So weird.
Our students are stunned that they're only 14.
Yeah, they're both freshmen, but we had a whole class full of people who were mesmerized by your eloquence of your students. So we were very excited. We'd like to try to do it again sometime, either a debate or something like this, whenever you feel like opportunity. Okay, well, she quit. Sorry.
Good morning, Your Worship. My name is Selena Moni, M-O-H-N-I, and I will be opening today. Marco Souza is an 18-year-old high school student whose father died 2 years ago. He used to do well at school, but his grades have been falling. A couple of months after his father died, Marco began hanging out with a new group of friends who have had a bad influence on him. Now he has a criminal record for dangerous driving because him and one of his friends, Jason, took Jason on a joyride one night. Marco was not taken into custody for this offense, and he did not have a bail hearing. At trial, he was found guilty, ordered to pay a fine, and placed on probation for 12 months. 8 months later, Marco, Jason, and two other young men were allegedly caught breaking into a neighbor's house late at night. Marco was charged with break and enter, assault, and failure to comply with his probation order from the first conviction. Marco was taken into custody by the police. At his bail hearing, the Justice of the Peace released him on a $500 surety, which his mother supplied, and gave him a 9 o'clock p.m. curfew. Marco is once again appearing before the Justice of the Peace at a bail hearing. Although he has not yet gone to trial for the break and enter incident, he was picked up by the police again because he and Jason allegedly stole a sign from inside a bar at 1 a.m. on a Saturday night. They were also allegedly in possession of a stolen vehicle that was parked outside the bar. The new charges Marco is facing are theft under $5,000, failure to comply with his probation order, failure to comply with his curfew, and possession of stolen goods under $5,000. I would now like to invite my co-counsel of the defense to introduce themselves. Crown.
Good morning. My name is Stefano Ardelin, and I will be directly examining the constable Tenzin Sonam.
Good morning. My name is Vivian Lee, and I will be cross-examining the mother of Isabella Souza.
Good morning, Your Honor. My name is Jamie Bursey, and I will be closing.
Good morning, Your Worship. I'm Jeffrey Lee. Today I'll be cross-examining Mr. Yusuf. Mr. Austin.
Good morning. My name is Andre Bandulo, and I'll be cross-examining Marcos Souza.
Good morning, Your Honor. My name is Alex Lane. I'll be cross-examining the uncle.
The defense ready to proceed? Yes, Your Honor, we're ready. Your Honor, I, Alondra Montezuma, and my partner Jacob Shaw are here to represent Marcos Sosa today in this bail hearing. A bail hearing, Your Honor, a place in our nation where we do not establish the guilt or innocence of a person, but whether or not the accused person will appear in the court for their trial on that crime. For this fact alone, we ask you not to be persuaded by the eloquent verbiage of our illustrious Crown's prosecutor. All we need to consider is two things. First, will Marcos Sosa show up for his trial? And yes, he does. Second, does Marco has document evidence of him showing up for his trials? And the answer is yes, he does. He is not a flight risk, has no means of leaving the country, and support a group, family, and friends who will not vouch for his bond, but who are willing to help Marco throughout his behavior so he can once again become a productive citizen of Canada. There are another two factors to consider here. First, in Canada, there's a presumption of innocence until proven guilty, and if Marco goes to jail now, this presumption of innocence is a dire jeopardy. Second, the plain fact is that Canadian police has a notoriously famous for overcharging or booking on charge against the accused. My client, Marcos Sosa, is charged with theft of a motor vehicle, yet no one saw him do it, nor was he driving the van when the constable pulled him over. He is charged with theft, yet no one knows for sure who had stolen the sign. We will call 4 witnesses today, and we will call neighbor and former basketball coach Joseph Osman. They will testify about the character of Marcos Sosa and the fact that this present behavior began at the time of Marcos' father's death. They will also testify to the characters of Marco's family and their commitment to Marco and his ability to do what he said he would do. Our second witness will be Adriano Gouveia, the uncle. He would testify how he would provide a strong male figure in the family and how his plan will work. Our third witness will be Isabel, the mother of Marcos Sosa. She will testify to Marco's ability to make his court dates and his sincerity in complying with the legal requirement. Finally, we will call Marcos Sosa himself. He will testify that he will show up for his court date, and he plans to show charges against him are completely overblown and overcharged in this case. Your Honor, we are left with a rather easy decision here today. Should we grant bail or not to Marcos Sosa? Will he appear for his court date today? Is he willing to clear his name in the court? Is he anxious to set the record straight in this matter? Yes, 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 and yes. There is only one thing to do, is the right thing. Set bail for Marcos Sosa. Let the legal process begin. It is only then that we will know the truth, the whole truth, and nothing but the truth. Thank you, Your Honor, and with these words, we conclude our opening conclusion statement.
Great, thank you. Crown, you ready to proceed with your first witness?
Yes, we are, Your Worship. Now, I would like to ask the Constable Sonam to take the stand.
For the purpose of this exercise, can we assume that all witnesses have already been sworn in?
Constable Sonam, before...
Just with the opposing team. Can I confirm with the defense?
Yes, you may.
Okay, thank you. So please proceed.
Constable, before we proceed, may you introduce yourself and please spell your name for the purpose of the court.
My name is Tenzin Sonam, Tendvinsonam.
Constable, how long have you been a police officer?
For 12 years.
Mm-hmm. And on that particular evening, when you received the dispatch, how did you get involved within this case?
I was at patrol. I was patrol at the time in the area, and I began to scout the area for any suspicious vehicles.
Was there a call from a person that evening inquiring as to Mr. Souza's whereabouts? What was your reaction when you received the investigation order after the bar manager reported missing sign? Please tell us what was your reaction when you received the investigation order after a bar manager reported a missing sign?
I took it as another assigned task to another task assigned to me.
Thank you. Did you end up finding the van offered within the description?
Yes, I was able to find the
Well, once you stopped the vehicle, what did you do next?
Before I exited my own car, I checked the license plate of the vehicle, and upon approaching the vehicle, I saw a sign in the back.
Okay. How were you able to spot the bar sign?
When I shined my flashlight through the van, I was able to spot the sign.
And after you did spot it, how did you interact with the occupants of the vehicle?
I approached them and I asked them to identify themselves, and as they were unable to identify themselves, I asked them to verbally identify themselves. And I found out they were Marco Souza and Jason King.
And where was Mr. King seated?
Mr. King was seated in the driver's seat.
And Mr. Souza, where was he seated?
Mr. Souza was seated in the passenger seat.
After conducting a background check upon the occupants, what did you find about them?
I found out that they were they had allegedly stole they in possession of stolen I found out that they didn't comply with their probation.
Thank you. And what did you do after you discovered that the van had been reported stolen?
I arrested them when I found out the van was stolen.
Constable Sonam, what was your reasoning for holding Mr. Souza behind for his bail hearing?
Can you repeat the question?
Certainly. Constable Sonam, please tell us what was your reasoning for holding Mr. Souza behind for his bail hearing?
I had reason to believe that he would not show up for his date because of his previous because of his because he recommitted crimes and his previous
And did you consider him liable to recommit?
Yes, I did.
Thank you very much, Your Worship and Constable.
Your Honor, may I proceed with cross-examination?
Yes, please go ahead.
Constable Sonam, your testimony today is mainly about the alleged charge pending against the defendant, Mr. Sosa, correct?
Sorry, it's a little bit broken up. It wasn't very clear.
Sorry about that. I said, Constable Sonam, your testimony today was mainly about the alleged crimes against our client, correct?
Yes.
However, according to the law, a bail hearing is not a trial, correct?
Yes.
And a bail hearing is a place to discuss just that, bail, correct?
Yes.
And your testimony is not about Marco's ability or inability to pay bail, correct?
It's about the
Excuse
me?
Go ahead. Just wait. Sorry, we're just going to switch witnesses. I think this witness is froze up, if that's okay with you.
That's completely fine.
Thank you. Sorry about that.
Can you start my questioning or?
Yes, please. Yes, please.
Okay. So, I'll just go straight into it. A bail hearing is a place to discuss bail, correct?
That is correct.
And your testimony today is not about Marco's ability or inability to pay that bill, correct?
No, today I'm discussing the fact that Marco could recommit had he not been held for a bail hearing.
Right. But your testimony is not about Marco showing up or not showing up for his trial date, correct? You can attest to that.
Well, as I stated in the police report, I found it reasonable to believe that Marco could fail to attend his bail hearing had he not been held in custody until this time.
Yes, but you have no factual evidence in support of that, correct?
Due to the fact that Marco has had a past conviction, his outstanding charges, and his breaches of both curfew and probation, I found it reasonable to believe that Marco could fail to attend his trial had he not been held.
But for the record, again, you can attest to him not being able to pay bail, correct?
As I stated, that was not the reasoning that I had when I held him in custody.
And you've never met Marco before you arrested him before this trial, correct?
Although I didn't, personally I did not, he has had previous encounters with the police.
Right, but would you, based on that fact, would you stand to reason that a former basketball coach, being the neighbor, would know Marco better than you do, correct?
I am unaware of Marco's neighbors.
But seeing as how they've been knowing him longer, and you never met him before this trial, they would know him better, correct?
I am unaware.
So you would disagree with the fact that a neighbor who's known Marco for 5 years would know him better. You disagree with that fact?
With all respect, I am unaware of Marco's neighbors and his relationships with them. Therefore, I am unable to answer this question.
Sorry, time is up. Did you want to ask one last question?
Certainly. So again, do you believe, Constable, or know that a bail hearing is for the purpose of bail and not the alleged crime?
That is correct.
Okay. Thank you.
No further questions, Your Honor. Thank you.
Thank you. Commissioner may step down. Thank you. Does the Crown have any further witnesses? Great, thank you. Would the defense like to proceed now with their witnesses?
Yes, Your Honor. Just give us a few seconds to get coordinated with that.
Of course, no problem.
Camera shot. Yeah, you must. Yes.
Your Honor, I will call my first witness, Marco Sosa.
Sure. Go ahead and proceed, please.
Your Honor, it's Joseph Osman.
Sorry, we can't hear you.
Your Honor, I will call just some Osman.
Yes, please proceed. Okay, see if we can hear you. Hello?
Hello?
Okay, let's try this again, see if we can hear you.
Sorry, we're just clarifying that instead of calling Marco Sosa, we're in fact calling the neighbor, Mr. Osman, as our first witness.
Yes, that's fine.
Thank you.
Yeah.
Can we be, Your Honor, may we begin?
I don't know, I'm not sure why we're not hearing them. Sorry, we can't seem to hear you clearly, so we're just checking our volume.
We're not muted, are we?
It is not. Okay, let's try this again. Sorry, it is on maximum, but we're just having difficulty in hearing you.
Okay. Can you hear it now?
Okay, go ahead, please.
For the record, please state your name.
My name is Yosef Osman.
For the record, please state your age.
I am 30 years old.
For the record, please state your relation to the defendant.
My relationship to Marco Sosa is I am a neighbor as of now, and about 5 years ago is when I met him. He was a middle school student, was also, he was both a student of mine as well as one of my players for the middle school team.
Can you explain what was Marcos Sosa's behavior when he was one of your players?
Well, his behavior was, he was a great kid, and within my classroom, he seemed to be a rather brilliant student.
How would Marcos Sosa's behavior change over these 2 years after his father's death?
Well, after his father died, that's when things began to spiral. I noticed that he quit his high school team, and he would then hang out with another set of friends. I tried to convince him to rejoin the team, and I also tried to get him to help me coach the middle school team, but he didn't show any interest.
For the record, please tell us your reason for being here in the court today.
Well, my reason for being here is to show that, one, he will be able to, of course, show up for the trial. I'm also here to speak about his good character.
Mr. Osmond, can you explain his good character in your terms?
Well, since you've asked me, I've been able to show that, one, without this incident, the incident in question, his father dying, he was a great student. He was a great kid, and it's all because of that things began to spiral. It's one of the reasons why we're here today.
Mr. Osmond, do you believe that Marcos Sosa can legibly go back to those good behaviors?
With plenty of support from his already strong family, I believe that this can be accomplished. Yes.
Why would Marcos bail in this charge present not challenge the safety of the public at large?
Once again, I know that Marco has been able to show up to his previous trials, and within said trials, everything was really faulty with his evidence. And you can also see that Marco, he's a good kid now. But with the help of the court, I'm sure he can better himself.
No further questions, Your Honor? May I pass the witness?
Yes, please.
Your Worship, is the Crown proceed?
Yes.
So I'm going to be cross-examining Mr. Osman. So, Mr. Osman, how long ago were you Mr. Sousa's basketball coach?
I'm sorry, can you repeat that?
So how long ago were you Marco Sousa's basketball coach?
Roughly about 5 years ago.
And would you agree that 5 years is a long amount of time?
It is.
So would you say, would it be fair to say that people change a lot over time?
It's fair to say that. However, I am a neighbor. I live right across the hall, so I've been able to see him, and he has changed, but that's all because of the death of his father.
Okay, so would you say that your relationship with him is distant?
He's made it distant, yes.
Okay, so with your relationship so distant, am I correct to assume that you have minimal influence on Marco and his future behavior?
His future behavior. Well, his behavior can only be influenced by those around him. And I can certainly attest that I would certainly have more influence over him than, let's say, the police.
Okay, so would you say that his mother has more influence than you on him?
Yes.
So, you know that his mother's influence is not that strong. So would you say that your influence is minimal?
Minimal? Well, it has a presence.
But you just said that his mother's influence was not that strong anyway.
I didn't say that. You did.
Okay. So, moving on to my next point, you have a family, correct?
I have a family, yes.
With 2 children, I believe?
Yes.
Okay. So are you working extra hard to provide for your wife who's not working and taking care of your children?
I'm working as hard as I can.
Okay. So your job is a teacher, right?
Yes.
So is it fair to say that you at least get 5 to 6 hours of work daily?
At minimum, yes.
Okay. So as a full-time teacher, I'm sure that your job, as you just said, is fairly busy.
Mm-hmm.
So with your previous answers, I'm suggesting that you will not have enough time for Marco and not being consistent influence in Marco's life, right?
I'm sorry, can you repeat that?
So with your previous answers, I'm suggesting that you will not have enough time for Marco and be a consistent influence in Marco's life, correct?
Well, to answer that, I, of course, have weekends. We are right there. And even then, I will obviously have more time for Marco than the police will.
Okay, time is up. Would you like to ask one last question?
No, thank you, Your Honor.
Okay, thank you. You may sit down. Would the defense like to call their next witness?
Yes, Your Honor, we'll call Uncle Adriano Guevia.
Okay, please proceed.
Yes. All right. For the record, please state your age.
I am 45 years old.
For the record, please state your relationship to the defendant.
I am Marco Sosa's uncle.
For the record, please tell us your reason for being here in this court today.
My reason for being in this court today is to testify that Marco Sosa is a fine young man and can better himself with my help and family's help.
Mr. Guevia, what do you think about Marco's family?
I think he has a nice family. It's just that without his father, he has no one to look up to and set a role model.
What do you think about his behavior over the past year?
Over the past 2 years, ever since his dad died, he had been spiraling down, hanging out with bad people.
How is Marco behaving? Please explain why Marco Sosa should receive bail.
Marco Sosa should receive bail because he's simply just an 18-year-old boy who got caught up in the wrong crowd. And this all happened because of his father's death, which would impact heavily on anybody.
How would you say will influence Marco Sosa?
As a strong role model, I will influence him by showing him how to become a man and be responsible and no longer be with the wrong crowd.
So, are you saying that you can provide Marco Sosa with positive effects?
Yes.
And so you're saying that you will also provide with role modeling, correct?
Correct.
So, stating that there is plenty of crime, would you provide money for the bail?
Yes, I would provide money for bail as well as help pay rent.
How has Marco's behavior changed since his father's death?
Since his father's death, he's been acting really strange, hanging out with the wrong crowd. But as his uncle that knows him well, I'm pretty sure that I can change this.
Do you have any legible criminal record?
I have no criminal record at all.
Why would Marco's bail on this charge present no challenge to the safety of the public at large?
He's not a danger to the public simply by having himself around these type of people that commit these crimes. It is the actual people that he's hanging around that are a danger to the public, not himself.
Can you explain that more?
He's a very good person and is simply confused on how to act because he has no one to look up to for support and guidance.
So, going back to all the facts, with y'all support, mother Isabel and y'all are going to better Marco Sosa, correct?
Correct.
No further questions, Your Honor. I will pass the witness.
It's Crown Manager Costin.
Your Worship, the crime may proceed.
Yes, ma'am.
I understand that Marco's previous bail hearing, you were not present, correct?
Correct.
So therefore, you weren't there to support Marco for his family.
No.
And now you decide to suddenly support Marco with a second bail hearing?
Can you repeat the question?
And now you decide to suddenly support Marco with a second bail hearing?
Yes.
It's my understanding that you work full-time as a research technician.
Yes.
With a full-time job, aren't you busy working the majority of the day?
I'm never too busy enough for my family.
As such, if something were to happen, you would be able to intervene in time then.
Of course, anybody that has strong ties to their family would do anything for their family. I would also provide more help than the police and the prison at which they want to put him in.
Will the company you work at allow you to spontaneously take time off to take care of your nephew?
Yes, because I've been working there for 15 years, so I have a credible background of being there and working hard.
It's a government job. They won't let you do things like that.
Well, as a person that's been working in that job for 15 years, I'm pretty sure what they can and will not let you do.
Very well then. So after Marco's father's death, he has been pushing you away, correct?
He shut me out a little bit, yes.
So then how can you make any impact in his life when he clearly doesn't want you in it?
Because I have more impact than his mother and the police, and he needs a role model, a strong father figure.
Are you trying to replace his dead father?
I'm not trying to replace a dead father. I'm trying to set a role model, and that is an insult to my brother-in-law.
I'm sorry, we're out of time. Would you like to ask one more question?
No, no further questions, Your Honor.
The witness may step down. Would defense please call the next witness?
Yes, Your Honor. We will call Isabel, the mother. For the record, state your name.
My name is Isabel Sosa.
For the record, please state your age.
I'm 40 years old.
Please state your relationship to the defendant.
I am Marco Sosa's mother.
Please tell us your reason for being here in the court today.
I'm here today so that my son will get bail.
Okay. Please explain why Marco Sosa should receive bail.
He should receive bail because not only did he show up to his last trial, but he's just an 18-year-old boy who doesn't deserve to stay in a county jail until his trial.
Ms. Sosa, what were the terms of you quitting your job?
I quit my job because I felt that I needed to be there for Marcos and his sons, Marcos and his brothers after his dad had died a couple years ago.
How will Marco Sosa's behavior change if he is allowed bail?
Well, Marco Sosa's attitude will change because he'll start helping his brother. He'll realize that he got a second chance, or he can get a second chance. And then my brother would also come and help him.
How has Marco's behavior changed in the past 2 years?
In the past 2 years, Marco's behavior has dramatically changed because of his father's death.
So you're saying that his father's death was the cause of his behavior, correct?
Yes.
Why would Marco's bail on discharge present no challenge to the safety of the public at large?
Because he's just a harmless 18-year-old boy. He simply got it mixed in with the wrong crowd.
The wrong crowd? Can you explain that?
By the wrong crowd, I mean wrong group of people, boys who have gotten into trouble before, and he simply just fell under peer pressure.
So, Ms. Osmond, are you saying that you're going to change his ways?
Yes, that's what we're trying to do, me and my brother.
And you and your brother are going to provide financially and emotionally positive change, correct?
Yes.
No further questions? I will pass my witness.
Ms. Souza, I understand that you used to work as a paralegal.
Yes.
And so you are aware of how our legal system works.
Yes.
And you understand the consequences of breaking the law.
Yes.
And you understand why it's important that the law be followed.
Of course.
All right. So from my understanding, you acted as Marco's surety at his last bail hearing.
I'm sorry, can you repeat the question?
From my understanding, you acted as Marco's surety at his last bail hearing.
Yes.
And are you aware of Marco's bail conditions?
Yes.
Okay. Were you aware that his curfew was at 9 o'clock?
Yes, that's my son.
Yeah. All right. So on September 23rd, was Marco home at 9 o'clock?
No.
Were you aware of this?
Yes.
Did you call the police?
Yes, once I realized he was gone.
And yet our constable testified that that the police received no call about the whereabouts of Marco Souza.
Well, your constable also testified that my son was the one who took the car in front of the house when nobody really knows who took the car.
Objection, not relevant. Hearsay.
Okay. So
we'll just ask that be straight from the record if you can continue, please.
Okay. So is this the first time that Marco has broken the law?
Sorry, some announcements are going on.
Just repeat your question.
Okay. So is this the first time that Marco has broken the law?
No.
Okay. And I'm sure you tried to stop him from breaking the law?
I'm sorry, can you repeat that?
Okay. So I'm sure that you are trying to instill good morals into your son.
Of course, I want my son to grow up and be the best he can be.
This will have to be your last question. Time is up.
Okay, so despite you trying to keep Marco from breaking the law, he has not listened to you in the past. He does not respect your authority. Is that correct?
Yes.
Okay, thank you. No further questions. Please take a seat. If the defense would like to call their next witness.
We'd like to redirect, Your Honor, if you'd allow it.
Pardon me?
We'd like to redirect the witness, Your Honor, if you'd allow it.
If it's okay, for the interest of time, we wouldn't be allowed, the court cannot permit this redirect. Unfortunately, we only have 10 more minutes for this class.
Okay. Right. Thank you, Your Honor. Move to our next witness.
Okay, please proceed. I think your mic is off.
Sorry about that.
For the record, please state your name.
My name is Marco Sosa.
For the record, please state your age.
I am 18 years old.
Marco Sosa, were you in trial for the past other ones?
Yes, I attended the previous trial proceedings. Yes,
So you were present, correct?
I was.
Can you tell us your reason for hearing in this court today?
I'm here today for alleged crimes or alleged charges. Then, of course, we're over trumped.
Can you please explain why you should receive bail?
I should receive bail because, one, this bail is determining whether or not I will actually attend the court proceeding, and of course, there is faulty evidence against me, if any.
Marco Sosa, what are those faulty evidence?
Okay, I'm sorry.
So you will be in court, correct?
I will be.
No further questions. I'll pass my witness.
Yes. Okay, so I'll be cross-examining Marco Souza. Do you believe that your mother put up $500 for your previous bail?
I'm sorry, can you repeat that?
Do you understand that your mother put up $500 for your previous bail?
I do, yes.
Your mother had to pay more money for this bail. Yes?
Yes.
You understand that this money was to ensure that you didn't get in trouble, but you still got in trouble.
Well, to answer that, the money were to ensure that I would make it to this trial, to ensure that I would be present.
So due to your previous behavior, is it fair to say that you have no respect for your mother's money?
That's not what I'm saying at all. Because if you listen to my previous answer, you would hear that I said that the monies were for my attendance, the trial, and I have I respectfully attended.
Okay, so in your first dangerous driving condition, Jason King has been with you?
My dangerous driving condition?
Your
driving.
Your previous charges, has Jason King been with you?
Has Jason what?
Has Jason King been with you?
Maybe come up to the, so it's easier for them to hear you.
It has nothing to do with the bail hearing.
Okay, was he there in your second set of charges?
I'm sorry, but
Objection, Your Honor, relevance.
But he was there in your most recent charges.
Objection, Your Honor, relevance. What relevance here are these questions?
What are you trying to establish?
I'm trying to establish that Jason King has been a negative influence on Marco Sosa.
Your Honor, that has no impact on his bail hearing today of whether or not he should receive bail to attend his next trial date.
Do you have anything to say?
I'd just like to move on. You claim that you won't that you won't get in trouble again, but you've claimed that same statement after your previous charges.
We'll let you get to that.
So, Cam's fine.
Yes.
So as my final question, let me ask you this. If someone did something to you multiple times and continuously told you that they weren't going to do it again, would you believe them?
Would I believe them? Well, I wouldn't believe your question. Anywho, well, in matters such as this, I, of course, have a strong family. They have reasons to believe me. It's in their best interest to establish our bonds and to build upon them.
I have no further questions.
Thank you. No further questions. The witness may sit down. Does the defense have any further witnesses to call?
No, Your Honor. We'd like to begin with our closing statement.
Yes. Due to it being reverse onus, the defense will proceed with their closing statements.
May I begin now, Your Honor?
Please.
So, Your Honor, I, Jacob Shaw, and my partner, Alondra Montezuma, we're here not only to represent Marco Sosa today in this bail hearing, but to represent the entire nation of Canada. Bail hearing, Your Honor. A place in our nation where we do not establish the guilt or innocence of the person, but whether or not the accused person will appear in court for their next trial date. If you listen to the Crown, Your Honor, they were trying to conduct their trial right here and now. This is not a trial. This is a place to determine if court awards bail to Mr. Marco Sosa. For this fact alone, we ask you not to be persuaded by the eloquent verbiage of our illustrious Crown's prosecutor. All we need to carefully do is look at the two things here. First, will Marco Sosa show up for his trial? And the answer is yes. He most certainly will. Second, does Marco Sosa have undocumented evidence of his showing up for trials? And the answer is yes, he does. He's not a flight risk. He has no means of leaving the country, and a support group of family and friends who not only vouch for his bond, but are willing to help Marco Sosa through the behavior so he can change once again and be a productive citizen of Canada, which 2 police officers in court have already agreed upon previously. This should be enough right here to stop this closing and for you to set bail at $500 for him, Your Honor. However, there are another 2 important factors to consider here. First, in Canada, there is a presumption of innocence until proven guilty, and if Marco Sosa goes to jail now, the presumption of innocence is in dire jeopardy. Second, the plain fact that the Canadian police have had notoriously famous for overcharging or booking or charging against the accused. Our client, Marco Sosa, is charged with theft of a motor vehicle, and no one saw him do it, nor was he driving the van when a constable pulled him over. He was also charged with theft when no one knows for sure who had stolen the sign. In fact, the constable today testified that he saw the sign in the back of the van in question. However, it was 1 a.m. In the middle of the night, not to mention there was a panel, a windowless van in the back. It would be impossible for the constable to see the sign in the back. Now the police are somehow trying to say that they can fortune tell what the future will be and is going to go back to a negative connotation on Marco. We call 4 witnesses today, Your Honor. We call the neighbor and the foreign basketball coach, Yusuf Osman. They testified about the characters of Marco Sosa and the fact that his present behavior began at the time of Marco's father's death. They also testified to the character of Marco's family and their commitment to Marco and his ability to be fed and that he will do so. Our second witness was Adriano Corbeil, the uncle. He testified how it will help provide a strong male figure in the family and how this new plan will work. Our third witness was Isabella, the mother of Marco Sosa. She testified to Marco's ability to make it to court dates and sincerity in complying with this legal requirement. Finally, we called Marco Sosa himself. He testified that he will show up for his court date and he plans to show that charges against him are completely overblown and overcharged in this case. Your Honor, we're left with a rather easy decision here today. Should we grant bail or not to Mr. Marco Sosa? Will he appear for his court date? Is he willing to clear his name in court? Is he anxious to set the record straight in this matter? Yes, 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 and yes, Your Honor. There's only one thing to do to set the thing right in this case today. Set bail for Marco Sosa and let the legal process begin. It's only then that we will know the truth, the whole truth, and nothing but the truth. Thank you, Your Honor. And with these words, we conclude the only possible court decision today you can reach to tell Marco Sosa a $500 bail and allow him the ability to defend himself against these current charges in a trial court. That concludes our closing today, Your Honor.
Thank you. The Crown ready to proceed with their closing?
Crown is ready. My name is Jamie Burst. I'll be representing the Crown in the closing statement. Marco Sosa's actions have consequences. You have stated that he is not a flight risk, but he certainly has a chance of recommitting. He has had plenty of bail conditions, and he has violated the law. His crimes have only gotten worse, and they will continue to get worse if we do not act. We have heard the same story over and over from the defense, and I ask you, Your Honor, what has changed? These problems have been identified before, and you have failed to continue to reach them. We can't keep letting him get away with these crimes. Marco has committed offense after offense, including failure to comply with his bail terms. We are not here to decide Marco's innocence or guilt, yet the defense still argues his innocence. He is guilty. This time, something must change, and we must end the cycle. He must learn his actions have consequences. Thank you, Your Honor.
Thank you. Although both the defense and the Crown have presented very strong arguments for detainment or release of the accused, Mr. Marco Sousa, at this time, the court will release Mr. Marco Sousa to the sureties presented by the defense today. We trust that he has met all three grounds as aligned with the Criminal Code of Canada. Thank you. Congratulations, full team. So just so you all know, we were a little surprised here in Canada. We actually don't bring the accused, so Marco Sousa, to the stand. So we didn't have questions prepared. So we apologize for the lack of questioning, I guess, that we had. It was a very short time. Thank you so much. You did a fantastic job again.
Thank you so much again. It was just a load of fun to do this for a second time and flipping sides.
Great. Well, hopefully we'll be able to present the trial. We should receive our trial material in December, so we'll be in contact then.
Okay, sounds great.
Great. Good luck with your bail competition.
Oh, thank you so much.
Thank you, Michael. We'll be in contact.
Thank you in all your future competition.
Okay, sounds good. Thank you. Bye for now. Bye.
Right. He heard his vehicle starting up and he ran out of the house. He saw his vehicle moving and shouted at the person. The person got out of the vehicle. At the time, he could identify some of the clothes the person wore, wearing a yellow shirt and dark brown hair. Then in a short conversation between the two, Albie was able to recognize the voice as that of the defendant here in this courtroom today.
When you left the station about half an hour later, what happened?
Well, a person wearing a yellow shirt and having dark brown hair approached me.
What did you do?
I told him that I needed to talk to him and at the police station.
What condition was this person in when you saw them?
He was sweating profusely and was quite out of breath.
What would be the physical condition of a person who had been running?
The exact same, sweating profusely and out of breath.
When you took him to the police station, what happened?
I told him that being of 18 years of age, he could get out of jail if he admitted to it.
Your Honor, we would like to submit this as exhibit, or submit this evidence as Exhibit 1. What is this?
Now, is there any objection to the admission of the statement?
No, Your Honor.
All right, the statement will be admitted.
What is this?
This is a signed confession by Angelo Crosio.
Your Honor, we would like to move this evidence into record. I'm sorry. Could you please read this, sis?
Certainly. It reads as, my full name is Angelo Crosio. I live at home with my mother at 45 George Street, Norwood. I am 18 and unemployed. I admit I took Albie Blackett's utility tonight. It was a fair cop. Signed, Angelo Crosio.
What did he do?
Well, he said, hey, he would confess, and Ms. Green said not to worry, because he could not get a ride to the party anyway.
No further questions, Your Honor. We pass the witness.
Thank you very much. Is there any cross-examination of the probationary constable?
Yes, Your Honor.
Please commence.
May it please the court, Your Honor. My name is Werfel and I appear for the defense. Probationary Constable Michaels, how long have you been a policeman?
I've been a policeman for a sufficient amount of time, a few years or so.
Do you know exactly?
I'm sorry?
Do you know exactly how long?
Well, as a probationary officer, I've been not that long of a time.
You were told by Sergeant Cox to just stay at the police station and deal with the inquiries. Don't do anything off your own back. Why did you go looking for the offender?
I'm sorry, could you please repeat your question?
You were told by Sergeant Cox to just stay at the police station and deal with the inquiries. Don't do anything off your own back. Why did you go looking for the offender?
I didn't go look for the defendant, or for the defendant, excuse me. I tended to my work and proceeded to address other inquiries. I stayed at the station for quite some time, in fact. It wasn't until I left some hours later that he was approaching me. But I wasn't directly seeking him out.
Your statement says you left at about 8:45. Were you lying?
Of course not.
Why is there a
Probationary
discrepancy?
Constable, could you please try to speak into the microphone again? Perhaps if you adjust it a little closer to your mouth, it might help. Thank you.
Of course not.
Does this mean that the police...
Sorry.
That's better, thank you.
Does this mean the police station was unattended?
Certainly not.
Who was there?
Besides me, there were other personnel at the facility.
Your statement says that everybody had left and you were on your own.
Objection, relevancy?
He left the police station unattended, Your Honour.
But
Why is that relevant to the facts before the court, though?
That he's not doing his job properly, Your Honour.
I think I will permit this line of cross-examination for the time being because it may well go to any bias that the probationary constable may have had towards the accused. I'd just like to see where it goes, but I won't permit it to go too much further. The objection's overruled for the time being.
When you spoke to Mr. Crossu in the street, did you tell him why he was going to the police station?
No, I did not.
Why not?
Well, I could already tell from his demeanor, that being him sweating profusely and out of breath, that he already knew what he was being brought in for.
Do you think offering bail to Mr. Crossu was the reason he signed the statement saying he attempted to take the ute?
Sorry, could you please repeat that?
Do you think offering bail to Mr. Crossu was the reason he signed the statement saying he attempted to take the ute?
Certainly not. A person such as him at that level who was more interested in going to a party was certainly more motivated in doing that than of being a good snap or holding any innocence.
The defendant told you, and I quote, "I told him that it was unfair and that I would write a statement to get bail. I have written and signed a statement admitting that I had tried to take the ute. I only did that so I would get bail. So I put it to you that the defendant was tricked into signing the statement. Do you have anything to say?"
Certainly so. So in that aspect, of course, anyone with a kind of confession would say anything on their behalf, try to make it seem as though what they did, they weren't guilty of. But in this case, all the facts pointed to Ms. Grosio did indeed attempt to take Mr. Blackett's utility vehicle. Because of this, and the nature that Ms. Grosio was in, as well as the description that matched for him, his only other option was to deny, of course, the charges brought before him, which isn't surprising in his case. Certainly a person who will be lying.
Other conflicting
Sorry, I was just saying.
Other conflicting information.
Go right ahead, I'm sorry.
Other conflicting information I have come across is the several inconsistencies in your statement compared to Ms. Blackett's. For instance, you stated that Ms. Blackett said that the offender was small. However, the defendant is 5'10", which you described in your statement as a person with medium height. Why is there a discrepancy?
Well, certainly what could have appeared to Mr. Blackett as small could depend on his size compared to mine. What could be small to him is certainly what could be different all compared to me. If you cross-apply the fact as well, though, the other distinguishing factors such as the color of the hair of Mr. Crocio, as well as the color of his shirt and the voice as well, those were other identifiers that would be more applicable to the case than that of height.
You also stated that you saw the defendant has light brown hair. However, the defendant has dark brown hair and he has never dyed it. But in your testimony just then, you stated he had dark brown hair. Can you explain this?
There's not a general inconsistency there. What I was told by Mr. Blackett over the phone was that there was brown hair, not a specific shade of color. But even then, the yellow shirt was the more critical factor.
Then why did your statement say he had light brown hair?
It was merely just a general description of Mr. Crocio.
Well, that's not accurate, is it?
It's very accurate considering that a person who would have ran from the scene would have also been sweating profusely, out of breath, as Ms. Crocio would have had the yellow shirt just as he did, and would have had knowledge of the event that happened, that took place, like Ms. Crocio also did.
Another discrepancy is that you stated that you received a phone call from Ms. Blackett at 8:15. However, Ms. Blackett says she rang just after 7, as soon as she ran back inside from the driveway. Can you explain this?
No, I cannot, other than maybe the times confused by calling, the distress that Ms. Blackett was in. We see that it's not hard to think that she may have gotten a little messed up in the time when calling me. I was more concerned with trying to get to justice for the death of his vehicle.
Can you please explain messed up?
Well, you may not be familiar with this if you never had your vehicle attempted death from you, but when you have a strong bond with such a conveyance and someone tries to take it from you, especially someone who you've been grateful to, who's been unemployed, it causes a great rift in your heart. It causes a great rift in the bond that you two had, and certainly a person like that who was on such a uproar of emotion could have easily misjudged the time at which the call was given to our precinct, or station, excuse me.
Could he have been intoxicated?
Could he have been intoxicated?
Yes.
He drank at the pub.
There's no proof.
Don't ask him.
I believe he drank before, sometime calling out much sooner before. But in my professional opinion, I don't believe it was drunk over the phone.
Was Angelo Crocio informed of his rights before he was asked any questions?
Certainly so. I told him that being of 18 years of age, if he admitted to the truth, he could get out on bail.
You didn't answer the question. Was he informed of his rights?
Yes, he was. I told him of being 18 years of age, that if he confessed to the crime, he could get out on bail that night. Legal right to do so.
Sorry, the rights are to remain silent and have a right to representation.
That's for being charged.
Did you inform?
He at that time wasn't being charged.
But he was questioned without someone present.
A questioning and interrogating are two very different things.
Mr. Crocio said he wasn't informed. of his rights. What do you have to say to this?
He also said that he was only signing a confession to get out. He also said that he didn't take the vehicle. We both know these two things are false. Again, I'm sure he would say anything.
How do we know that?
Off. There's a totality of circumstance, the preponderance of evidence. That being the description given by Mr. Blackett didn't match him. The voice recognition that was given by Mr. Blackett to identify Ms. Carosio. The fact that he was sweating very profusely and was also out of breath, which would have matched him running back from the scene of the incident. And those fact that he had severe with the vehicle.
Could he have not been out of breath from running home to turn off the oven?
Yes, and that factor alone, again, may not point to him being guilty, but again, all the factors together. And even then, he would have he knew about the vehicle in question, driven.
Sorry, did you just admit there was doubt about my client's guilt?
Not in the slightest. I'm 100% certain that Mr. Carosio did indeed attempt to steal Mr. Blackett's vehicle.
I'll put it to you that you did admit he was guilt. There was no guilt. Doubt.
I will again defer to the fact that in his statement, which I am attesting my basis, that he admitted he took Mr. Blackett's utility vehicle on the night in question.
Okay. Was a parent or someone on behalf in the room with Ms. Green when you questioned her, as she is not yet 18 or a legal adult?
No, a parent was not. However, she did not ask for a parent. They're both very motivated to get to a party. Having legal counsel was the last thing on their mind.
She does not need to ask for a parent. That is her right. Why did you not inform her?
However, again, it wouldn't have made a difference because they were worried about getting to a party. I'm sure teens who are doing any great drinking around town would be not worried about trying to call their parents, but again, be trying to get to their next destination. Where?
That is irrelevant. She has the right and she is under 18. Isn't this a breach of her rights?
Certainly not. She wasn't being charged within any way. She wanted to help out with the process as much as possible.
She was being questioned, therefore she had the right to have someone there on her behalf.
I'm sorry, could you please repeat that?
Just say, don't worry.
Don't worry. Did you have to wait until the next morning when Mr. Blackett wasn't heavily intoxicated to take his statement?
Not at all. He was never heavily intoxicated.
According to his statement, we've calculated that he was drunk.
I never.
Why was his statement not tonight?
I'm sorry, according to my statement or Mr. Blackett's statement?
Mr. Blackett.
Mr. Blackett, I believe, never said that he was drunk. Even then, it didn't make his
The amount of alcohol
any less true.
The amount of alcohol consumed shows that he was in fact drunk.
Not at all. It
Or
depends
leads to being.
on an individual basis. But even then, even if Mr. Blackett happened to be drunk, it didn't change the nature of his story. It didn't change it any less true.
Then why did
I'll only allow one more question in cross-examination, all right? Cross-examination has gone long enough. One last question.
Your Honor, I question the reliability and credibility of this witness. There appears to be errors and confusion between Mr. Blackett and Probationary Constable Michael's statements. He is not
Well, you can
experienced.
tell me, I'll hear about that in the closing, but that's enough cross-examination for now. Thank you very much.
No further questions, Your Honor.
Thank you. Now, we don't have re-examination. No, is there any re-examination?
No, Your Honor.
All right. And who's the next witness for the prosecution?
We call Abby Blackett. What is your name?
My name is
Where do you live?
I live at 37 Williams Parade, Norwood.
And what is your occupation?
I'm a self-employed plumber.
What were you doing about 6 p.m. on November 26th?
I was at the Bel Air Golf Club doing an urgent job, fixing a burst sewer, having a couple of drinks with friends when my spouse rang to tell me about an urgent job and if I could do it on my way home. But I decided to go home first to see if I could find my spare glasses.
Where did you park your car and why?
I parked my car outside the gate by the driveway.
How long were you inside your house?
I was inside my house for about 30 minutes getting dressed and eating.
Then what happened?
I heard my truck start, so I ran outside.
What, if anything, did you see and say?
I saw my truck pull out and go out the footpath, and I yelled, "Stop!" And then the truck stalled, and a man got out wearing a yellow shirt and black pants.
Who was the person driving your car?
A man who had a yellow shirt and black pants.
What, if anything, did you say to the person?
I yelled, "Stop, you thief!" And he yelled back, "Give up, old man."
Who was this person?
This person was Angelo Corcio, who was unemployed at the time and did a couple of jobs for me in the past.
And what did you do next?
I went back home and called the cops.
No further questions, Your Honor.
Thank you. Is there any cross-examination?
Yes, Your Honor. Mr. Blackett, how many drinks had you consumed the night that you claim Mr. Crossio tried to steal your utility?
Just 4.
My calculations according to your statement is that you had at least 5.
No, that's incorrect.
So what is correct, your statement or you?
The statement I made about only having 4 beers.
When did you consume your first drink?
I consumed my first drink at the Bel Air Golf Club and then at home.
Sorry, what time did you consume your first drink?
Approximately 4.
The defendant stated that you get half full at the golf club and are unable to make the ute up the drive. Do you usually come home in this sort of state?
No.
Would you maybe consider yourself as an alcoholic?
Objection, relevancy?
Yes, what's the relevance of that question? It may be that the witness had a drink on the night, but why does it matter if he suffered from an alcoholic disease?
Mr. Crossio says he does it all the time.
No, I won't permit that question. You can ask how often he drinks.
Where did you leave your car that night?
I left my car outside the gate near the driveway. On the driveway.
Probationary Constable Michaels stated that you said the utility was parked in your drive, but Mr. Crossio claims the vehicle was parked across the footpath, where it frequently is. Where was it on this occasion?
It was on the driveway. Mr. Carrasio moved it over the footpath.
And where did you leave your keys?
In the truck.
Do you usually leave your keys in the car?
On occasion, in this particular occasion, I was about to leave, so I did.
You were inside for half an hour. You do understand this is seen as careless behavior, don't you, Mr. Blackett?
Careless behavior does not justify a crime. It wasn't careless behavior.
No, but Do you believe this may have made your vehicle an easy target?
Not at all.
Do you wear glasses, Mr. Blackett?
Excuse me?
Do you wear glasses, Mr. Blackett?
Yes.
How would you describe your eyesight when not wearing them?
My eyesight is rather good. I just use glasses for nearsighted.
Given that you had broken your glasses, could you see more than 200 meters without them on, particularly in the dark?
First, it wasn't dark. It wasn't as far as you stated, and my eyesight is rather well on further distances.
Should you have been driving in the state, for example, you had consumed at least 5 alcoholic beverages? Or, sorry, 4.
I didn't drink 4 beers while I was driving.
But you were intoxicated before you were driving. You had consumed 4 beers in 3.5 hours.
I was not intoxicated before driving.
Do you believe that alcohol, impaired vision, and dim lighting are factors that led you to believe that Crossio was the thief?
No, it wasn't dim lighting or impaired vision. I recognized and identified Mr. Corosio by his voice.
In your statement, it says the drive is unlit except for the front gate. How could you see clearly?
Very dark.
Sorry?
It wasn't dark. The sun sets at 9:30.
No, it's at 6 p.m.
During summer,
Well, the witness has given his evidence about the sunset, so you'll just have to accept the question, I think. Go on.
Probationary Constable Michaels stated that she received the call at 8:15. Can you explain this discrepancy?
I was just upset over the car. I hadn't made the call yet. Truck.
Witnesses have Mr. Crossio at the pub at 7 p.m. until 8 p.m. How can Mr. Crossio be the offender? I ask this as there are so many contradictions between your statement and Probationary Constable Michaels.
Object. That's not really a question.
How can he be when there are witnesses?
Perhaps you could rephrase what it is that you wanted to say in question form.
Witnesses have Mr. Crossio at the pub at 7 p.m. until 8 p.m. How can Mr. Crossio be the offender?
Well, my time may be slightly off because of my distress over the truck, whereas it fits right into the timeline of the probationary officer's statement.
No further questions, Your Honor.
All right, thank you. Is there any re-examination? All right, is that the case for the prosecution then? All right. So can we have an opening then for Findon, for the defence.
Yes, Your Honour. The prosecution has the responsibility to prove guilt beyond reasonable doubt in relation to each of the elements of the offence, and my client is entitled to the benefit of any doubt. I direct Your Honour to the case of Wilmington versus GP 1935 at page 481, where Sankey LC remarks, throughout the web of the English criminal law, one golden thread is always to be seen. That is the duty of the prosecution to prove the prisoner's guilt. If the end of and on the whole of the case there is a reasonable doubt, the prisoner is entitled to acquittal. No matter what the charge or where the trial, the principle that the prosecution must prove guilt of the prisoner is part of the common law of England, and no attempt to whittle it down can be entertained. The prosecution must prove all of the elements of the offence. That is, the defendant took the vehicle without the owner's consent, the vehicle is a means of conveyance, and they took the vehicle and drove it for the purpose of driving. We will establish doubt about some of these elements and remind Your Honour that pursuant to the remarks of Hargrave J. and R. V. Phillips, 1868, at page 54, the accused is presumed innocent until he is proved to be guilty, and he is entitled to the benefit of every reasonable doubt that has been raised in the case. We will call two witnesses, Angelo Crossio, who will refute the prosecution's allegation that he had taken the ute, and Teresa Green, who will attest to the fact that she was with Angelo, who had to dash home to turn off the oven and feed the dog, returning approximately 30 minutes later. Thank you, Your Honour.
Thank you very much. Please call your first witness.
We call Mr. Crossio, Your Honour. Mr. Crossio, can you briefly explain your previous education history and your current employment?
I left school at the end of 2013 and I've been unemployed since. However, I sometimes casually work for Abby Blackett.
What did you do?
Plumbing jobs.
Can you tell me your recollection of the night?
Teresa and I went to the pub to have a meal and have a few drinks. And we intended to see my favourite band, Do Re Mi. Then all of a sudden, I remembered my mum had asked me to turn off the oven and feed the dog.
What did you do next?
I left on my own to go home and turn off the oven.
How many kilometres would you say your house was from the pub?
It was only 1k each way.
What happened next?
On the way to my house, I ran past Albies and noticed, as usual, the ute was parked across the footpath, and I tried to unsuccessfully move it back into the driveway, but it stalled.
How did you do this?
The keys were in the ignition, as usual.
Did anyone notice you trying to move the car?
No.
Was this the first time you have moved the car?
I've done it a few times before when Albie was too drunk to move it up into the driveway and just leaves the keys in the car.
What happened after that?
I just left the keys in the car and continued home. I was just trying to do the right thing for Albie.
Did anything happen next?
On the way home, as I was running, there was an elderly lady walking her dog on the footpath. As I moved to the side to let her through, I got my top caught on a branch and it ripped. Then when I got home, I had to change my top.
What colour top did you put on?
Yellow.
Did you change anything else?
No.
Did you manage to turn off the oven?
Yes.
What then?
I had to run faster on the way back to the pub because I took so long, and I was extremely hot and sweaty when I arrived back at the pub at 8:30 p.m.
What happened when you got back to the pub?
I then discovered that Phil had lied to me because my favourite band was not playing, and because Teresa didn't want to go to the pub in the first place, we decided to go for a walk.
When did you see probationary constable Michaels?
As I was walking past the police station, probationary constable Michaels asked me to answer a few questions, so I did.
What then?
He then accused me of taking Albie's ute, and I denied it because it wasn't true. He tricked me into signing the statement so I could get on bail. as there is no way I wanted to spend the night in jail for something I didn't do. Why would I steal his car after everything he has done for me?
Did probationary constable Michaels read you your rights?
No.
No further questions, Your Honour.
All right, is there any cross-examination of Mr. Crossio?
Yes, Your Honour.
Thank you. Please proceed.
So, Mr. Gracio, on November 26th of 2014, you went to the club, right?
Yes.
And you were with Terry Green, right?
Teresa Green, yes.
And is she 18 years old?
No.
And you drank some beers at the pub, correct?
Yeah.
So, in the course of being there for a while, you learned that one of your favorite bands, Do Re Mi, was playing later, right?
Yes.
And then you learned that wasn't the truth, correct?
Correct.
But you also heard that Ken was having a party, correct?
Yes.
And around 8, you left the pub?
Around then, yeah.
And you went right past the Blackett home, correct?
Yep.
And while going past that house, you saw his ute, correct?
Yes.
It was parked in his driveway, wasn't it?
No, it was parked on the footpath.
You then opened the door and entered his ute, correct?
Yeah.
And you got behind the steering wheel, correct?
Yep.
And you turned the ignition on and started it?
Yes.
And did you put your hand on the gear lever and move it?
I attempted to, but it stalled.
And you put your foot on the accelerator and pushed it, didn't you?
Yes, but it stalled. It stalled soon after.
Also, you just admitted to making at least 5 different driving moves with the ute, correct?
The car didn't move.
Yes or no?
Yes.
So you ran away from the Blackett's home, correct?
No, I ran towards my home.
But you ran away from his home, right?
Yeah.
And in the course of doing that, you tore your yellow shirt, right?
No. I tore my shirt that I was wearing. I changed into a yellow shirt.
So when you returned back to the pub, you were sweating and you had changed your clothes, right?
Yeah.
And Constable Michaels talked to you about this event on the night, right?
Yes.
And he told you to tell the truth, correct?
No, he told me to sign a statement to get bail.
But didn't he tell you to tell the truth?
No.
He told you that if you told the facts, then you would get bail, correct? Because you're 18 years old?
No, he said if I signed the statement, I'd get bail.
But wouldn't signing the statement be telling the facts?
His facts, not mine.
Mr. Crossio, how many drinks did you have?
2.
And how many drinks did your girlfriend have?
It's not my girlfriend.
Then how many drinks did Miss Green have?
She had 3 Cokes.
you signed the confession, correct?
Yeah.
And did you take an oath to tell the truth today, right?
Yes.
And if you lied then, that means you would say anything you want, correct? You would say anything to
No.
get what you want.
No.
Change around it.
So, since you claim that your confession was incorrect, are you lying? Were you lying then when you signed it, or are you lying now in this court?
I only signed it to not spend the night in jail.
So, are you admitting that you would do anything to not go to jail?
I was doing what Constable Michaels told me.
Well, yes or no, please. You just admitted that you would do anything to get out of jail. Yes or no?
No.
So, in other words, you're telling me right now that you signed the confession because it was right, correct?
No, I signed the confession because Constable Michaels told me to.
So now you're saying the confession is wrong, right?
Yes. I was pressured into it.
So you're saying you signed a statement that was false, right?
Yes.
And that means that you would bear false witnessing, correct?
You would bear a false witness then, correct?
Your Honor, he has answered the question several times.
It's a different question.
Well, I'll allow this one last question as to whether he would sign a false statement for an ulterior motive. I'll just hear his answer to that question. Please answer the question, Mr. Crossio.
I signed it because I was unaware of what was really happening. I was only 18. And I didn't have a lawyer at the time.
But
No further question.
okay, no further question. Okay, well, no further question.
No, tell me.
Thank you. Stephanie, did you say there were no further questions?
Go ahead.
Yes, Your Honor, there are no further questions.
Thank you. Is there any re-examination of the witness?
Yes, Your Honor.
I'll allow a couple of questions only.
Why did you sign the statement?
I only signed the statement because Constable Michaels told me to. No.
No further questions, Your Honor.
All right, thank you. Are there any other witnesses for the prosecution? Sorry, for the defence.
Yes, Your Honor.
All right, please proceed.
Could you please state your name for the record?
Teresa Green,
How old are you?
17.
How do you know Mr. Crossio?
We went to the same high school, Norwood High School.
What would you say your relationship was like?
We were quite close, but our relationship is strictly platonic.
Miss Green, why were you reluctant to go to the pub with Mr. Crossio?
My mum doesn't like me going, as she doesn't like me drinking. She thinks I would be pressured to do this.
How many drinks had you and Mr. Crossio consumed at the pub?
I asked Phil to get me 3 Cokes.
At what time did Angelo leave the pub?
Just after 8 p.m.
What time did he get back?
He took about 25 minutes.
What did you do in the meantime whilst the defendant was gone?
I sat there and played Keno.
When approached by Probationary Constable Michaels, did the officer seem in any way to be pressure you both into going to the station?
He didn't seem to be pressuring us, but he didn't tell us why we were going there with him.
Did the probationary constable read your rights before questioning you?
No.
Once you were at the station, what did the officer do?
He started asking me questions about where we had been and what we had been doing. He also asked me where Angelo was at 7 p.m.
Who was present when Probationary Constable Michaels questioned you?
Just me and Probationary Constable Michaels.
Was anyone there to represent you?
No, I was in there by myself.
Do you think Mr. Crossio was pressured into signing the statement admitting he took Mr. Blackett's utility?
Of course he was. Probationary Constable Michaels scared him. He said if he didn't sign it and didn't admit to taking the ute, then he would spend the night in jail. Angelo said it was wrong and not fair, but didn't want to spend the night in a cell as he had done nothing wrong.
No further questions, Your Honour.
All right, is there any cross-examination?
Yes, Your Honor. Okay, so Ms.
Please proceed.
You were at the pub with Mr. Carrasco on November 26, 2014, correct?
Yes.
And you're underage to be in the pub, correct? Because you're not 18?
Anybody can be in a pub. It's just in the gaming area that anybody under 18 years of age is not allowed.
And Mr. Carrasco's favorite band is Do Re Mi, correct?
Yes.
And his friends were teasing him about the fact that the band was playing there later that night, correct?
Yes.
But that wasn't the truth, was it?
No, but we didn't know that.
So, and Mr. Carrasco left around 8 p.m., correct?
Yes.
And when he left, was he wearing a yellow shirt?
No, he was wearing a white shirt.
And when he came back, he was wearing a different shirt, correct?
Yes, it was yellow.
And also when he came back, he was sweaty and out of breath, correct?
Yes, because he ran.
And did you ever leave the pub when he left at 8?
Sorry, could you please repeat the question?
Certainly. You never left the pub when Mr. Carrasco left at 8 p.m., correct?
Yes, that's correct. I stayed there and played Keno.
You didn't see what happened at the Blackett's house, did you?
No.
And before you left, Mr. Carrasco was trying to get you to a car or a ride to the party, correct?
That wasn't until he got back.
But according to your testimony, weren't you asked to see if you could borrow your mom's car before you left?
I don't remember when it was.
So are you telling me that you just lied under oath?
I didn't lie, I just can't recall it.
But it's in your statement. So did you lie in your statement? Is that what you're telling me?
I gave the statement several months ago.
But shouldn't you know what happened being that you were there?
I know what happened, but I can't recall what happened at the time, as it was
So do
several
you
months
really
ago.
know what happened then if you don't remember? What is the point in you being here today if you
I do
don't remember what happened?
I do remember what happened, I just don't remember the timing.
So if you're mistaking about the timing, then that means you could be mistaking about anything else, correct?
Wasn't Abby mistaken?
So are you telling me that you are mistaking about other things?
No.
So if your logic is right, then that means that you're excusing Albie's mistakes then too, correct?
No.
So if you can't excuse his mistakes, then you can't excuse yours either, correct?
Your Honor, it's the same question again.
Your Honor.
I'll allow the question to be asked in two different. Wait a minute. I'll allow the question to be asked in two different ways, but I won't allow the topic to be pursued much further. I allow the question.
Can you please repeat the question?
Certainly. So if you can't excuse Mr. Blackett's mistakes, then why should we excuse yours?
Because I'm not lying, I just don't know the time, but I know exactly what happened.
Then that means other people who can't remember, that doesn't mean that they're lying too then, correct?
But if it happened to them, then you would remember.
Yes or no?
No.
No further questions, Your Honor.
All right, thank you. Is there any re-examination?
Yes, no, Your Honor. No, Your Honor.
All right. I'll hear closing addresses then.
Your Honor, I remind you the prosecution has the burden of proof in this matter, and the standard of such proof is beyond.
Sorry, Your Honor, is that the prosecution closing?
Yes, I'm just going to have a look and see what the mock trial rules are. Normally, prosecution would close first. Have a look.
Yes.
Sorry, Your Honor.
It's all right. Yes, no, the prosecution closes first.
You listened to the testimony, you saw the exhibit, and you should be able to make up your mind strictly on the facts in this case. The facts are very simple. On November 26th, the defendant, Mr. Corsario, did start, operate, and move forward Mr. Abby Blackett's ute from the road to the inside of his driveway. Cross applied to the defendant's own words as he admitted to opening the door, getting behind the wheel, putting his hand on the wheel, turning the car, turning the gear lever, and putting his foot on the accelerator. This is more than 5 different elements of driving. Corsario did, without the consent of the owner of the conveyance, take and drive the conveyance for the purpose of driving it and should be punished. Even though he didn't have permission to do this, it qualify as breaking the law, Section 44A of the Road Traffic Act. Because of all of the elements of the offense took place and were proved in court today, we ask for a guilty verdict. You have to apply the evidence here and cross-examination statements of the defendant that he did indeed break the law. Your Honor, look at Corsario's own testimony. He said that